The Royal Commission into Defence and Veteran Suicide is now in session. Please be seated.
Good morning, Ms Longbottom.
Good morning, Commissioner Caldas. The first witness this morning is Mr John Armfield. Before I call Mr Armfield to give evidence, I understand his counsel need to make an appearance.
Yes, thank you. If you could take appearance.
If it pleases, my name is Lodziak, Lodiziak, initial J, counsel instructed by Ms Starkey, Starkey, initial K, from the Defence and Veterans Legal Service, appearing for Mr Armfield.
Thank you, Mr Loziak.
Commissioners, I call John Henry Armfield and ask that he be administered the oath.
Do you swear by Almighty God that the evidence you shall give will be the truth, the whole truth, and nothing but the truth?
I do.
Thank you.
Operator, could you please display the tender bundle? Commissioners, I seek to tender the documents in the tender bundle in the manner in which they are described in the list.
Thank you. They'll be accepted on that basis then and allocated the next lot of numbers. Thank you.
Thank you, Commissioner Caldas. Operator, can you please display tender bundle document number 1? It's JAR.000.001.022. Mr Armfield, if you can have a look at that document on the screen. Now, you have provided a statement to this Royal Commission.
I have, Counsel.
Can you have a look at that document and tell me whether or not that is a copy of the statement that you've provided?
It is.
Are there any corrections that you need to make to that statement?
Counsel, paragraph 121 refers to inside paragraph 130 below. It should be referred to paragraph 150.
Okay. Are there any other corrections you need to make?
There's no more corrections, Counsel.
So with those corrections, the statement is otherwise true and correct to the best of your knowledge and belief?
It is.
Thank you. Mr Armfield, you joined the Navy in 2003
I did.
and you served for just over 20 years.
I did, yeah.
Now, over 15 years of that service was as a Navy clearance diver,
It was.
and your service as a Navy clearance diver included numerous deployments overseas,
Numerous.
and you also received a number of commendations and awards during your service.
I did.
That included 2 commanding officers' commendations,
Yes.
and in 2017, a Chief of Navy recognition for exemplary Navy values.
I did.
Mr Armfield, can you tell Commissioners what led to you deciding to join the Navy and become a Navy clearance diver?
I'd always wanted to serve in the military. I was lifeguarding in the Bahamas at the time, and the idea come back, and someone I was lifeguarding with sort of it brought up the notion of becoming a Navy clearance diver, because I was always in the water. I'd grown up around the water. I had a trade prior that was around the water, and I just felt comfortable in the water. So on his recommendations and advice, I applied to enlist in the Royal Australian Navy as a clearance diver.
Now, Mr Armfield, I can see on the table in front of you there is a photograph. Can you tell Commissioners who is in that photograph?
That photo is my little brother. On my advice, he joined the Royal Australian Army.
And you just tell me if you need to take a break at any point.
I'm good.
And you talk about this in your statement, Mr Armfield. So your younger brother, Andrew, he first served in the Army and then in the Royal Australian Air Force, is that correct?
Yeah, after Timor, he put in a transfer category or transfer of service and went across the Air Force.
And I want to jump forward in time to sort of around 2000 and 2008, and you talk about this in your statement at paragraph 20, where that was a period of time where, because of your respective postings and training requirements, you didn't get that much of an opportunity to see Andrew. And you go on to say at paragraph 21 that you had no idea that Andrew was suffering with mental struggles.
I had no idea. I was very entrenched in my own career, and my life was the Navy. So yeah, no idea.
But you later did become aware of that, and I'm sorry, if this is upsetting, please tell me if it's difficult to talk about. But you talk in your statement about how Andrew self-harmed, attempted to take his life a number of times.
I'd actually got the dream posting, and I'd posted into, at that time, IRR, which is now SOA. I was very excited, and it was my second day on the job when I got a phone call from my sister. Sort of flipped my world upside down.
And you say in your statement, and I'm just going to take you to paragraph 64 at your statement, you talk about how at that time you tried to do everything you could to support him, but you felt that you just couldn't find that support. Can you tell the commissioners a little bit about that?
My father was terminally ill, and
His life a number of times.
I'd actually got the dream posting, and I'd posted into, at that time, IRR, which is now SOA. I was very excited, and it was my second day on the job when I got a phone call from my sister. Sort of flipped my world upside down.
And you say in your statement, and I'm just going to take you to paragraph 64 at your statement, you talk about how at that time you tried to do everything you could to support him, but you felt that you just couldn't find that support. Can you tell the commissioners a little bit about that?
My father was terminally ill, and my sister was a twin to my brother, so neither of them had the ability or the mechanisms to deal with what was happening. So I took it upon myself as an able seaman. I wrote a plethora or numerous emails requesting support for my brother, and there was no response. And we sort of, we'll get to what happened, but yeah, it was in isolation.
And in 2011, Andrew died by suicide.
He did.
Where were you serving at that time?
And I should apologise. I was doing the same thing, just about method.
Yeah. Now, you speak in your statement about the circumstances surrounding your brother's death, and I don't want to focus on that in oral evidence today, but that is before the Commission. What I would like to focus upon, though, is the support you received at the time of your brother's death from the Navy. Can you tell the Commissioners about that?
The support I received was actually from my colleagues who are here today. One of the lieutenant at the time was in Adelaide. He was a good friend I did dive course with. he supported me, and then a chief clearance diver at the time flew down against his chain of command's wishes and provided support.
And what about your officer in charge at the Navy diving school?
On posting back, they required me to see the submarine underwater medicine unit, see the doctor, and have a psychological assessment to make sure I was fine to return to work.
And can you talk to commissioners about the impact of receiving that psychological care on your mental health and well-being?
I understand there was a duty of care. We were training in diving, demolitions. I actually found there was some value to that psychological support, but it was done at that time very discreetly. I conducted that very discreetly because there was, in that environment, it wasn't a place you openly talked about mental health.
But you say in your statement, and I'll just take you to paragraph 34 of your statement, you say there you found that support beneficial and you are a firm believer in utilising mental health support as part of service within the Australian Defence Force. Can you explain to commissioners why you hold that view?
There was a lot of divorces, there's a lot of separation, there's suicides within the Navy and the diving branch. And being able to take that baggage I had and not take it home and not take it into the workplace, it was offloading. And I referred to the psychologist that I was seeing. It was more like a life coach. He gave me the strategies, the way ahead. It wasn't a session where you're emotional and you're in tears. But through the life coach, or through the psychologist, I was able to move forward rapidly. My brother died in October 2011. I was promoted to leading seaman in 2012. I was then able to go and serve with an all-army unit, posted up in 2012 and deployed to Afghanistan in 2013. I then did my advanced course and duxed that because I was the only one who passed. I got commendations, deployments, and it was all in the background. There was a psychologist, and I'd like to refer to as a life coach, giving me the tools to move ahead. We had a commander at the diving school who brought the lifeology program across. I believe it was being used at HMAS Watson to help seamanship training officers, and I volunteered to be a part of that and just done an assessment on your personality, your strengths, your weaknesses, and through that I was able to understand what I brought to the Navy and to the diving branch and to my team, but I also was able to explain to them my weaknesses and why and how I operated. I used to explain to people, I get my car serviced every 6 months. Why wouldn't I get myself serviced every 6 months? It made rationale.
And I might just touching on that point you made about your awards and commendations, I might just particularly draw your attention, commissioners, to paragraph 11 of Mr. Armfield's statement, where you can see there in the period following that support, you went on to receive a number of commendations and awards for your service.
I did.
Now, Mr. Armfield, your brother's death was the subject of an inquiry officer inquiry.
It was.
And that took place in 2012.
Yes.
And commissioners, I just note that you will recall evidence we received in hearing block 11 that those inquiries are now conducted by the IGADF, but at the time they were conducted within the Australian Defence Force itself. Now, Mr. Armfield, were you informed at the time of the outcome of that inquiry?
No, I wasn't.
And if I can just take you to paragraph 38 of your statement. You refer there to having been told that you received a letter that the inquiry had been completed in 2012. But do you recall ever receiving that letter?
No, I don't.
Okay. Now, I just want to move forward in time now to 2021. In January of 2021, you were posted to Defence Force recruitment in Robina.
I was.
That's obviously a very different type of posting from being a Navy clearance diver. Was that a posting that you elected to seek?
It's a posting that you have to nominate for and sit a board and be assessed eligible and suitable. So yes.
And so why did you seek a shift in posting from being a Navy clearance diver to going to Defence Force recruiting?
I'd been in the clearance diving branch and in those sort of roles since 2003. I'd been away from my wife and my firstborn child. My 2-year-old at that time, people actually thought I'd stolen him when I took him to a playground. And I knew I had to spend time with my family. And I thought Defence Force recruiting too would give me a chance to rehabilitate some of my musculoskeletal injuries. It'd be a less stressful position. And at that time, I'd really enjoyed my career. I was a proud clearance diver, and I thought I could promote clearance diving on the Gold Coast, and that was where I came from. And I thought as an instructor and a trainer at the ADF diving school, I knew what was required for not just a sailor, but also a clearance diver. So I took the role as career promotion team leader, and within that role, I was also a defence interviewer, and I was also the fitness, pre-fitness assessment supervisor. I'd run the pre-fitness assessments.
And Mr. Armfield, in May of that year, you received a letter from the Chief of Staff of the ADF headquarters in relation to the inquiry into your brother's death. Can you please tell Commissioners the information in that letter?
That letter outlined that the inquiry officer's inquiry report into my brother's suicide had been sent to the Royal Commission. At that time, I was aware the Royal Commission was going, but I'd moved forward in life. I had a family, and I was unaware there was an inquiry report, so I wanted that inquiry report straight away. But prior to that, receiving that letter, I'd sort of put that in my past and moved ahead.
And can you step the Commissioners through the actions you took to try and obtain a copy of the inquiry report into your brother's death?
I emailed directly back to the Chief of Staff, CDF's office, requesting a copy of that. I was advised that I'd have to get approval for that to be released. I then did reach out and do my own research and found out that all information on completion of the Royal Commission was open to a freedom of information, which aggravated me more that I was fighting. I'd loyally served my organisation and my nation, and here I am fighting for a report that was going to be made public to the Australian people and the media on completion of the Royal Commission. So I was very invested at that time to get that report.
And so you became aware of the report in May, and that process of trying to get a copy of the report went on until August.
Yes.
I'm just going to ask the operator to please display tender bundle document number 28. It's DEF.1139.0001.0059. And if you could please expand the content of the first email in that tranche, please. Now, Mr. Armfield, am I correct that this is the response you received from ADF HQ telling you that finally, after a number of months, you would receive a copy of your brother's inquiry report. The mechanism by which you were to be provided that report was via registered post. At this time, were you offered any supports upon receipt of that report?
No, I wasn't.
And as you talk about this in your statement, sometime later on the 16th of August, you then went to the Australia Post at Helensvale to collect a copy of the report.
Yeah, I'd arrived home and found the Australia Post card in the letterbox. I was unsure exactly what I was going to pick up. I didn't know if it was something for my wife, her business, or it was something for me. So I proceeded to Helensvale Australia Post to pick up whatever the package would be.
Now, you talk about some of the contents of the inquiry report in your statement, and I don't want to take you to that orally, but can you talk to commissioners about the experience of receiving that inquiry report at the post office and the impact that had on you? And if you need to take a break, you just tell me.
It broke me. It literally, the content of that report, the comments relating to my brother, I believe the inquiry officer at the time did a very good job, and in every summary from every key part of his investigation, he outlined the issues. And throughout that was Able Seaman Armfield sent numerous emails and none were responded to. There was content that defence instructions and policies were required to be followed. A number of people identified that. Can I say rank?
Look, I think you've spoken about what was actually in the report in your statement. I think my question, Mr. Armfield, is really directed to the impact on you of receiving that report in that way.
I was sitting in my car, broken. I'd loyally served my nation. I'd recruited for my nation. And this is how they were giving me the report on my little brother's death. The commentary was so bad in that IOI, and no one, they found it acceptable to give to me. And 5 days before I left the Navy, they actually acknowledged, almost 2 years later, that the content, because we're talking about the content, the CDF in 2012 wrote, "This is a horrible, horrible report." There were so many failings admitted to me 5 days before they medically removed me from my dream job. And what I've read in the IGADF assessment report, but they left me on my own on the 16th of August to deal with this. And not only that, it was my advice for him to join. It was my advice from January 21 to the 16th of August for Australians to join. I actively recruited, and I felt it was just so many emotions of guilt, culpability myself for recruiting into this organisation. And I sat there and sobbed, and I couldn't take it home to my family. I couldn't.
And you've just touched on this, and you talk about it in your statement as well. You ultimately received an apology from the Navy for how that report was provided to you. But I particularly want to focus on the steps you then took yourself, given the impact of the report. As I understand it from your statement, you went and you reached out to get some psychological help. Can you talk commissioners through that?
My 4-year-old at the time identified I was getting angry. I didn't identify any issues myself, except I was emotional. I took myself to Kokoda Barracks, Canungra. I spoke to the GP there, who's a civilian GP on the base. He immediately referred me to a psychologist in Robina, who's been amazing and been with me the entire time. And thankfully for me, she was also an ex-army psychologist who understood the system and how things were happening to me. So it was a totally different intervention. I had someone who could explain why the organisation was doing it and who sort of has supported me in this fight since.
And am I right to understand, Mr. Armfield, that this was in around October 2021 and your psychologist recommended that you take 3 weeks of stress leave?
Yes, I couldn't look anyone who wanted to be recruited into the Defence Force in the face. I couldn't tell them it was a good and safe career, and I couldn't be responsible for that anymore. And she simply wrote that John can't be in a public-facing role at the moment.
Now, I don't want you to mention particular names, but having received that recommendation from your psychologist, you then approached your chain of command at DFR Robina to obtain leave. Can you step the commissioners through how you did that and what happened?
The psychologist referred me straight back to the GP at Kokoda Barracks at Canungra. I asked if she could send me that email she was forwarding because I felt an obligation and responsibility to advise my chain of command myself. She agreed, so I proceeded not to Kokoda. I went straight to my workplace. I crossed paths with the flight lieutenant, who can't be named, and she asked how I was going. I said, "Can I please send you an email and have a discussion after?" She said, "Yeah, sure." Her office opened straight out to mine, and next to me was a flight sergeant. I logged on. I hit forward to the email. I logged off. By the time she'd read the email, she moved herself from the office, shut the door. And I said, "Ma'am, can we please speak about that email?" And she goes, "No, I'm too busy," and walked off.
And what impact did that have on you?
I'd never taken stress leave in my career. I'd never asked for help. That if I did need help, it usually come from my colleagues within the diving community. And in front of the entire workplace, the civilians and the military, I was left standing there on my own, unsure even what to do. And that broke me.
And so what did you do after that interaction?
I went next door to the Warrant Officer 2's office, who I'd had a good relationship with. I knocked on his door and he was quite busy. And he goes, "Are you okay?" I said, "Can we have a quick chat?" Shut the door. He goes, just let this sit. Go to Canungra, go to Kokoda. He left. So I went and packed up my desk and I went out the front. And as I was going out into the public area, the area manager of Defence Force recruiting caught me. He goes, "Are you all right?" And I said, and I just broke down. He turned to the receptionist and said, "I just need some time with John, hold all my meetings and calls, and I'll be back." And he took me away and we had a chat of what had just occurred. And I do believe within the evidence pack there are statements confirming that, including from him.
And I just want to take commissioners to what this warrant officer said about you as a worker in the Defence Force recruitment office at the time. Operator, can you please display paragraph 87 of tender bundle document number 1 and across to the next page? Just the end of that quote, please. Mr. Armfield, is it correct that this statement of your capacity as a member of the Defence Force Recruitment Office came from that warrant officer you've just spoken about before?
Yes, it did.
And commissioners, you can see there that the warrant officer talks in explicit detail about the tremendous contribution Mr. Armfield was making at that time to that office. Mr. Armfield, I want to jump forward a month
Yep.
to December 2021. At that time, you were transferred to HMAS Moreton, which is a personnel unit.
Yes.
You say in your statement that about that time you were thinking about making a complaint about a number of matters, including some of the things that occurred at DFR Robina. Who did you, sorry, and don't mention any names, but did you speak to people in the chain of command at HMAS Moreton about making those complaints?
I'd put out an email just prior with 6 questions pertaining to my mental health and my career. That email had gone out with support of my psychologist and a GP.
And can I just stop you there? Am I right to understand that email was sent to someone in your chain of command at HMAS Moreton?
That email was firstly sent to the Warrant Officer 2 at DFR.
Yes.
And then the Lieutenant and Commander at HMAS Moreton.
Okay. So after you sent that email, what happened next?
An individual welfare board was conducted. I didn't feel safe is probably the word to attend it within the ADF confines. So I proceeded to Kokoda Barracks, and although it's an ADF establishment, I sat for that IWB with the civilian GP who'd then been with me since August. I wanted to attend that meeting, that IWB, even though there was no requirement, I guess. I wanted to make sure that everyone understood that we were in a situation and this IWB was occurring because the entirety of it occurred since August 21.
And so as a result of that IWB, you were posted from DFR Robina to HMAS Moreton.
I was.
Can I then just take you to your statement at paragraphs 101 and 102? And you there talk about an engagement you had with your chain of command about formalising, and you correct me if I'm wrong about this, the matters in your email in the form of a formal complaint. Is that correct?
That's correct.
Now, at paragraph 102, you talk about advice you received about the options available to you.
Yes.
Were you directed to resources you could use in determining what a redress of grievance should look like or what an alternate dispute resolution process might involve?
No, I wasn't. And at that time, I didn't have the capacity to do that. There was a Navy lieutenant who was a mental health officer, somehow become on board at this stage. He'd actually recommended at this exact time, around this time, that I'd be admitted to a hospital to undergo some medical care. And the reason that never occurred was the GP at Canungra had put me onto a chaplain, an army chaplain, who told me you don't need hospitalisation. The emotions you're feeling are valid and you need to address those issues. So at that time, I didn't have the capacity to do a redress of grievance or an ADR. And to be honest, I wasn't quite sure of that process and how to go about it. But I did, on the 13th of December, leave the lieutenant with easily an A4 page of issues that I had raised.
And I might just ask the operator to please display tender bundle document number 18. It's DEF.1139.0005.1192. Do you recognise this document, Mr Armfield?
I do, Council.
Is this the document where you set out those concerns and complaints you had?
That's the document that I wrote as my complaints to the Navy, yes.
Okay. And am I right to understand that that complaint was ultimately the subject of a fact find that was undertaken?
Yes, it was.
Okay. Now, I want to take you to that process. First of all, you received a response in relation to your letter of complaint. If the operator could please display tender bundle document number 19, it's DEF.1139.0005.1454. Do you recognise this document, Mr Armfield?
I do.
Can you explain to the commissioners what it was and what role it played in the fact find that ultimately took place?
This situation had evolved and it really intensified when I put the 6 questions out. There was numerous meetings with PSU and HMAS Morton Command. Prior to this letter, in a meeting with the chain of command at Morton, I was asked what did I want from this situation, and I said I wanted accountability and justice. And they said to my complaint, and I was told what complaint, which left me flabbergasted because this had gone on for so long. So then we drafted the letter of complaint to try and highlight what I was doing. This response I got here was what I received in 30th of August, 2022, after I'd submitted my initial letter on the 8th. When I submitted my initial letter of complaint, I was called in for a meeting with the commander, CO Morton, and I was asked, what are you trying to achieve with this? It's very subjective. It's very emotive. Nowhere have you provided details of what you want. Do you want to go through with this? I left that meeting, again, emotional. There was an intervention on the car when I left Morton, and 2 members of the Royal Commission Veterans Death Suicide team had called me, both the mental health and legal, and are here. And they said to me, John, this is a very good letter of complaint you've put forward. And I said, no, it's not. And they straight away, what do you mean? And it was a very weird situation because I'd just driven out of the gate of Morton after being beat down. And I said, this is what's occurred. This is what I've been told. And the legal expert, the lawyer, said, hang on, John, every paragraph you've asked for accountability and justice. It is the mental health lady who's supported me the entire time, and I appreciate it. She's here from the Royal Commission. She goes, it should be subjective. It should be emotive. This is your little brother. So what people don't get is every time I was beat down, the Royal Commission team and Davils picked me up and helped me keep going, which I appreciate. And 30th of August, after fighting this fight now for just over 12 months, I received this letter of complaint. The response, paragraph 4 hit me. And that was when I knew that the Navy and the ADF had formally given me this. This one document, I did go external. I told the Navy, I was always honest and upfront, and I tried to adhere to the values they didn't. And I told them I was going to take this external to the local member because that seemed appropriate. I emailed my local member, I won't name because we're doing redactions, I emailed the opposition, the leader of the opposition, who at that time he was the defence minister, and he had a great reputation amongst the enlisted, and I'd heard good things. I'd read an article, I was very reaching here, I read an article on the Attorney General of Australia, so I wrote to him. I was in a pretty emotional state at this stage, and I also wrote to the current Minister of Defence and Veteran Personnel. This was the one document that I was responded to very quickly, within days, by my local member. He viewed this. I was then escalated to the current Shadow Minister of Veteran Personnel, and this is the one document out of all the evidence I contained they wanted, because what I was told is there's a lot of veterans being told their issues are now for the Royal Commission of Veteran Death Suicide, but I actually had that in writing. I had numerous meetings and discussions over this time with the Royal Commission. I do appreciate that. And a number of times I was told, because my chain of command, the Navy, kept saying, this is for the Royal Commission. Your situation's for the Royal Commission. So what any good sailor, soldier or airman would do, I followed that advice from my chain of command and went straight to the Royal Commission. The Royal Commission were empathetic, compassionate, professional at every meeting, but they would always say, John, we can only provide a collective of advice or recommendations to government. We cannot provide accountability, we cannot provide justice, and least of all, we cannot read and break down the inquiry officer's report that the ADF have presented to you. That's not our job, that's their job. So this was the clincher where the ADF had said it was over. So I had to go external. In September, I was driving into my local MP's office. I pulled up in his car park, and as I pulled up, my phone rang, and it was the lieutenant from HMAS Morden, and he said, if you go through with this, there will be repercussions. I said, sir, you sat in the meeting. You were there when I received this document. Can you confirm all matters pertaining to me and my brother are closed? He goes, yeah. I go, that's my fucking little brother. Sorry about that. That's my little brother. This fight's not over. So I walk into my local member and he goes, John, you're in the ADF. Of course there can be repercussions. But tell him you've just sat with the Honourable Redacted. And he said, I will make sure those people in that command are held accountable, and if required, I'll have the CDF come to the Gold Coast. When I left his office, I did what he said. I called the lieutenant and he said, do you want me to pass this up the chain of command? I said, it's up to you, sir. My local members documented this conversation.
Now, and I just want to stop you there, Mr. Armfield, and I might just ask the operator to please display paragraph 3 of that document that was just displayed. Your complaint was in 2 parts.
Yes.
The first part were about issues connected with your brother's death, but the second part of it was about treatment that you had received during your time at Defence Force recruiting in Robina. And so as I understand the evidence you've just given, and it's documented in this letter, insofar as it concerned the complaints you made about matters surrounding your brother's death, that was treated as closed.
Yes.
Within the ADF, at least at this time. But insofar as it concerned complaints about what had occurred at Defence Force recruiting, that went on to be part of a fact-find process.
Yes.
And I want to focus on that fact-find process and the response you received with respect to it. Can I take you to a paragraph 150 of your statement? And I might ask the operator to display that. Would it be fair to say that your complaint in relation to the fact find included things like parental leave and other aspects of your treatment there?
Yes.
Now, you received the outcome of that fact find in about November of 2022?
Yes.
I want to take you, and I'll ask the operator to please display paragraph 152 of the outcome of that fact find? Now, that there is a comment on the fact that you had sought and received mental health support. What impact did it have on you in reading that in the fact find about your complaint?
It absolutely destroyed me. At no way did it align with the service values. At no way did it align with Navy signature behaviours and putting people first. No way did it align with the ADF's mental health plans and what they were encouraging people to do. On the 5th of May 2023, the representative of the ADF themselves said, this is a paradox where we encourage people to go and seek psychological support, and now we're using it against them. As it states at reference B, I openly stated that I'd seen psychological support. I believe it was part of the success I had in my career. I've seen some good mates suicide. And to see that an officer could have this opinion on mental health, it absolutely destroyed me. And the problem I've got is when I sat on the 5th of May 23, 5 days before they removed me, the medical expert in my evidence and in that timeline that's there actually said, these are the issues we have with lieutenant colonels. And so that's the head medical professional identifying. And I was like, so nothing's done about this. There was no time, anything I raised, did anyone stop this? I think that says a lot. When I was escalated through the different external mechanisms, because I was receiving no support from the Navy or the ADF, a current MP, which we won't mention names, but I do appreciate his support, said to me, I've sought psychological support. Am I uneligible to be an MP? And I said, yes. That's what he's stating. And I won't drop names, but the very highest level of our organisation, when I met with this individual 6 months after I got out, the 24th of October 2023, because they realised how serious this issue is, they flew me to Canberra 6 months after I was out, said to me, I see a psychologist, and I have since I was a commander. I said, well, how do you think it makes me feel? I'm a petty officer, I'm an enlisted sailor. You're the leader. Fix this, do something. I said to captains, I said to the boss, is this acceptable? No, it's not. Do something. I flew to Canberra to receive an apology from DCN, which is tendered as evidence. That was on Monday, the 28th of November 2022, for the way I was divisionally managed, not for my brother, not for the bullying, harassment or the abuse I encountered, but just for how this situation had been managed and how I'd received the report, nothing else. I met with head of my capability on the Sunday. I said, I don't want to be subjective. I don't want to be emotive. I just want to give you the evidence and let you make a decision. And I said, is any of this acceptable? No. On the Monday, I went in to receive the apology from another captain, and she gave me the apology from DCN, which is tendered as evidence. I said, ma'am, how come I'm receiving a formal apology from DCN on the 28th of November 2022 when on the 30th of August 2022, the Navy said all matters pertaining to my brother and I are closed? We never said that, John. So I pull out the document, I go, ma'am, paragraph 4, and I read it out as the evidence that you've just witnessed on the screen. And she goes, we never approved that. I said, the Navy gave me this, ma'am. That's the signature block. And I said in that meeting, because I knew it was a hot topic within Defence. Does the CN and senior leadership know about this? I'm the delegate for Navy PO, and put me back in my box. And I said to the captain, I said, ma'am, are you aware, so you're aware of this is not acceptable, this is not the course the Navy wanted to take. Are you aware of the document, and this one from the Lieutenant Colonel, saying that my complaint of his maladministration cannot be substantiated because I see a psychologist? And she goes, no, I'm not. I said, is this acceptable in 2023 in the Royal Australian Navy? No, it's not. I said, I'm a petty officer. I'm an enlisted sailor. Someone fight for me. Where is my leadership? I said, are you aware, ma'am, of a timeline that was created by the flight lieutenant that's very critical of me, is probably the nicest way to put it. She goes, yes, I am. I said, are you aware of the statements that I tendered to the CO Morton saying this is a lie? No, I'm not. Here are the statements. This is from the area manager of that organisation. Here's one from the flight sergeant of that organisation. I could see her face as she read them. I said, ma'am, I didn't ask anyone who was subordinate to me for a statement, because that in alone is an abuse of power. I got to the airport. She took the documents and scanned them. I knew I needed a trail. So when I got to the airport, I emailed her, thanked her, and reattached those documents. And she wrote back straight away going, thanks for this, John, I'll take this for. And that's all within the evidence. And that was the 28th of November, and nothing was done.
Now, Mr. Armfield, you also made a complaint to the IGADF about the outcome of this fact find, didn't you?
I did. Group captain come back to me at that stage and said, we need this legalised. I said, I've done the best I can. What do you want me to do? And she goes, John, we've got Defence Counsel Services. I said, ma'am, they've already refused to help me. And she goes, what do you mean? And I sent her the emails, which attended as evidence. And it said in September 21, when this process started playing out, I sent the documents, the IOI, to Defence Counsel Services for support. And they wrote back, John, we are the Commonwealth. We cannot assist you in pursuit of vicarious liability of the Commonwealth. Therefore, we're unable to assist.
And you're talking there particularly about the complaints connected with your report into your brother's death. I want to focus particularly on the fact find, though.
Yes.
Did you ultimately get help from Defence Counsel Services in putting together a complaint to the IGADF?
Yes, I did.
Okay, and I just want to take you to that document. Operator, can you please display tender bundle document number 33? It's IGD.0033.0001.00027. Do you recall whenabouts you received this?
I received it in August 23, I think.
Okay, so just last year.
But I did get, in a meeting on the 4th of August, to view a redacted copy.
Okay.
But I couldn't keep that copy.
Okay. Can I take you, please, operator, can you please display .0044 of the document? And first of all, expand paragraphs 53 and 54. So the IGADF is there dealing with the complaint you'd made about your treatment at DFR and the way in which that fact find was conducted. And so you can see there in paragraph 54, they found that, first of all, the person who conducted the fact-finding officer had some oversight of the earlier matters, and that was in contradiction of the guideline that it should not be someone who is personally involved.
Yes.
It also found that the fact-finding officer hadn't even undertaken a fact-finding course. What impact did that have on you in reading that?
I was very naive in the early stages and thought the organisation would provide leadership. the organisation would adhere to the values of honour, honesty, courage, integrity, loyalty. As soon as I identified this, the organisation that I'd put in a complaint of maladministration against had done their own fact-finding, were unqualified. The emotions changed. The emotions went from trying to fight for my career, trying to fight my way back, trying to support my brother, to holding this individual accountable. In no way do these actions and the way this was handled represent what an ADF officer should embolden or should provide to our soldiers, sailor airmen. I was in a very, very angry place.
I want to take you then to paragraph 56 of this document. And it refers there to your statement that you didn't have faith in an investigation being undertaken by DFR itself. The fact that you had raised concerns about the timeline, and I think you referred to this earlier, that was part of the material before the fact-finding officer containing errors, and that the fact-find didn't conduct any interview, just undertook a desktop assessment and didn't undertake a critical examination of the contemporaneous notes. What impact did that have on you?
No one within Defence Force recruiting was questioned. This was a fact find that was initiated because of me and I wasn't questioned. To me, it started to become a cover-up.
And can I then take you to the next page, to .0045, and if I could ask the operator to please expand paragraphs 57 and 60. And this really touches on the point we spoke about before about the findings made in the fact find about you seeking mental health support. Paragraph 57, they are the terms of reference for the fact find, and yet at paragraph 60, the person conducting that fact find purported to put in gratuitous comments about your mental health. If the operator could please then go to .0047, the IGADF observed in this respect that the fact find made conclusions that went far beyond the terms of reference. And indeed that the way in which that was conducted could reasonably open to an apprehension of bias because of the earlier dealings that fact-finding officer had with your matter. When you received this, how did it inform your view about the Navy or about the ADF and the way in which they dealt with that aspect of your complaint?
The evidence I was starting to collect clearly identified, and the evidence has been supplied. It was a two-tiered culture. There was one set of rules for the officers and one for the enlisted. I can be charged or infringed for such minor infractions, and yet I'd raise serious issues relating to the treatment of my brother. I've raised issues of maladministration. And when you raise these issues, they investigate themselves and they're not even qualified to do the job. It's hard to contemplate. It's like me going and supervising a dive and not being qualified to dive or to supervise a dive. You'd be charged. You'd be removed from the Navy. You can't do that. But in this case, it seems acceptable.
Now, I want to take you back to August and September 2022. So on the 30th of August, you received that response we've spoken about your complaint.
Yes.
The next month, you did a search of your name on Defence's data storage system. Can you explain to commissioners why or how you came to do that?
At the time, there was a chief diver, and he's actually present today. was collating and moving hard copy documents to electronic. When he was doing this, he found a document relating back to my clearance diving acceptance test in 2004 and sent me a photo. These documents were all unofficial. I said, can you scan that and send it to me? Because it's something I like to keep memory of my career. And the guys who assessed that were guys that were held in very high esteem within our organisation. The chief at the time said, I'm putting it all into Objective, put your name in and the document will come up. Obviously I had access to Objective, I was qualified to use Objective, so I log on, put my name in, and a serious amount of content turned up. Now, I use Objective to store my stuff because you don't want to keep it on the computer's hard drive within the organisation. So you keep everything on Objective and allows you access if you're using a different terminal or a different base or you're moving around. So I knew what was supposed to be an Objective. I'd save dive briefs, missions, different things. There was a heap of documents and I didn't know what they were. I was looking for the document that the chief had put on. So I opened the first document and I identified the first document that I opened was a decision brief for the Chief of Defence Force and the CN and CAF, for information only, no one else. It outlined the entirety of this situation. It outlined my mental health, my mech status. It outlined how my brother suicided, where he suicided, and I think most importantly, because it was a decision brief as Chief of Defence Force, it aligned with my 6 questions. They stated in that decision brief that the issues that may arise is that Edinburgh was the senior medical officer at Edinburgh at the time in the IOI said they were severely undermanned and they were at 50% of staffing, and they'd also added another 1,000 troops to Edinburgh. That was the senior medical officer's comment in the IOI. And there's another couple of comments, but all this was sitting on Objective and accessible to me. So I was very torn, I was very emotional that this was there, but I was also torn that the CDF was being pre-warned of the issues that I was about to receive, and that the way I interpreted that report, but everyone had sort of brushed it off as you don't know what you're talking about. But here's the Chief of Staff identifying the same issues and providing that to the CDF. I rung the Chief, told him what I'd found. He goes, just let me check. I said, Objective is tracked. We probably, these are in a common file. They're just there for anyone. He confirmed that he could access it. Another chief, who's a very close friend of mine, confirmed he could access it. And they advised me to go to Defence Counsel Services. So I go back to Defence Counsel Services with this, and the matter was raised very quickly. I went to a Lieutenant Commander Legal Officer, Reserve, and he provided me the advice to take this straight to my chain of command.
So what did you do next?
I asked for a record of conversation with my chain of command. I had no faith in a meeting that wasn't recorded. I had everything outlined that I wanted to talk about. The meeting was organised, and then I attended a record of conversation with the CO and a couple of other people.
And during the course of that meeting, did you talk about the fact of you identifying this material on the Objective system?
I started that meeting, she started the meeting with, you've requested this record of conversation, what is it about? I said, I'm trying to save my career, because I did love my career. I was very, very proud to be a clearance diver. I said I wanted to identify breaches of Australian privacy principles, data pertaining to myself and my brother. At this time, I knew what the breaches were because the legal officer had told me. I believe it was Australian Privacy Principle 11, which is in writing. I also raised the timeline that was written about me and I raised in that record of conversation that in accordance with the Defence Fraud and Corruption Plan 2022, lying, deceiving on a government document is fraud. I raised numerous issues. I showed her the statements from the area manager of DFR saying this was all, the timeline was a lie, and that he had to support me because my chain of command at DFR didn't. I showed her the statement from the flight sergeant who was present at the desk next to me when I was brushed off by the flight lieutenant, saying there was lies. I think the area manager's statement speaks very strongly on my behalf. I raised everything with her, and she concluded, and it's in the record of conversation with, "John, are you trying to say you're a good clearance diver?" I said, "No, ma'am. I'm an exemplary sailor in the Royal Australian Navy." And that's how the meeting ended. And I believe council will go to a further thing, but what happened next put me into a very bad place, a defensive place, where there was a potential, and I was legally advised I was facing serious criminal charges.
What did happen next, John or Mr. Armfield?
I'd raised the record of conversation was my one chance to have everything documented officially. I was hoping for some compassion or some leadership. I received an email from Morton saying I was the subject of a fact find. They wanted everything. Now, I'd raised a breach of the Australian Privacy Principles data and privacy relating to myself and my brother, but what was actually investigated in the fact find was me being authorised to access Objective. The complaint, the fact find that went to Joint Military Police Unit, I've never been charged, I've never been infringed in my career, was me being unauthorised to access the Objective system, which obviously I was authorised to. I was very, very angry. 14th of December, I received a letter from Joint Military Police Unit saying the investigation into me was concluded and the findings are being sent to CO Morton. It's very hard for me not to want to name these people, but the Commonwealth's had their names redacted. The letter said, so the findings being sent on the 14th of December 2022. I get a letter from Defence Counsel Services, which is in evidence, saying, John, you and your family are the victim. John, you're now facing serious criminal charges. And he said, if anything happens over the Christmas period, call me on my mobile. Defence Counsel Services had been great. There was something else that was in that, I forget. So over that period, I was waiting to be charged with civilian charges and potentially face jail time.
And I just want to make sure, Mr. Armfield, that I'm really clear on what happened here. You searched Objective, you identified documents that shouldn't be there.
Yes.
You went and told your commanding officers about that. After that meeting, a fact find was conducted into you.
Into me.
Into you accessing that material.
Yes.
As a result of that fact find, the matter was referred to JPMU for criminal investigation.
Yes.
You were told that that criminal investigation had been closed or had been finalised.
Yes.
In 2022.
The 14th of December 2022, I was told that matter was finalised and the findings were sent to Morton.
Were you told what the outcome at that time was of
No.
those?
I met with the Inspector General ADF's representative on the 4th of August at Canungra, and he had approval not to give me the IJDF assessment report that was redacted, but to at least share it. And he gave me I was having a coffee in a setting with him. He gives me the report. He goes, "You can go straight to the back and see the summary, John." And he goes, I was looking for that one thing. I wanted to know if I was facing serious criminal charges. And I get to it and I read, and I think council has the findings, but there was no issue with me accessing objective that PO Armfield did raise concerns. They didn't say it was a data or privacy breach in accordance to the APPs, but they did raise concerns with how Defence Force recruiting was storing documents. And this is documents for CDF, CN and CAF, not for flight lieutenants and lieutenant colonels, by the way. And it vindicated me. I was expecting to be charged between the 14th of December and the 4th of August 2023, just shy of 9 months. I was not going to be compliant if I was arrested, and I told my wife to film whatever happened and forward it straight to the media. It was a hard way to see my career go. It was an unfair way to see it go. And again, nothing was done about any of this.
Now, Mr. Armfield, you were ultimately medically discharged from the Navy on the 10th of May 2023. During the course of this Royal Commission, we've heard and we've seen in a lot of documents reference to the expression trauma-informed. Can I ask you to give the commissioners the benefit of your view about whether or not a trauma-informed approach was taken in your case?
It definitely wasn't. Through freedom of information, I requested the emails pertaining to me. On the first tranche, the pages were pretty much fully blacked out, fully redacted. I had a Navy commander who was advised of my situation for a colleague who's here, who rang and said, "I'm happy to support you. I want to support you. I need to remain anonymous." I said, "Happy, sir." He goes, "They're intentionally redacting the FOI. You need to go to FOI review." I said, "But sir, it's the same organisation. It goes to the same people." He goes, "What you don't know, John, is if they do it a second time, then you can take it to OAC and it can be a civilian charge." And again, the enlisted people do not know this. So I followed the advice of the commander, which I appreciate, and I'm sure he's listening. I go FOI review. Everything's there. Things that have been redacted under sections 37 and 47, I forget which order, but public interest and security were things like John is triggered. I raised on my last day, on the 10th of May 2023, I thought I'm writing a letter to my boss, the boss of the Navy, and I included in there stuff I'd received through FOI, like John's chain of command at DFR identified he was triggered in March at an all-female recruiting event by protesters. I said to the CN at the time in the email, it clearly indicates it's an all-female event, therefore I wasn't present. My psychologist said, what makes a flight lieutenant capable of diagnosing someone as triggered, specifically when not even at the event. And there was so much commentary within the FOI. So obviously in June 2022, I'm told there's no official complaint. But on the 13th of December, the lieutenant at PSU had sent the CIO of Moreton easily an A4 page of a summary of his meeting with me. And what they took out of that entire page was one word, and that was maladministration. That one word on the 14th December was sent, it was something ridiculous like 0700. It was sent to the Lieutenant Colonel at DFR going, a complaint of the word or complaint of maladministration has just been made against DFR. And these things were in movement in December 2021, but in June, July 2022, they're telling me no complaints being put forward. And when I did put the complaint of maladministration in, officially in August, they were well aware of that in December. But no one sat me down, no one in my chain of command, and I was in a very, very bad place. No one sat me down and helped me stuff documents. No one told me how to go about this. And as per the evidence I've provided in the emails, 3 officers knew that I had an issue with the maladministration, and yet nothing was done to support me.
Mr. Armfield, what do you hope to achieve by coming here to give evidence today?
I've asked for accountability and justice the entire time. That is all. I've said to the Chief of Navy when I met him on the 24th of October 2023, this could have been solved for $6. All someone had to do was their job. Sit me down with the IOI, buy me a coffee, and I said, I've even got the term or the statement I would have accepted, and that was, John, we apologise, but we weren't in tenure at the time. But the attempts to hide it, to cover it, to do whatever we want to call it, it just exacerbated. It blew up. False timelines created about me that I was able to get statements to say they were lies. But no formal apology, nothing, no recognition. Trying to charge me with serious criminal, making me face potential serious criminal charges for a 9-month period. The timeline on the advice of a member of parliament, and we're redacting names, told me when I was going to the meeting on the 5th of May 2023, do not attend unless it's recorded. And all I ever wanted was an explanation on the IOI, the 28-page document on my brother. That's all I wanted, just an explanation for 2 and a bit years here. So 5 days before they medically removed me from my job, they organised a meeting at Canungra with medical and legal experts. And that meeting brings up admissions of culpability, liability. John, I remember it, and I've put in the statement is, John, we're sorry on behalf of the ADF. Errors occurred, and those errors kept occurring. We're sorry. 100%, if those errors didn't occur, you would still be serving. But where's the accountability? You took my job. You took my brother. The other one that sits with me is, John, we all know there were failings relating to LAC Armfield, my brother, his treatment. We all know he shouldn't have been able to come and go from the hospital. He's on 15-minute watches. We all know he shouldn't have been able to consume alcohol. He shouldn't have had 6 1-litre bottles of whiskey in his room, which again was tried to be covered up, but only because the nurse, when I went to collect my brother's belongings, started crying and gave me the official hospital transcript that I have it as evidence. No one else has provided it. But that's on SA Health and the repatriation hospital. Although the IJDF assessment report says clearly that all ADF members at all times are under ADF care. So where am I at? It's medical negligence, loss of my career, loss of my identity, false timelines created about me that I can prove. But what do I want? I don't want this to happen to anyone else. This has to stop. This is simply leadership. That is all it is. I told the Chief of Navy when he sat with me in Canberra, and I appreciate it, you do something about this or I will. This is my little brother. It's not going away. And nothing's still being done. People are in positions of power. People are paid and required by rank, virtue of rank, to do their job, and it's not happening. I can be charged for being adrift. I can be charged for not wearing my uniform correctly, haircut, insubordination. All this can happen to an enlisted person, but this is what they've done and got away with it. I've gone to Comcare with evidence of clear breaches of legislation. In the IGADF report, it says that there were breaches, but nothing was done because they, ADF, were able to verbally tell us what they should have done. So we don't do our job, right? We breach legislation, we breach law, but because they know what they should have done, it's acceptable, so no regulatory action's taken. It is mind-blowing that me as a petty officer in the Royal Australian Navy can undercover this. And the hardest thing is, at all times, I was bashed and berated back into my box. And it was people that are sitting over there, my colleagues, the dive branch, the Royal Commission mental health coordinator has been amazing and picked me up. Legal, been amazing. My psychologist, my wife and 2 boys didn't deserve this. And I was really, really good at my job and I loved it, and I pay the consequence and I lose everything because I asked a question about a report that the CDF thought was a horrible report, but they'll give it to me in isolation, right? I think that timeline, the apologies for failings related to my brother, for failings related to me, and the lies in the inquiry report. I asked the Inspector General ADF lawyer, defence were going, well, what do you want from this? I said, what happens if I lie in an inquiry report and you'll be charged under section something of the Defence Force Manual? I go, well, I want that. You're going to charge an enlisted person, you've got to start charging the officers. This is a 2-tiered culture. And I actually put the 2-tiered culture in a report to Defence Ombudsman and Inspector General ADF's office because it is clearly identifiable. The group captain at IJDF come back with my report, and she called me and she goes, John, we're going to investigate this, we're going to do this. Do you want us to investigate that it's a 2-tiered culture? I said, no, ma'am, I don't need you to. And she's like, why not? I said, because the Defence Ombudsman's already come back and said, John, there is nothing we can do to influence, to change the 2-tiered culture in defence because of legislation, regulations, policies, and the culture of the ADF. We know it's a 2-tiered culture, and that is in writing, and that is part of my evidence from the Defence Ombudsman. It is known. So when people ask what I want, we should have an amazing Defence Force. We need an amazing Defence Force. We need new leadership. We need someone to lead. This shouldn't happen to me. It shouldn't happen to anyone. But everyone knows this is happening. The Ombudsman knows. For anyone wanting to join, if my boys wanted to join, I'd say I have to tell them, join as a commissioned officer, because it is clearly in writing from the Defence Ombudsman, it is a 2-tiered culture. So what do we do now to fix this? It's a massive problem. I never foreseen this happening to me, Council. But it's been 2 and a bit years. So hopefully a break. This fight has been very, very consuming.
And Mr. Armfield, it's clear this has been all-consuming, as you say, for the last 2.5 years. This Royal Commission is tasked with making recommendations for systemic change in the future. In that vein, are there any particular recommendations you would make for the commissioners to consider?
It's quite simple. I teach my boys this. You have to be accountable for your actions. I've fought the system for 2.5 years, and that fight was still going late last night when the Commonwealth was trying to have names redacted. Right, that fight didn't stop till last night. And fortunately, the legal team was up, everyone was working it, because that is the issue. There is no accountability. They will fight tooth and nail till last night trying to stop this going out, the names going out. But I won't stop. There's some amazing people. There's amazing within defence. A lot of them are sitting here, but the right people aren't being listened to. And hopefully an example needs to be made. The people who did this to me need to be made an example of. I told the Chief of Navy on the 24th of October 23, if he didn't do this, I would. And I appreciate his support, but as the leader, the buck stops with him. He needs to make an example and do the right thing. It's quite simple. It's respect your enlisted, and do the right thing by the Australian government, Australian taxpayer. It's not hard.
Thank you, Mr Armfield. Thank you, Commissioners. I have no further questions.
Thank you, Ms Longbottom. Before we move on to questions, I just want to point out this has been an incredibly effective part of the evidence, obviously, Mr Armfield, but we do recognise it can affect people. So if there's anyone either with us today or watching it on live stream or otherwise, and you feel affected by the evidence, please reach out to our staff, either here or online. All the details are available online to assist anyone who is struggling. Thank you. Commissioner Brown?
I don't really have a question. Thanks, Mr Armfield, for your evidence today. I'm just, I guess, sitting here reflecting that we heard in the last couple of days from the Vice Chief of the Defence Force. In fact, I think he's appearing again later today. And I did ask him about the comment that we hear often, that what defence does best is defend defence. And it kind of seems pertinent to the account that you've just given, that it sounds like there's a closing of ranks from what you've described, and you use the word cover-up. So it's not a question, it's just a reflection, I guess. But thank you.
Commissioner, one thing that was pointed out to me, and it's in the timeline as evidence from the meeting on the 5th of May 2023, the Inspector General ADF's office representative said, it just appears there's no advocacy. So the entire time when people talk systems and processes, they are there for the organisation and the reputation of the organisation. But there was nothing from me. And people go, you know, you've got different organisations here and there, but there was no one to actually champion my cause. There was no one to go call this out. Two commissioned officers tried to stick their neck out for me, which I appreciate, and one of them's here, verbally and in correspondence. But they shut down as well. So within the organisation, there needs to be a mechanism that you can go to. And IJDF himself said, I didn't get the context of your situation till I met you, John. So everything's happening via phone or email. So there's no one-on-one relationship. Therefore there's no compassion, there's no empathy, there's no understanding in everything I try to achieve. So it's something that definitely needs to be looked at.
Thank you.
Thank you. Commissioner Douglas?
Can I just follow through on what you mentioned about a mechanism to go to? Some people have said to us that in certain circumstances they need to be able to go outside the chain of command. From what I gather, though, you may well have been assisted by some of the people inside your chain of command?
Commissioner, not inside that chain of command, but I've had retired people from senior leadership reach out and meet me on the Gold Coast, and when they were there, and tell me how this situation would play out and what to expect. And if I didn't have that sort of support, I may not have knew there would an end would come, and I couldn't have gone through this fight for much longer. Commissioned officers that I'd trained or I'd worked with reached out anonymously if they were still serving and told me, for example, how the freedom of information, why it was being redacted, and how to navigate that. The clearance diving branch, a lieutenant commander was on his Mindhunter as a CO, and when he knew I was going in for the record of conversation, dropped everything and wrote up a quick character reference and sent it through to Morton to try and raise awareness that this is wrong. You know, there's a commander here who supported me throughout. And obviously within the organisation, there was 3 chiefs who stuck their neck out and looked at the documents to confirm what I was saying so I could raise this as an issue. So within the chain of command, Commissioner, there was not. DFR was the area manager was a civilian who wrote the statement and the flight sergeant, but no, not within that chain of command.
And could I conclude from what you've just said that the assistance you obtained was because you were well regarded by a number of other people who were your friends?
Yes, I like to talk and network, and so they were all my friends or colleagues.
And you think of a way for helping people who may not be as connected as you were, but need some assistance outside the chain of command. IGADF apparently came to your assistance.
IGADF come on the second attempt. I was very dogged, and I don't leave people alone, so I'd probably get a bit annoyed. And I keep going and I keep digging. If I wasn't back when I tried to help my brother as a naval seaman, there was no support within the organisation, and I think that's summarised in the IOI, in the inquiry officer's comments in every statement. He identifies failings, and I raise these failings, but no one would listen. If you're a junior enlisted, things could be very tough. Definitely.
You mentioned it being a 2-tier culture, and sometimes in different parts of the services, say in the Navy, you hear about above deck and below deck. Do you have any suggestions about how to fix that culture?
I believe the culture in the enlisted is good, and the strength you get in with your colleagues is good, and that's why I've got so many here, because we do have accountability and we do have justice and we have values, and everyone I'm a friend with adheres to honour, honesty, courage, integrity, loyalty. They did. And that's why we're all such good mates. That's why it creates a brotherhood. But I really don't believe, and I've raised this with the Chief of Navy, that his officers aren't adhering to those values. It's quite simple. And when they're not, do what you do to the enlisted. Hold them accountable. Infringe, charge, disciplinary action. They have to do it. And I believe I've collected enough evidence to show there were failings in mine. And the hardest thing for me is, and people don't get it, is when you're in a fight, and this fight went for 2 and a bit years, and people are constantly, the organisation's telling you you're wrong, the only people that kept buoying me were, actually I've got a team of 5 very influential and intelligent professional ladies who've helped me, the Royal Commission team, my psychologist. They're there going, reading the documentation I'm providing or sending, and your team read most of the documents, and they're going, you're right. So they pick me up. Otherwise, I could be another statistic, because it got very dark. You're being beat down. And it was intentional. So they need to answer for these actions. I really thought and hope today It's an abuse of power, right? Because by virtue of rank, I can do nothing about it. I can't. I've tried, and I believe the evidence shows I've tried. But it was another abuse of power happening today because there was three key individuals that I wanted to name, and that would be it's a level playing field now. I'm out, right? Now we're on equal terms. But that was denied because the Commonwealth didn't feel it appropriate. But I'm standing here to front. I'm standing here telling everyone I had a mental health breakdown. That's out there for the world, you know. Where are they? Right? That is poor leadership straight away. And the fact that the ADF tried to have their names redacted last night at last minute shows there's a problem because there is no accountability. That's all they have to do, hold people accountable. The CN knows because I emailed him within the last probably month or two and I got a response back on Sunday. I've clearly named the three individuals again, you know, but nothing's happened. Actually, something has happened. One was promoted from lieutenant colonel to colonel. So something has happened, okay? Unfortunately, do something about it. Otherwise, we'll just take it to the public now. You know, I've got the time, I've got the resources, and there's a massive there's some very good people out who want to fix the organisation. And that's what this is all about.
Thank you.
Thank you.
Thank you, Mr. Armfield. I don't have any questions, but I do want to make a couple of points, and then we'll see whether Mr. Lodziak and Mr. Fordham may have any questions. You've raised and you've highlighted very effectively many issues that are really very concerning and disappointing, obviously, but perhaps the most concerning aspect is that these events took place while this Royal Commission was sitting. All these things that we've heard about today and that are included in your statement were carried out by people while this Royal Commission was sitting with, I have to say, an air of impunity from senior people within the ADF, and those above them have done nothing to hold anyone to account. We want to thank you for your evidence today. We want to thank you for your service. We want to thank you for your courage in speaking up. If this is any comfort, you need to know that your statement and your story has helped the Royal Commission greatly. It's very much appreciated. Mr. Lodziak, did you have any questions you wanted to raise?
No, thank you, Commissioner.
Okay, Mr. Fordham.
No, thank you, Commissioner.
Ms. Longbottom, any matters arising?
No, thank you, Commissioner Cowdes. May Mr Armfield be released from his summons.
Thank you again, Mr. Armfield, and we wish you every happiness and success. You're excused from your summons to appear today. If there's no other matters, we'll adjourn till 11:15.
All rise. The Royal Commission into Defence and Veteran Suicide is now adjourned to 11:15. The Royal Commission into Defence and Veteran Suicide is now in session. Please be seated.
Good morning, Mr. Singleton.
Good morning, Commissioners. This morning and in the early afternoon, we have a panel of 5 DVA officials. We will be addressing 2 large and a couple of smaller topics. The first is claims processing. The second is engagement with veterans by the Department of Veterans Affairs, mostly in a non-claims processing context. And the 2 smaller topics will be the Department's Adverse Events Analysis Program and its outreach program, outreach counselling program run by Open Arms. Claims processing isn't necessarily more important than the other topics, but it is a lot more granular, and so it will take up more time for that simple, practical reason. Because there's not a lot of overlap between these topics, some of the panellists will be spending quite a bit of time listening to their colleagues, dealing with matters outside their ordinary work. But they are all invited to contribute, time permitting. I will introduce them once they're sworn. Might the witnesses be sworn or affirmed as required?
Do you solemnly declare and affirm that the evidence you shall give will be the truth, the whole truth, and nothing but the truth?
I do.
Do you solemnly declare and affirm that the evidence you shall give will be the truth, the whole truth, and nothing but the truth?
Yes, I do.
Do you solemnly declare and affirm that the evidence you shall give will be the truth, the whole truth, and nothing but the truth?
I do.
Do you solemnly declare and affirm that the evidence you shall give will be the truth, the whole truth, and nothing but the truth?
I do.
Do you solemnly declare and affirm that the evidence that you shall give will be the truth, the whole truth, and nothing but the truth?
I do.
Thank you.
Morning, panellists. I'll ask each of you to introduce yourself by name and current job title. I'll just go from left to right. Ms. Cole.
Natasha Cole, First Assistant Secretary, Client Benefits Division.
Mr. Carrolly.
Alexander Carrolly, Acting First Assistant Secretary, Claims Process Improvement Division.
Ms. McLaren.
Alison McLaren, Deputy Secretary, Veteran Family and Stakeholder Experience.
Mr. Pullen.
David Pullen, First Assistant Secretary, Program Delivery Division.
And Ms. Knoll.
Leonie Noland, First Assistant Secretary, Open Arms.
Might the tender list for today's panel session be brought up? I thank the operator for that. I tender the documents in the manner in which they've been indicated on this document.
Thank you, Mr. Singleton. They'll be accepted on that basis and allocated the next lot of numbers. Thank you.
I might just ask the operator to display the current DVA organisation chart. It's DVS 0012 0001 0635. It just will indicate to anybody interested just where these witnesses fit in. They're all on the organisation chart somewhere. While that's being done, Mr. Pullen, I might start with you. When was the Claims Processing Improvement Division created?
So the Claims Process Improvement Division was created around the time that I commenced in the role. I commenced in the role in the beginning of June 2023.
Were you the inaugural head of that division?
I was the first Assistant Secretary commencing in the role. That's correct.
And Mr. Carrolley, you're now acting head of that division, is that correct?
That's correct.
I'll come back later to get a list of all the work that you do, but could you just summarise the basic conceptual difference between your division and Ms Cole's division, which also deals with claims processing?
Yes. So the Claims Process Improvement Division was set up to undertake a range of claims process improvement reforms, separated from Ms Cole's division, which primarily deals with service delivery. And the Claims Process Improvement Division is really focused on working.
Sorry, Mr. Carrolley, can I just ask you to move the microphone closer to yourself? You can actually pick it up and move it closer. Thank you.
That's fine. So we work with business areas, particularly with CBD, but also with other business areas across the department to reform and establish a range of programs that will ensure that claims process improvements are made.
Ms Cole, you've been in your current role or an equivalent role for quite some time, particularly compared with the other panellists in their roles. Are there functions that were previously under your management and supervision that are now with Mr Carrolley?
Yes, there are. In particular, the QA program, the internal review program, and we had a small business improvement area, which has been significantly increased under the new arrangements. I think that's it in terms of the transfer, yes.
And QA is quality assurance?
That's right.
And internal review is of decisions with which people, claimants, are unsatisfied or dissatisfied?
Yes, so this is around the legislative ability to seek a merits review under each of the three acts, which has slightly different arrangements according to the acts themselves.
All right. You're aware, are you not, that in 2021-22, the government granted to the DVA a temporary increase in the average staffing level cap?
Sorry, when did you say?
The 2021-22 budget.
Yes.
And that increase was an additional 447 staff?
Yes, that's correct.
Many of them, but not all, went into claims processing work, is that correct?
That's correct.
The next year, the 2022-23 budget saw an additional temporary ASL cap increase of 92 people?
Yes. I believe it was 90, but it may have been 92.
Were they all dedicated to claims processing?
I believe those 90 were, yes.
All right. Mr Carrolley, one of the tasks that your fairly new division has actually completed, correct me if I'm wrong in any of these statements today, has been the recruitment of 500 additional staff. Is that right?
That's correct.
And all of them were recruited to work in claims processing roles under Ms Cole's management, is that?
That's correct.
Did it include a cohort for a new position known as claims support officers?
That's correct.
Ms Cole, it is a new role, is that right?
Yes, the claims support officers is a new role that we developed after a couple of trials within my division.
And when did the new role begin? I'm not talking about the trial, but as a permanent feature.
The new role as it currently is probably commenced primarily from about June 23 onwards.
And how many is now in place?
I can't recall the exact number right of today, but it will be between 350 and 400 staff.
What is the work that they do in brief?
So what we did with the client support officer role was we looked at the time-consuming elements to some degree of a delegate's work, and which could be done by another person. So in essence, we separated out the investigation process from the determination process. And what we did in that is that we created a role where someone is gathering up the necessary evidence in order to make a determination, and then it is handed to a delegate for that determination process. The delegate may yet choose to seek further information if they don't feel that there is sufficient for their decision-making process, or if the veteran or family member feels that There is further evidence in support of their claim, which they can provide. So it's kind of the first stages of investigation rather than the complete investigation process.
Are CSOs used in aid or as a part of the initial liability determination process?
Yes.
Are they also used for other types of claims?
They're also used at the permanent impairment claim stage.
Not, for example, incapacity claims?
Not for incapacity.
All right. Do the CSOs have authority to require a medical assessment or examination?
Yes, they can require or ask an applicant to provide a medical examination.
And when they ask, it is a request that has the effect that the claim stops if they don't do it.
No, that's not necessarily the case.
Can it be the case?
The only time where we would not continue a claim...
Just asking whether it can be the case.
I beg your pardon. There is a provision under the legislation which allows us...
Sorry. We know that delegates can, in effect, require a veteran to go and get an assessment. It might be nicely put as a request, but if the request is not fulfilled,
yes,
then the claim can be stopped. That is, it won't be granted, it'll be put in abeyance, correct?
If...
Suspended animation, if you like.
If... I'm sorry, I don't really understand exactly what you're asking, Mr. Singleton.
If a veteran claims an entitlement,
yes,
is asked to go and get another medical assessment,
yes,
and says, no, I don't want to, just grant my claim, will the claim be granted? Ever?
Yes.
Right.
So
it's optional for the veteran.
Yes, that's correct. However, there has to be obviously sufficient evidence for the delegate to find in favour of the veteran.
The legislation does permit, does it not, the processing to be suspended if there is no compliance with the request.
The legislation has the ability for a delegate to ask and provide a time frame, and if there is no response, to make a separate decision not to continue with that application.
Right. Do CSOs have the same authority as the delegate?
No, they do not.
So if the CSO thinks that that course is appropriate, the CSO must go to a delegate and recommend it.
Yes.
Thank you. Just diverting away from CSOs for a moment, but sticking with medical assessments, when they are required, I'll use the term required or requested, who pays?
For the medical examination, the department.
What are the main reasons why a delegate might require, in the sense that I've discussed, whatever the wording used is, why might a delegate typically require a medical assessment?
Usually where there is no evidence of a diagnosis of the condition that's been claimed for.
If a claim is supported by medical evidence that, if it was believed on face value, would technically suffice to meet the criteria of the SOP or other applicable rules, might the delegate nonetheless request a further assessment?
The usual time where a delegate or a CSO might require but mostly it would be a delegate in this circumstance, an additional assessment is where there is conflicting evidence available to that delegate, and they might be seeking a third opinion to try to clarify aspects of a diagnosis.
And if there is that situation, is it the usual thing to go and get a third opinion?
It's frequent to go and get a third opinion. It's not mandatory to go and get a third opinion.
So in a majority of cases, the third opinion would be granted, but in some cases, the delegate has authority to prefer one of the medical opinions over the other. Is that right?
If they're wishing to prefer one medical opinion over another, they need to have some element to justify that preferral. So it may be that it is a more recent diagnosis compared to a diagnosis at some much earlier time. It may be that the diagnosis is from a medical specialist as opposed to, for example, a GP.
Let's assume there was a a conflict, and the delegate consulted a medical advisor within the department who said, look, this first opinion, not necessarily in time, but opinion A is the more likely correct one, but opinion B is a plausible and quite respectable opinion. What would the delegate, in accordance with training and policy, do there?
So what the delegate should be doing in that scenario is, I'm making some assumptions here, Mr. Singleton, about the scenario, which I will outline. So say a veteran has declared that they have condition A, and there is evidence which suggests there may be condition B instead of condition A. This would be most likely to come up with something like a mental health condition, where there can be discussion around diagnosis. So if the veteran is insistent that they want to have condition A as their recognised condition for whatever reason, then it is open to the delegate to say to the veteran, I have a diagnosis of condition B here, and what I need to do is I need to ask you if you have any further evidence which supports your contention that you have condition A. And that would ordinarily be a discussion at the time of the decision determination, prior to the decision determination. And then the veteran has the option to go back and seek their own further medical advice if they wish, to go to one of our paid specialists under the the independent medical specialist arrangements, or to say, no, I'm actually happy if you find that I have condition B.
All right. Coming back to the CSO role, how long does it typically take for a new claim support officer to become fully productive?
At the moment, we are still working through in terms of productivity elements, but we think that a claim support officer is usually fairly competent at around the 12-week mark.
I just want to see how the CSOs fit into the organisational structure. Just to give some context, I'll put a few propositions one at a time, and I'll just get you to correct me if necessary or confirm. Delegates themselves are organised into teams under a team leader, is that right?
Yes, that's correct.
And there can be several such teams under one director and assistant director?
Assistant director first and then a director after that.
So there are several assistant directors with their teams under one director?
Yes, that's correct.
Many of the teams have a specialised role, such as in initial liability under MERCA or permanent impairment under DIRCA, is that right?
That's correct.
Whereas in the past, medical advisors were assigned to work under the management of directors and assistant directors, and thus to help those teams, is it the case that in more recent times the medical advisors are actually under the at least formal management of the Chief Health Officer's division?
That's correct. The medical advisors across the department are now under the Chief Health Officer.
When did that change take place?
I can't remember, I'm sorry, Mr. Singleton. It was in the last couple of years.
In that context, are CSOs assigned to work in particular claims processing teams with the delegates, or are they in their own teams?
So CSOs are within sort of technical types. So there are CSOs who work in the IL space and CSOs who work in the PI space.
But does any given CSO, let's say working in MERCA PI, come under an assistant director who's also supervising a delegate, or do the CSOs have their own assistant directors and they're, figuratively at least, in the next room doing their work?
I think it actually varies a little bit, Mr. Singleton. So, for example, we have a team in Melbourne who looks after all the incoming applications to get them started as soon as possible. That team, I'm just trying to remember, is within a broader registration, screening and, in a sense, claim startup team. I'm just trying to remember, I believe the Assistant Director also has some responsibilities for delegates within that structure.
Sure. When it comes to claims determinations, whether it's IL or PI, are the CSOs doing that work in the same teams as the delegates, or do they have their own teams of CSOs?
No, there is a separate team. Yep.
Do those, and each team has a team leader who reports to the Assistant Director, is that right?
Each team has a team leader, and then every two teams also have a senior delegate.
And do the that's with the delegates.
Yes,
A team
but
of delegates.
also with the CSOs.
The CSOs will be in a team by themselves with no delegates, but they have a senior delegate.
They have a senior delegate, and they often also have a delegate who provides a referral point and assistance point for them.
Right. Is it the case then that the CSOs work on particular claims that are given to them in some way or other, but given to them by the system rather than by delegates? They're not attached to a delegate who receives them and then hands it down?
No, that's correct. So the main space where we now currently use CSOs is for claims that are new, that have just been registered and screened. And so we have a team in our Melbourne office who essentially take those claims. They start the investigation process. They have delegates to assist them in that, specifically with that startup process, and senior delegates to assist them to make the right investigations, in a sense, if you see what I mean.
Well, does the CSO receive a claim to work on?
Yes.
Because the CSO says to management, I've cleared my desk or have got to some other point where I can take a new case, or are claims just allocated to CSOs on a regular basis and they just get another one every day or another 5 every week or something like that?
So generally they're allocated claims on a Monday, and those claims are allocated to a certain number, to a maximum number. But if a CSO has a number of tricky claims or is struggling with some of the technical aspects, then it's at the discretion of the team leader to reduce their weekly allocation.
Now, the last couple of answers, do they refer just to the CSOs working in Melbourne in the context of the registrations, or does it, what you've said, also apply to MERCA PI teams in other cities and IL
Yes,
teams?
so in terms of the allocation process?
Yes.
Yes. So we have a national allocation pool essentially for IL and a national allocation pool for PI, and essentially those are drawn down and distributed each week.
Right. In terms of those who are working on claims determinations, once they've done their investigation, they may or may not have got more information, but they've analysed what's available. Is the terminology that the claim is now labelled as investigation ready or decision ready or something like that?
Investigation ready.
And that's a reference to the legal term of investigation which the delegate technically undertakes?
Yes, I believe so.
It's just that everything's, in theory at least, nicely prepared by the CSO, and the delegate gets a much neater file than before, with fewer gaps, we hope.
Yes, so we find that the vast majority of our applications come in, you could describe as incomplete, without sufficient evidence to make to make a determination one way or another. So the CSO role is essentially about getting those applications up to a stage where they can be best looked at by a delegate.
The essence of this reform is it not, as follows? Previously, delegates received claims out of the backlog in an unprocessed state, but now they receive claims that have been curated or reviewed and put in a more ready state.
That's correct. It's still up to the delegate to determine whether or not there's sufficient evidence for that claim.
Mr. Carrolley, how many of the 500 people whom your team recruited are delegates or were delegates? Roughly speaking.
I don't have that information on hand at the moment, sorry.
All The ASL cap now has been removed by the government. Is the retention of the 500 people now really a matter of whether or not the DVA just has the budget to employ them?
The 500 were employed through an ongoing budget measure, so they are ongoing.
On the other hand, the 447 plus 90 or 92, around 430 odd positions, they are scheduled to end on the 30th of June this year, aren't they?
That's correct.
Since this Royal Commission's interim report, the DVA has done a lot of work to reduce the backlog. Let me just define that. The backlog, anyone can answer of course, but the backlog referred to claims that had been received but had not yet reached a delegate. Is that right?
Not been allocated for processing, so that's the definition that we use.
All right. And was that the definition back in 2022?
I might be able to help Mr Singleton. Yes, it was. And that's the definition which I believe is in the Commission's report, interim report.
There has, however, been a slight or perhaps significant difference in that the substantive meaning back in 2022 of the phrase allocated for processing was allocated to a delegate because the delegate did all the processing, correct?
Yes, that's correct, Mr Singleton. We didn't have CSOs at that point. here.
Now they go to CSOs, so when it gets to a CSO, it's out of the backlog, correct?
That's correct.
All right. To the extent that large numbers have been cleared from the backlog in the last couple of years, it's the case, is it not, that to a large extent, although not only, that's been achieved by the work of the additional 530 odd staff, correct?
That's correct. It's been achieved by the additional staff that have been provided.
What study, if any, has the department done on the likely impact on claims processing of the loss of several hundred staff come 1 July this year?
So the department has a demand-driven funding model which is used for budgeting purposes. We update that on a biannual basis, so twice a year. We're currently in the process of updating that at the moment. It's fair to say that while staffing levels are, of course, a very major component of our ability to make determinations, there are other factors that we would take into account in terms of any of the factors that go into the demand-driven funding model. And that includes things like productivity, things like the number of determinations, lodgements, and a range of other factors. We, as a department, provide that information to government for government to make a decision on in terms of the funding that they allocate, including for terminating measures.
Has a study specifically been done of the impact of losing several hundred staff from 1 July, if it occurs?
We undertake that work through budget processes using the demand-driven funding model. But those outcomes of that work would be budget in confidence.
So don't tell me anything about the budget documents or the budget process. Just tell me what your analysis is of the impact on claims processing if those staff are lost from 1 July.
So probably, hopefully not repeating myself here, but we provide the results through to government for budgeting purposes.
I'm asking you not to talk about that. Yep. Don't try and give an implication. Sorry, I'll rephrase that. We don't want people to infer what's going on in the budget process because you say what I think is the same, what you think might be very different. I'm asking just for your opinion as to what's going to happen to claims processing if those several hundred staff are lost.
Well, it's as mentioned, staff are a key component of our ability to make determinations. We would not be able to make as many determinations if we lost a number of staff. It is complex, and we do take into account, in terms of our modelling, a range of other factors as well. And as I said, including the number of lodgements that we forecast, productivity increases, as well as the complexity of claims. So there's a range of factors that we take into account, but it is fair to say that staff levels are a key factor in our ability to make determinations.
Your division, and we'll get to the detail a little later, but in very short, your division is devising improvements to the actual efficiency of the system. But until they are fully identified and embedded, the bottom line is if the supplementary and temporarily allocated staff, 530 odd, are lost in July this year, there's a real risk that the backlog or the time taken to process or other measures will start to go up again. There's a real need for those staff to stay on at least for a while if we are to avoid that risk, correct?
I'll repeat myself that these matters are subject to budget processes. Of
Please,
course,
I'm not asking about the budget process. What I say is correct, isn't it?
Lower staff means lower determinations, which would put at risk.
And that means
time taken to process.
a real risk that the backlog will start to go up again if those staff are lost.
We haven't finalised that piece of work for budget purposes. It's fair to say that time taken to process certainly we wouldn't be in a position to achieve time taken to process targets in a timely manner if we had lower levels of determinations as a result of lower staff. The backlog has been cleared this financial year with the current staff levels, including the 500 ASL that have been provided for.
All right. Is it a function of the CPID, Claims Processing Improvement Division, to conduct internal reviews of decisions with which claimants are not satisfied? I think you've already told us that, so I'll skip to the next question. Just in practice, how's that done? Do you receive from a veteran or an advocate some communication that they want an internal review? Is that the first step?
That's correct, and I might also ask Ms. Cole to add anything that I may not be across. But we have a team, quite a large team within our division that undertakes reviews and appeals of applicants that come forward.
But essentially, they're delegates having another crack at the same case, but they're under your management, not Ms. Cole's.
I'd just like to clarify that they're also more senior staff members.
Thank you. Now, Mr. Carrolley, does your division have a role with respect to the Veterans Review Board, which is the next level of review?
Yes, I'm not across the details of that, but in detail, we do have overall a role in liaising with the Veterans Review Board on reviews and appeals decisions.
All right. How does the DVA go about gathering lessons from the internal review process or the VRB or the AAT? Is there a feedback loop or some other way of learning?
Yeah, that's correct. So as part of the outcomes of reviews and appeals, we have a team within my division that looks at business improvement activities, does a research on whether we're seeing any particular trends in those activities, and provides some remediation actions or reform suggestions that may occur.
And to whom do you give those suggestions?
So we work closely with CBD or other business areas to identify those suggestions and work out a work program to remediate those issues. If they're systemic, sometimes issues are just simply a mistake of an individual.
Well, is there a feedback mechanism for simply a mistake?
Yes.
How's that done?
I might ask...
I'm happy for any of you to answer.
So once an issue has been identified, say for example an incorrect application of points at a PI stage, then Alex's team will liaise with my training and procedural team. It may involve a new procedure being written up to address that issue, and then generally we will also do follow-up training for the relevant teams. A similar process happens in terms of QA mistakes, where a persistent QA error is coming up.
To a large extent, that's systemic in nature. Does anybody go to the delegate who made the mistake and let's just say, listen, friend, you made a mistake here. This is what it should have been.
Yes, that does indeed happen. And in fact, actually, if the VRB has, or a QA officer has returned a decision because it was incorrect, it goes back to the originating team to resolve the issue.
And does it go back, does anybody actually speak with the delegate? who made
Usually the
mistake?
team leader will have a discussion with the delegate about the error at that point.
Mr. Singleton, if I could add to that.
Please do.
So particularly the quality assurance process, there is that feedback loop directly back to the delegate decision maker that made the error. And then the decision maker actually then has an opportunity to correct that error. So actually learning from doing by correcting the error. So we think that's quite an important mechanism to create that learning feedback.
Ms Cole, part of it's training and just correcting human error. I'll put that to one side. What, in your view, would be the most significant reform or other measure of a systemic nature that has occurred in the last year because of feedback through quality assurance or internal review feedback?
In the last little while?
Yeah, last year or so, but if you think the really big one was 13 months ago, then go with that.
More recently, and this was actually an issue that was coming up also in the AAT, there was a misattribution about how we were doing DIRCA PI cases, and after working with, in terms of attributing same body part but different injuries, and how we were applying points and impairment in that space. And so after much discussion with our policy colleagues, we subsequently significantly changed our instructions to delegates as a result of that scenario. That's probably the most recent one I can think of off the top of my head.
Right. Mr. Carroll, I just want to get a sense of what you do in your division. Firstly, there was the recruitment project, 500 people. Secondly, the review work, which we've just been talking about, and quality assurance work is third. The CPD also conducts discrete projects for improving the claims processing system. Is that right? So before I go to those discrete projects, is there a fifth or a sixth big topic that we should just add to that list?
The other area of the division deals with claims data analytics, and that's a service we provide to CBD and other areas, which looks at a holistic level the data on claims that it's coming through, seeks to provide that information to other areas for business intelligence purposes, and provide that in an easier to understand manner.
I could think of a few things, and maybe it's you could detect potential budgetary impacts coming down the pipeline, and the people who need to know are over at Treasury or Finance, or you could detect some changing thing that needs training, and you tell Ms Cole's trainers, you need to address this. You could detect all manner of things. Is there a particular focus that you have? Is it more about internal systems, more about the budget of Australia, or something else?
It's both. It's more, we do both internal systems, and we work with our budget. So the budget areas of the department don't sit within CPID, they sit within the division, but we use the information that we have on claims processing to provide that information for budgeting purposes. But a lot of the data analytics that we do is used by main business areas will be Ms Cole's division.
All right. Turning to the specific projects that your team does, I'm going to read a list of a bit over half a dozen and just ask, did I muck any of them up? And then I'll ask if there's anything of similar importance to add. We won't have time to do all of them in detail, but they are Our Commitment to You, which is a website. Sorry, I'll come back to that in detail, but that's one. Enhance My Service, the Medical Advisor Queue, expanded computer-based decision-making, a trial of a new medical information gathering service, trial of Smart Coach in inverted commas, and the Medical Reforms Review. Any mistakes in that list? Did I muck it up?
No, that's correct.
Anything to add to the list?
Look, I think the other aspect is the website and being able to provide more data on the website than historically the department has been able to have available.
You're in charge of the website?
No, I'm in charge of the website, but each individual business area provides the information that we put on the website in a format that is accessible.
Thank you. Let me just sample a couple of from the list. Our commitment to you, would it be fair to say that's a set of customer service standards in respect of communication between Department of Veterans?
That's correct.
They're published on the website?
That's correct.
And one of them is that phone calls will be returned within 2 days?
That's correct.
How is compliance with that standard measured?
So at the moment, because our commitment to you has been established, I think it was in October last year, we're still collecting data on the compliance associated with that, as well as the other metrics that are published.
How are you doing it? Did you actually have a log that tells you when each veteran rings and another log of when the calls are returned?
I don't have that information, but I would assume, as we do with many of our programs, we would take a sampling approach. But given it's only a recent innovation of the department, we haven't collected a large enough sample set of...
Right, but it would be a matter of sampling the data you have, not, for example, doing random surveys of veterans and asking them whether they did receive a call back within 2 days.
It could involve both, but as I said, we haven't done the analysis at this stage.
All right, so we don't have compliance rates at this stage, correct? Another standard is to acknowledge the lodging of a claim within 5 days. In the case of claims made via My Service, is that done automatically, that acknowledgement? If anyone knows.
Unfortunately, I don't have direct access to My Service, not being a veteran myself, but it usually says your claim has been received or something similar once they press the submit button. When we are talking about lodgement, though, however, we're talking about after it's gone through registration, and we send an acknowledgement letter after that period.
And quite properly, one would imagine that the acknowledgement letter is pretty much the same for each veteran.
Yes.
Strikes one that could be automatically generated. Is it automatically generated at the registration time rather than the lodgement time through My Service?
So we would describe it, I think, as application time and registration time, just to be clear. Because some people lodge through other means, such as a paper form, which comes through the mail, or through the ESO portal. So registration is what generates an acknowledgement letter. And what happens at registration is we start to activate things which may be automatically available to that applicant at the time of lodgement, for example, PAMT.
How long does the registration process take?
At the moment, we are aiming for registration and screening to occur within 14 days.
14?
14 days for both processes.
Okay, that's the aim. What are the current stats on how long it's actually taking?
We're still collecting data, but the interim data that we've been able to collect over the last couple of weeks has been 98% of new claims allocated within 2 weeks.
And does the registration process include what we heard about 2 years ago, Ms. Colvin, I think when you were testifying, the triaging process to spot claims or claimants that need expedition or support?
Yes, that's correct. So that 2 weeks covers both those actions. So registering the claim on our system, activating and advising the applicant of things they may be eligible for, like non-liability healthcare and PAMT, depending on the application, and also screening for prioritisation and also referral to Triage and Connect.
I could be completely wrong about this. It's just the memory of an old man. But my recollection is when the testimony was given in Sydney 2 years ago, mainly in the context of the McKinsey report and what was happening, we were told that registration is within a day or two and the triaging is within 4 days. Firstly, does that sound right to you as the situation a couple of years ago?
I'm sorry, I really couldn't say from 2 years ago. The whole process, we aim to allocation to a delegate. So in a sense, when we're talking about a delegate or a CSO. So in a sense, the 14 days we're referring to has 3 subcomponents.
Does the registration process, that 14 days or however long it is in the individual case, count as a period when the claim is in the backlog?
Yes.
Once it's registered, I want to go step by step through the claims process. I'm going to ask the operator to display DVS 0012 0001 1889. This is a printout of the DVA webpage making a claim for a service-related condition. And you can see that it begins, I'm summarising, but it begins with a bit of a table of contents. And if you click on one of those many links, you just jump down the page. I'll ask the operator to scroll down until we get to step 1, get your medical practitioner to confirm your diagnosis. So do you see there are different size headings, but one of them there is step 1, get your diagnosis. And I'll just ask the operator to make a larger balloon, not bigger, but covering more text, because there are 2 subheadings. Do you see submitting a paper claim as the second subheading under get your medical practitioner to confirm your diagnosis? You can see that, Ms. Cole?
Yes.
Do you think it would be helpful on this webpage to tell veterans where they can get the paper form? The implication is you can do it on paper.
Yes.
Do you think it would be helpful to tell the veteran where they can get the paper form?
Undoubtedly, that's true.
Has consideration ever been given to that idea of putting that information on the webpage?
Well, it had never occurred to me, but I'm sure that we could go back and reconsider that issue, Mr. Singleton.
Has consideration been given to including on this webpage a list of all the ways in which a claim can be lodged?
I think at the time that this component was drafted, we were very much trying to make it as simple as possible.
Well, what I'd suggest to you, it would be as simple as possible. There's the veteran who wants to make a claim and is wondering how to do it. There are multiple ways of doing it. They'd go to the How to Make a Claim webpage. This one's called Making a Claim for a Service-Related Condition. That sounds like the right place to go. Don't you think it would be helpful to have a list of the ways you can do it?
Yes, I agree. And we are, Mr. Carrolley is currently working on some revisions to the website, which would potentially enable us to pick up some of your suggestions.
All right. Now, many claims are made via My Service. Would that be a majority by now?
Yes, certainly for MERCA, less so for this other acts.
Right. And MERCA's the big one.
Yes, that's correct.
In terms of statistics. Now, we've heard that although it's an electronic method of lodging the claim, the information that the DVA thus receives then has to be manually typed into the processing system. Is that right?
That was the case in the past, particularly when My Service was first being established. One of the amendments which were made fairly on when I was in this role, started in this role, was some automatic movement of the details between our processing system and My Service.
Is all the data received through the My Service, all that is entered by the veteran or representative, automatically put into the processing?
That's my understanding.
How long has that been the case?
It would be at least 3 or 4 years.
Right. for other ways of doing it, turning up at a DVA office
Yes.
or posting a paper form, does that then have to be manually entered into the system, or is there some scanning system or something else?
So when a application is received in paper through the post, it goes to a postal service who scans it electronically and then forwards it through to our registration system. I believe that they still have to manually enter it at that point, but I would need to confirm it.
If a veteran just has a single injury, can he or she, by making one claim, seek all of his or her entitlements in respect of that injury?
Sorry, Mr. Singleton, what are you asking? Like, what do you mean?
I'll just lead into it. It is the case that if a veteran wants to do so for an injury, let's just say it's a knee injury, just make a claim for the Commonwealth to accept liability for the injury. They're not seeking compensation, they'll do that later. They can just ask for a determination.
Yes, absolutely. Yep.
But some will want to not only get the Commonwealth to admit liability, but they'll want the compensation as well.
Yes.
Do they have to put in two claims or one at that point?
So that is a two claim. So one claim for initial liability and one claim for permanent impairment, because as you say, many people may choose not to go because they get health services and other.
So do they have to fill in two forms?
No. So can I talk to a typical case?
I think, because we're a little short on time, I'll just try and get out a couple of details. They can do the one process, is that right? That culminates in two claims being received.
What ordinarily would happen is that an initial liability claim would be made. It would be determined to be positive, not a claims adjudication.
We haven't got there yet. The poor veteran is sitting in front of a computer. We'll do a My Service case.
So in a My Service case, you cannot apply for PI until your IL is finalised.
Right, now, so if the person wants to, as is their legal entitlement,
Yes.
to claim IL and PI at the same time, they can go to My Service and claim the IL, and then they've got to go and find the paper form and mail it in.
That is correct.
All right. I think we've dealt. Now, all of the registrations received, all the claims received through My Service are registered in the Melbourne office, is that right?
Yes.
What about the claims that come from other channels?
All claims are registered through the Melbourne office.
All right. Once they're registered, I think you did say, but I've forgotten. Once the registration process is completed, 98% of the time within a fortnight, has the matter got to a CSO for some work, or is it now just going to sit in the backlog?
So the target is that it is with a CSO within 14 days. So those other processes must occur before that can happen.
Once the CSO has finished his or her work, what happens to the claim then?
So at that point, it is marked as ready to investigate, and it goes into the allocation process for the next available delegate, basically, who has the right skill set for that type of claim.
Is it now considered to be back in the backlog?
No, it is not, because it's a claim that is commenced.
So it sits there. Where exactly does it sit? Is there some terminology we can use to refer to this period when the CSO has finished work and there's no delegate yet available to do the work on it, do further work?
So most of the time it goes fairly fast between the...
I'm not asking that. What's the terminology, that, if any, that you use?
So we call it the ready to investigate queue.
Right. And when a matter's in the ready to investigate queue, it's not considered to be part of the backlog.
That's correct, because that claim has commenced.
And what is the average length of time that a matter for initial liability sits in the ready to investigate queue?
I don't know at the moment, but it is not a long period.
Well, that's relative. I mean, 2 years ago when we were getting the details, we were hearing about cases that didn't get to a delegate for 400 days and other large numbers. So relative to that, 300 may not be a long period. Are you saying that 300
No, we're
might
not
be
talking about that.
What are we talking about?
We're probably talking, depending on the time of year. So, for example, over Christmas, it might take 2 weeks because we have 10 days of shutdown. After that, it might take a week because what will often happen is teams will have a day that they delegate. IL usually allocates on Mondays, PI usually allocates on Wednesdays. So it can sit there waiting for an allocation day. And then if there is a period where we have, so say it was put into the queue on a Friday, didn't get allocated that Monday, it might get allocated the following Monday. So that's the kind of time period that we're usually looking at. If there is something in between, like Christmas in particular, Easter, Anzac Day, etc., it can extend out a little bit longer.
So let me, in terms of productivity, January would be a relatively low productivity month because of
That's
people on
correct,
leave.
yes.
Is it the lowest productivity month?
December is actually the lowest because of the office shutting on the, essentially finishing work on the 24th. So we lose six to 7 working days.
Are there other seasonal variations or are the other 10 months about the same?
Usually there is a variation around school holidays, essentially. Yep, when delegates go on holidays.
And in a leap year, February has a huge surge, is that right?
A day's surge, yes.
Mr. Singleton, if I could just add to that, there's also the factor on the other side, which is there's less claims that are actually lodged over the Christmas period, so that the two generally tend to balance out. The other element is I was aware that additional staff were working additional hours to also balance some of the urgency around the backlog over the recent Christmas period.
Thank you. Let's just step through the process. We've got to an initial liability. It's in the terminology after pestering you to get it, but the ready for investigation queue gets to a delegate. The delegate has to consider it.
Yes.
Does the delegate call for a matter because the delegate has a clear desk or something like that? Or do, as with the CSOs, do matters just keep getting fed to the delegate and they're meant to keep up, although they can put up their hand if they need to?
That's correct. So we have an expectation that we'll be able to assign a certain number of claims to a delegate at allocation day. However, if a delegate has a particularly complex matter before them, perhaps with many, many conditions, or doing a number of cases with high priority, or maybe struggling with workload, then those adjustments are made by the team leader at that point.
Has a study been done to see whether the time taken per claim by a delegate has been shortened since the introduction of the CSO?
Yes, it has.
How much?
Mr. Carrolley this team undertook that study.
So I don't have the details on hand at the moment. We undertook a study to look at the impact of the new CSO model on the number of determinations per delegate, and we found a significant productivity increase as a result of that model coming through.
Now, let's be precise, that's a significant productivity increase, which means delegates are taking less time per claim. Is that what that means?
Delegates are taking less time per claim, but the CSO has largely done quite a bit of their previous role in terms of making a claim investigative ready.
Well, that's the explanation of why the delegate can spend less time, correct?
That's correct.
Is the total amount of time taken by a CSO plus the time taken by a delegate longer or shorter than it used to take the delegate working alone?
So we haven't undertaken that level of analysis. We're seeing at a holistic level some improvements, particularly in Mercer IL, in terms of the amount of time taken to process a claim overall. but not on a per delegate or per CSO basis.
This is not a criticism. I in no way suggest that the CSO model is a bad one. It, on all indications, looks to be a sensible idea. But it would stand to reason that the total time taken for the two officers to look at the matter will be longer than it used to take one delegate, because it's at best the same amount of work, but the bigger piece of work is actually being done by a person with less experience and perhaps less qualifications. That'd be right, wouldn't it?
I'm not sure that is right. What we're seeing at the moment is overall time taken to process for many of the claim types that were initially out of backlog in around November start to come down, and that's over the period that we have the CSO delegate model running through. But again, we haven't done the analysis specifically on the time taken to process split out by CSOs and delegates, but at a holistic level, we are starting to see a reduction in time taken to process, albeit small, from the peaks that we saw last year.
Are there more CSOs than delegates?
No. There's currently there are around 150, I believe, more delegates than CSOs.
And is that true of specific areas like Merca PI? Are there more delegates in Merca PI than CSOs?
I believe so, but I would have to get the specific numbers.
Now, if initial liability has been accepted, I just want to keep going through the process, and the person has claimed compensation for incapacity and permanent impairment, as we've heard, they must have written it in rather than done it through my service.
Can I just clarify that,
yes,
please? So under the legislation, we are required to do something called a needs assessment. The needs assessment must occur after the IL application, but before the PI completion. So essentially we do it in the middle. In the needs assessment process, we will have a discussion with the applicant about what they need, obviously. One of those things they need might be household services, it might be incapacity, it might be permanent impairment. If it's any of those latter two, we will lodge an application for them.
I appreciate that, but they might have, and have the legal right to do so, do they not, have lodged claims in the first place before?
Indeed, they do, and in incapacity, the system allows them to do that at the initial point of engagement.
So a veteran may claim initial liability, claim compensation for incapacity, and make a claim for permanent impairment.
Yes.
In the way that this is processed, once initial liability is accepted, let's say it is, there'll be the needs assessment. That's a part of the initial liability process. But once it's determined and the needs assessment is completed, does the department first turn its attention to incapacity, or does it turn its attention to PI?
So because those are run by different teams, they can run concurrently. Depending on the circumstances of the individual, we may be giving particular priority, though, to their incapacity claim.
And it may well be, even if only for workload reasons, but sometimes the sequence will be IL, incapacity, PI, in that order.
So we would particularly do it in that order for example, a person who is transitioning who did not have an income available to them post-transition at this stage.
Given the distribution of teams around the offices, it could come to pass that a claim or set of claims is registered in Melbourne, initial liabilities determined in Hobart, off to Adelaide to deal with incapacity, and then it lands in Brisbane for a PI determination. Is that right?
It's theoretically possible, except for the fact that Adelaide does not do new claims for incapacity. So incapacity new claims is only done in Brisbane and in Perth, and both those offices also do PI.
So if it's a new claim, we'd have to modify my question to have Perth, not Adelaide, and then off to Brisbane.
Yes, but it's more likely that Brisbane would do, if you had the incapacity team in Brisbane doing the incapacity claim, that you would also allocate the PI claim to the Brisbane office as well.
Is there a person that's actually doing all of this traffic management?
Yes, we have allocation managers.
All right, well, let's say we're now in the Brisbane office, and let's put incapacity to one side with no disrespect to that topic, but let's take a simple case. IL's been granted, the delegates rung up the veteran, confirmed that he or she wants PI to be assessed at this stage, and it's in Brisbane now for that purpose. It goes to a CSO first, is that right?
If there's not sufficient. So a CSO will look to see if there's sufficient evidence, which there may be.
That could only happen if it went to the CSO first.
Yes, so the CSO will look at that.
And they may well find that everything is in order, so they don't have a lot of work to do, or they may find that there's more work to do.
That's correct.
Is there anybody else or any other role to whom a matter might be allocated other than a CSO?
For a claim?
Yes, there's a Merca PI claim. It's come out of Hobart. Liability's been accepted. It's landing in Brisbane through an allocation decision. It goes to a CSO in the first instance in the typical case. Might it go to somebody else?
Yes, so there would be two circumstances where that might happen. One is if it's a combined benefits claim, in which case the same delegate who did the IL will also do the PI. So it doesn't go anywhere in that scenario. In a combined benefits claim...
Well, see, I'm not asking about that with respect. It's a simple IL Merca PI.
That I'm telling you that in some cases, if it commenced with a IL delegate, it will stay with that delegate to do the PI stage.
That can't possibly meet the description, can it, of IL was determined in Hobart and the cases arrived in Brisbane.
Apologies, Mr. Singleton, I didn't realise.
There are hundreds of different permutations. I'm just taking this one, which is not uncommon.
Yep, okay.
It arrives in Brisbane. Typically, it'll be given to a CSO to look at first. I'm just asking, might it be given to someone else first?
It may be given to a delegate first if it were a prioritised claim.
Right. And these allocations are all recorded, I presume?
That's correct.
In a computer?
Yes.
Are matters ever allocated to team leaders?
Not to team leaders, but to senior delegates.
So it could go to a CSO, a delegate, a senior delegate, not a team leader, not an assistant director?
Could go to an assistant director if we felt that it was a particularly sensitive claim.
Who would make that decision?
Usually that decision would be made by generally by an EL2 or an AS, Assistant Secretary.
Someone in the allocation section that we meant, the traffic direction people?
So it is more likely in that scenario that we would be aware that a claim is coming through that has high sensitivity, and in that case we may choose to to ask the allocation team to direct it to a certain individual who has expertise.
All right, so we've got the claim could go to a CSO, typical, might go to a senior delegate within the CSO team, not a senior delegate in a different team.
No, in that scenario, if it was going straight to a senior delegate because it was a sensitive technical case, for example, then it would most likely bypass the CSO and go straight to a senior delegate.
Yes, but you told us before that senior delegates can be found in at least two places. One is a team of delegates.
That's
one
correct,
is a team of CSOs.
Sorry, I meant to a delegate team, senior delegate.
Right. They don't get allocated to team leaders, you told us, but they might get allocated in rare cases to an assistant director. Do they ever get allocated to a director?
It would be extremely rare. It is possible, but would be extremely rare.
When it's allocated to an assistant director or a director, do they have the role of a delegate?
Yes, in that case, they're exercising delegations as a delegate.
Now, let's go back to a typical one, lands with a CSO who sees that there's work to be done and starts work. How often does the matter get taken off that CSO and given to another one?
Ordinarily, it wouldn't get taken off a CSO unless that CSO ceased working in that position.
So one can imagine resignations, illness of a long term, but not according to ordinary practice if the CSO is still available to work.
That's correct.
In a typical matter then, and absent a factor like a resignation or an illness, one would expect 4 people of the kind we're talking about, which is the Hobart-Brisbane axis. There'll be one CSO in Hobart, one delegate in Hobart, one CSO in Brisbane and one delegate in Brisbane, and then the claims are determined in our scenario, correct?
That's correct. So,
do you have a sense of how often the computer will record that more than 4 people are allocated?
no, I don't have that.
Is that sort of thing ever checked or audited?
I don't believe it's checked or audited except in individual cases.
Can you tell us what holding bays are?
Holding bays is a terminology we used particularly when we had a large backlog. And so a holding bay was where we had claims that weren't active at that point in time. We also used
What was it? What was the holding bay?
Well, essentially it was where the queue was held in an electronic sense, where the claims waited for allocation.
And did that count as being in the backlog?
Yes, it did.
So if a matter had gone through a CSO and they'd done some work on it, could it ever then go into the holding bay?
It will go into a bay for allocation, like the ready to investigate queue. So the terminology is not precise in this space.
But the ready to investigate queue is a bit different from a holding bay, is it?
That's correct. So holding bay was generally after registration. So we had a Mercer IL holding bay, a Durka PI holding bay, and so on and so forth, as you can imagine.
Generally, but is it the case that there are, for example, holding bays in the Mercer PI area in Brisbane?
There were certainly holding bays for the backlog cases, and there are ready to investigate queues now in the Brisbane PI space.
So is it the case that a matter that of CSO has worked on could then next end up in a holding bay?
Well, it would be possible if there weren't delegates available to do those claims, yes.
Now, under the current system, that would not count as being in the backlog because the matter had already gone to a CSO, correct?
That's correct.
But in the past, before the CSO system was brought in, it would count as being in the backlog when it was in the holding bay, correct?
The holding bay was after registration, yes.
Yeah, so under the old system, 2 years ago, before the CSOs came along, if one was measuring the backlog, one would take every case that had come in and had not yet reached a delegate.
That's correct.
Including a bunch in the holding bays.
Yes.
But now you would take every claim that had come in and it's only in the backlog till it gets to a CSO. After the CSO's worked on it, if it goes into the holding bay, it's no longer counted as being in the backlog, correct?
If it goes into a ready to investigate queue.
Or if it goes into a holding bay.
Except that we don't have anything sitting in holding bays currently.
You say that the holding bays currently have 0 Mercer PI matters?
I don't have that information.
So there will be a ready to investigate queues in each of our process
Just come back
lines.
to my question and say you don't know if that's the truth. My question is, are you saying there are 0 matters that have been looked at by a CSO in the holding bays in respect of Mercer PI?
So if you distinguish between a ready to investigate queue and a holding a bay,
I'm asking a yes or no question.
I cannot guarantee that there is not 1 or 2 claims. I do not know.
And what about with initial liability? Can you guarantee there are no matters in holding bays for initial liability, being matters that a CSO has already looked at?
So my view would be that those are in the ready to investigate queue.
Right. but you can't guarantee there are none in the holding bays.
No, I can't guarantee there are none.
And in practical terms, there's no difference between the ready to investigate queue and the holding bays, because whether it's classified in one or classified in the other, no work's being done on the matter, correct?
So if we were to go back to the purpose of a CSO,
Well, I'm not going to do that. I'm sorry, because we're very short on time. In the case of matters in the the investigation ready queue, no work is being done on them to progress them, correct?
for a brief period, yes, until it's allocated to a delegate.
For the entire period that it's in the queue, correct?
For a brief period in the queue, yes.
You saying that for a brief period in the queue there's no work, but for a longer period in the queue there's work?
No, I'm not saying that at all. I'm saying the period in the queue will be brief.
And if it's in the holding...
Sorry if I could add to that,
yes,
Mr. Singleton. I think because of the very brief period, I guess one aspect is it's actually an administration exercise. So it's less about being a queue and more about actually being able to allocate it to the right delegates in a sort of an orderly way. So I'm not sure the queue is really accurate, or it might be misleading terminology.
Let's assume that... So with that qualification, and we understand that there's a special definition for queue now, do you keep statistics on the number of matters in the queue at any given time?
Yes.
And do you keep statistics on the average length of time matters are in the queue?
I don't currently, but I could keep statistics on the average length of time.
All right. According to the DVA website, last November 30, the PI backlog was 11,647. That's Durka and Merker combined. In December, 2,667 claims were allocated to staff, so that backlog went down to 8,980. Did that figure represent a significant surge around that time?
So after we basically brought IL back into BAU, we were able to transfer staff from IL to PI, and that occurred over November and December.
Right, so that was, because the figures on the website only go back to 30 November and then there's a jump to 2022, but that there's a surge beginning in October, November, is that right?
Oh, sorry, can you just tell me the timeframes you're asking again?
Late last year.
So we're talking 23?
Yes, last November 30, we're at 11,000 odd, and in December they allocated 2,600 odd.
Yes, so that was subsequent to us moving resources.
When was that move of resources?
So that occurred over November and December and finalised in January.
All right. I'll come back to you, Mr. Carrolley. Are you aware of a pilot project being undertaken with the Special Air Service or SAS?
That was before my time in the department. I'm not sure if Ms. Cole has any further information on that.
So soft pilot?
No.
Sorry, which
not,
pilot?
not the Special Operation Forces pilot, the Special Air Services pilot.
Oh.
Is any of you aware of that pilot?
Sorry.
No, I'm not aware of that pilot.
So we'll come to the Special Forces pilot instead. I'll give a very brief description of one aspect. A key feature of that pilot for our purposes was that a delegate who was supported by a team with an administrative staff member, perhaps a bit like a CSO, but they didn't exist then, a medical advisor on hand, would collectively review the whole of a claimant's different claims, all aspects, IL, PI, try and do the whole thing in one big process. Firstly, does anybody wish to add or detract from that? Admittedly oversimple, but brief summary. We'll move on. Do you accept that SOF pilot approach was fundamentally different from the production line approach that we have now, where a matter could go from Hobart to Melbourne to Hobart to Adelaide to Brisbane? I meant Perth when I said Adelaide. Do you see the fundamental difference between doing it all in one big go and the production line? Do you agree that's fundamentally different?
Yes, I do. And I think the thing that has been difficult around those kinds of pilots has been the highly technical nature of the work that we do with the 3 acts.
Well, we may there may be a question to which that's the answer, but let's just keep going. Has the CPID undertaken a study or some planning exercise or something along those lines with a view to introducing a new model of claims processing, either based on the Special Operations Forces pilot model or some other model which is more integrated along those lines?
No, we haven't. We are doing some initial considerations around future operating models and what they may look like under the new single act, but not specifically in regards to soft pilot.
Are you in a position? Are there any labels we can put on that so that we can ask you about it later? What's your favourite one?
This again is something that Ms. Cole might be able to add to, but we are having a look at a model around that focuses on a wellbeing approach to or a life cycle approach for a veteran, and that's a model that we've started to do some initial thinking around. But I think Ms. Cole might be able to provide more details on that.
If you're able to assist Mr. Carrolley with letting us know what in practice they're all meant to be wellbeing.
Yes.
You know the one he's talking about?
Yes, I do. So one of the discussions we're having at the moment is the opportunity that the potential change in legislation, the simplification of legislation and the increase in the percentage of MERCA claims gives us. Because previously we have had this really significant difficulty around training and the ability of delegates to be able to deal with the complexity of a dual act and a triact case and so forth. So what we are thinking is that this gives us the opportunity to perhaps reorganise the claims processing into a sort of a life stages model. So we would have obviously some common functions up the top, like registration and so forth still, but then we would be able to do a much more bespoke model for serving members who have particular needs, including working more closely with Defence in that space. We already have quite a few strong models around transition, but strengthening up that transition process. And then moving towards non-serving members having their own specialised processing teams doing all of the functions, for example, combined benefits processing within that middle stage. And then what we see at the moment is a real gap where veterans are moving from sort of employment age to retirement age and anxiety about their financial status in that scenario. So putting in a kind of retirement transition team. And then finally, we already have, quite a distinct function in our income support area around supporting people who require some financial assistance in income support.
Could I put back another way of saying that with examples, and you tell me if I've got it wrong or right?
Yeah.
But you'd be rearranging your delegates and CSOs into teams,
yes,
not based on MERCA PI or incapacity over here, but based on the stage of life of the veteran.
That's correct. That's what we're considering.
And so there might be a team for currently serving Navy personnel.
I don't know whether we've thought that detailed about whether you would also have service distinctions.
Well, I'll just keep it a little broader. You might have a team for currently serving personnel under the age of 30 and one for over the age of 30.
You could, in that scenario.
And you might have one for people who retired long ago, and another for people who are going through transition, and another for people who are recently retired. And I'm not binding you in any way to those teams, but does that give the flavour?
Yes. So an example that we have at the moment is we have a specialist team in Perth, and that specialist team looks after medically discharging, transitioning officer, service people, and they do the IL, the needs assessment, the incapacity payments, and the PI. They do have a warm handover in incapacity because it's technically difficult, but essentially they try to make sure that all is in hand prior to the person actually transitioning out.
Does this model have a name?
We're calling it the life stages or wellbeing model. It's still in early conception stage.
Is there a particular, I'm not going to ask for a name unless it's one of you, is there a particular person who's leading that project?
So Alex and I are working on that together.
And is there a paper that describes the idea? Have you got to that level?
There's actually a diagram rather than a paper at this stage.
A one-page diagram?
Yes.
When was that document created?
A couple of months ago.
All right. So early days yet?
Yes. We think that it becomes more possible as a concept with the advancements in the legislative change agenda.
I'm going to suggest it sounds rather like the Special Operations Forces pilot, not because everybody will be made to join the Special Forces before they can come to the DVA, but that it would be a team dedicated to a group and everything is done. All the different types of claims are within the competence of the group. To that extent, is it similar?
Very similar. So it would take us a while to do. I think the other thing is that we need to acknowledge that there will be a number of people who will still have VA and DERCA entitlements, and we will need to keep a centre of excellence in one of our offices for those older acts in the legislative change environment.
What triggered the thinking that's led to this diagram and this model that you've outlined?
So,
what or who led to it?
So what we are very conscious of is the fact that a veteran can pass through many hands, as you've described. And
I'll ask it another way. Whose idea was it first? Who told you to do this, start this thinking, or was it one of you two?
It was a concept that I worked up with my assistant secretaries recently in a planning day.
Was there an event that led you to start this work and thinking? I'm not claiming any credit at all, but maybe you gave evidence at the Royal Commission and the next day you start thinking. I suspect not, but was there some event that triggered your work?
I think the things that have really concerned us over time has been the client experience, obviously.
I understand the concerns that need to be addressed. I'm trying to work out, in effect, why did it start when it started?
So essentially the work on the potential effects of the legislative change allowed us some freedom, I guess, in a sense, to think laterally about how best to arrange our division, whereas we've had to do it, as I've described, around technical expertise up to this point.
Thank you.
Do you mind if I add to that as well? The other aspect, of course, was the reduction in the backlog that enabled us to actually look and forecast out into the future what we should be doing going forward, together with the legislative change as well.
Thank you. Ms. Colt, I want to go through a few scenarios of the individual veteran experiences, not naming anybody, even if you happen to recognise anybody, and we won't be outlining details of the whole cases for the same reason. But just the idea is to look at some of the ways the system can work or misfire and get your thoughts on these. So let me start with the first one. If a veteran in a claim form claiming acceptance of initial liability and treatments on a non-liability basis claimed that he was seriously injured, and that's the nature of the claim, I have received injury in combat or something, and if he said in the claim form that he is living alone and he needs help, and I'm saying he's written this on the claim form and he's used the word help, would you expect that to be considered routine, or would that flag that there may be a concern?
So and that's not an entirely uncommon scenario in the contentions part on my service. If a veteran has indicated at that stage that they require assistance, what I would expect would happen would be that the screening team would refer that person to Triage and Connect for further assistance.
Now, to be fair, the particular example comes from early in the Royal Commission, late 2021. Does that change your answer? Was it different back then?
No, back in 2021, we had our screening process up and running, and I would expect that that person would have been referred to Triage and Connect if they were writing things that create a concern, like I need assistance, I am whatever.
So you referred to referring it to the triage. Does that mean, because the registration process, does that, just remind me, does it now include, 14 days include the triaging process, or is it after the 14 days?
So my division is not responsible for Triage and Connect, so we do a referral to that team who have considerable more expertise.
So your team is the one with the job of spotting these flags. If you do spot it, you would expect it within 14 days, but it may be that long, off to one of Mr. Pullen's teams.
Yes, that's correct.
We will get you, Mr. Pullen. And on present arrangements, if it took 2 weeks for someone asking for help, that would not be out of the ordinary or a matter of procedural concern.
So because the 14 weeks includes the allocation process, which might be a next Monday or whatever the case may be, it may be sooner than that, and I would certainly hope so.
Just as an aside, there's a series of criteria to guide your staff on when there might be a need for triaging or other support or whatever remedy is available. That's correct?
Yes.
Some of them are just, this factor alone is enough, correct?
Yes, yes.
It doesn't have to be a complicated set of weighing. It might be one thing flagged, correct?
Yes, that's correct.
One of those flags would be that the person was impacted by the IGADF's Afghanistan inquiry.
Yes, if that's the case, there's a very particular pathway that claim will go down.
Has it been the experience of the DVA that is a real concern, that the experience shows that people so impacted have a distinct need for such support, or for some support? So if what the arrangement that we have is that if a person indicates that their advocate indicates that they're impacted by the IGADF investigation, we do 2 things. We obviously screen, and we then also send it through to our specialised case team, and they have social workers. About half the staff there are social workers and senior claims delegates, and they will work together to assist that individual through a very difficult time. And much the same with other reasons for flagging concern. Yep. I'm not wanting to be too cynical, but there are various risks if one looks at any risk matrix, one of which is financial, another of which might be the risk to the veteran of some self-harm or otherwise. There's reputational risks. Is the reason that the Afghanistan inquiry reference is one of the flags because the department has learned that those people are at higher risk to themselves or higher risk of anxiety or whatever it may be, as distinct from this is a political issue and therefore it needs attention for reasons of reputational or organisational risk? So it was a decision that was made very shortly after the public knowledge of the issue. It was a decision made by commissions. Commissions set the prioritisation criteria. So the risk was foreshadowed or foreseen rather than it came later because of experience? Yes, that's correct. Let me turn to another example from a little later in the process, I think, and a different veteran. One of the scenarios that we understand can be as follows. A veteran lodges a claim for acceptance of initial liability for an injury and also seeks permanent impairment compensation. The claim is supported by adequate medical and other evidence. After a while, initial liability is accepted, and then after a further while, the PI claim comes before a delegate, and the delegate sees that the medical evidence is sufficient except that more than 6 months or some other threshold have passed, and so the delegate now does not feel he or she can rely on that evidence and now requests a new medical assessment before the PI claim can be determined. Are you aware of that problem? Effectively, delay leading to the evidence becoming stale?
So it depends on what the evidence was to begin with, and
Just asking whether you're aware of the general proposition first. You are aware of it?
yes, it is always up to the delegate to determine whether they feel they have sufficient evidence. That's their role in order to make a determination. In many cases where I have seen that happen, it is because the delegate is wanting to maximise the points available to the individual. So they're seeing if there's been a worsening of the condition over that period.
It's correct, though, accepting that as many but not all cases, it's a case where, because of the department's delay, a claim has become defective, at least in the sense of not as strong as it could be or should be, and the burden now falls on the veteran to fix it by going to another medical appointment. That's a fair, if incomplete, summary of the situation?
Yes, I believe that there were many examples of that, unfortunately, while we had a significant backlog.
There's no legislative reason that you know of that requires the delegate to do that. It's more a matter of judgment of the facts of the case. Is that it?
That's correct.
Has the department implemented any procedures or policies to try and fix this problem, other than just processing quicker?
So processing quicker is obviously going to solve a lot of this problem.
Yes.
We are talking about, I guess, in a sense, a judgment on the part of the delegate. And so we need to be careful to not assume from an individual scenario that the delegate wasn't working in the best interests of the veteran at that time.
At the moment, I'm assuming a systemic more than an individual problem.
Yeah.
I'm not casting aspersions on people's caringness or integrity in this question. But is it the standard procedure for the delegate to speak with the veteran or a representative to explain that the situation is, if you go through the rigmarole of another assessment, you may get more compensation, and give the veteran effectively a choice?
Yes, that is what I would expect to occur.
Is there any monitoring of how often that is occurring?
Not at the moment, no.
It could, for example, be a topic for an internal auditor to come along, sample a number of files and compare number of assessments ordered with number of phone calls that were made to check in the file note.
Or it could be a project for my colleague, Mr. Carrolley.
Of course, we'll assume that every question is answered with it's for Mr. Carrolley to work on, but we'll get some extra detail as well.
Mr. Singleton, you asked about other initiatives. So there's two other things. Firstly, the simplification of the medical forms is also assisting, although, there's a time difference. If we're getting more complete information the first time from the doctor, that certainly assists in requiring the back and forth. The second element is we have a contract with a medical company that does allow delegates to access a specialist if the veteran can't get access to a specialist appointment. So that can also assist in getting the more quick follow-up and in terms of allowing the claim to be progressed.
All right, thank you. Let me turn to another example, Ms. Cole, if I may. In this example, it comes from late 2023 and goes backwards a little bit. The veteran lodged a claim in respect of a serious injury. After nearly 2 years, initial liability was accepted, and after a bit over another year, a bit more than 12 months, it reached a staff member in the DERCA PI team who marked the claim as now open, and the staff member emailed the veteran to ask for confirmation in writing that the veteran wanted to continue with the claim. Is that standard practice if a claim had already been lodged?
I understand your asking me about standard practice. The only scenario where I would believe that would ordinarily happen is if there is a suggestion on the medical or the evidence available to that individual that the condition was not causing any impairment and so therefore was unlikely to be successful.
Would you then expect in that circumstance the delegate would be explaining to the veteran, your claim's not likely to
Yes.
result in any money
Yes.
or other remedy, do you want to drop it?
Yes.
That'd be the essence of do you see that might strike the veteran as an attempt by the department to dissuade them from carrying on with the claim?
That could be, or also it could be correctly telling the delegate what the likely outcome is.
Well, it might be, but they've made a claim and
So, Mr. Singleton, is it any different from saying to a veteran, because permanent impairment is really only about impairment, if you see what I mean, is it any different from saying to a veteran, I'm unlikely to be able to, on the evidence available to me at the moment, to grant your initial liability, or I am unlikely, on the evidence available to me at the moment, to be able to grant your impairment?
if the veteran withdraws the claim, then they definitely don't get any compensation.
That's correct.
And the department has saved the resource of doing the work.
Yep.
But there's nothing in it for the veteran to withdraw, is there?
No, there's not. And many wouldn't, in those circumstances, either way, choose not to withdraw in order to activate their review rights.
I mean, the choice really is contact the veteran and give them a chance to withdraw the claim, even though it does them no benefit whatever, or just process the claim, and if it's rejected, it's rejected. Is there any advantage to the veteran in this system of contacting them and asking them if they really want to carry on?
Or could you see it another way and see it as an opportunity on the part of the veteran to provide more evidence so that their claim could be granted?
Let's distinguish that, because the example was not that at all. There was no suggestion that it was a defective or weak claim that could be improved. The veteran was asked whether they just wanted to withdraw it. And I'm suggesting to you that that's not an appropriate procedure at all in a case of the kind we're talking about.
So, Mr. Singleton, if that's the case, then yes, you would be right. If they were not given advice that there was evidence which would suggest that permanent impairment could not be granted because there was no impairment for that particular condition. If, on the other hand, the person is being provided, the veteran is being provided with natural justice, as I've described, then I do believe that's an appropriate
I suggest
process.
to you that the appropriate options would mainly be contact the veteran and say, your claim is weak but could be strengthened with medical evidence, or don't contact the veteran and just determine the claim.
I would prefer them to do the first.
Yes. And are they trained to do the first and not to just suggest withdraw the claim?
Yes, that is the training that is called the open door policy, and essentially what they're supposed to do is, prior to a determination, contact the veteran and advise them of what the likely outcome is at this stage based on the evidence before the delegate.
In the case that gives rise to these questions, the veteran replied and he or she, I can't be sure, he or she sought an indication of how long the claim was going to take to resolve. And the staff member wrote back, this is an email exchange, wrote back to, quote, acknowledge your concern regarding the delay, but gave no indication at all about how long the matter would take, nor even gave an acknowledgement that question had been asked. Is the failure to answer a question from a veteran in such a circumstance something that the department addresses in its training?
It's certainly something that we try to address. However, we are quite clear that because of the fairly significant differences that can exist between individual claims, it's almost impossible to give a clear indication on that particular claim at that particular time as to how long it would take.
Accepting that truth, or accepting that to be the truth, would not the delegate better be trained to say, if asked, tell the delegate that no estimate can be given because there's no realistic estimate?
And generally, actually, we do. In that scenario, they have some standard words for that purpose.
Does either of your divisions have any mechanism for checking the compliance with the training of the delegates?
So in part, this is why we have our QA process, and the QA process will go through a checklist of what the delegate is trained to do, and those sorts of things would, failures of communication and so forth can be picked up in that process.
I mean, to what extent? What's the chances that the email, from which I have read a little bit, would have been picked up by one of those processes, leading the delegate to be told, actually wasn't a delegate but a staff member, to be told that's not the way to do it, you should have done something else?
So it depends on where that person's up to in their training. So if the person is, for example, undergoing accreditation, and a team leader or a senior delegate, actually primarily a senior delegate, will go through that claim and check that everything was done correctly. If they were post-accreditation, it would only be through the QA process or some other kind of review system. For example, if a complaint came in or a piece of ministerial correspondence, we will go back and look through the entire trail of that claim.
If I might add to that as well, the QA process that we undertake is undertaken through a sampling method. So it would be possible that that individual issue would have come up through sampling a range of documents and then identified, but I couldn't confirm that because the sampling method that we use, which is audited by the ANAO, is a sampling method, and it's not a whole of population survey of everything that has gone on.
All right, I want to just compress a couple of scenarios where the basic fact was that the veteran had been granted certain approvals to receive certain services for a time, and the time had not elapsed. But then the delegate was told, sorry, your time has elapsed and you're going to have to pay for it yourself and you can try and get reimbursement. And it was just wrong. Do the systems that support the staff adequately keep them informed? I mean, would the staff member have had ready access to the fact that the service had not expired?
I suspect you're not actually talking about claims processing in this example.
No, I don't think I am. So it might even be Mr. Pullen's area, and if it's no one, just say so. So we're talking, I'll tell you the two. One is the car service, booked car with driver service, and there's another one for getting a meal. Mr. Pullen, are you able to throw any light on whether the staff, if they've got maybe the computer screen, actually has that information displayed, or do they have to go looking for it, or do they have access at all?
So staff do have training and they would have access to the systems. The systems are very basic though. For example, on book car with driver and other transport related services, a lot of those processes are using basic spreadsheets and so forth because of our ICT is very limited. We also do have an internal review process as well for approvals. So if the client was unfortunately given the correct information, there is that escalation point to then make sure that it is corrected. If the
client knows it's a mistake and challenges it, if the client just believes the wrong information, he or she might not take the service to which he or she is entitled, correct?
That can happen from time to time, absolutely. But we are working on always improving that through our training and through the systems.
In one of the scenarios that I've just conflated, the veteran was known to the department to have experienced great frustrations with DVA processes and administration to the point of suicidal ideation. Does a staff member who's going to make a phone call or receives a phone call have immediate access to a warning that this veteran that you're dealing with needs sensitive treatment or whatever the appropriate warning might be?
Depends on the client. So if the client is in that situation, it's most likely that they're being case managed and most likely complex case managed through the branch that sits within my division. So they would have a specific case manager that they would be calling, which would be across their circumstances and would be able to provide the right connections. There is certainly the expectation, though, that if they come into another entry point, such as through the VAN network, which my colleague Mr. Karen looks after, or another part of the business, if they're exhibiting clear suicidal ideation, firstly, if it's an emergency, to contact emergency services, but also then to refer it back to my team for the sort of quick escalation, and we have a same-day escalation point for the sort of the higher risk activity and events.
I think you drifted a little bit away from the question, which is about the information available. So let's take the case of the person who isn't the case manager, has received a call, is taking the call, knows who it is because the veteran identifies her or himself, says, I'm so-and-so, and this is my situation. Can the staff member immediately access a system that will warn the staff member of a need for any caution that might happen to be required?
So I don't know all the detail, but I do know that our systems are very limited in terms of we've got a number of different systems that a number of different staff have access to. Part of the reason for that is for privacy reasons. Another part of the reason is just the limitation of our systems.
All right. Ms. Cole, I'll come back to you for one more example, and then you get a much easier time in the second half and your colleagues get to enjoy some questions. We'll take a break in a few minutes, but this relates to a veteran who happens to be a medical practitioner giving some advantage. Mm-hmm. Some decades ago, according to the DVA's own records, this veteran had a VEA claim for a torn medial meniscus left knee, and it was rejected. But the next year, liability was accepted for injury left knee under the system which is now covered by DIRCA. A couple of months ago, the veteran needed surgery on the left knee to effect a meniscal repair, made a claim to the DVA to cover the cost, which was initially rejected. Now, ultimately it was overturned and it was sorted out, but not until after the surgery. Would it not be a logical approach for the delegate or person who, and this might be your area, Mr. Pullen, so maybe you're up.
It is my area, Mr. Simpson.
I'll take an answer from anywhere, but would not the logical approach be to rely on the later acceptance of the condition a left knee injury, which may well have degenerated into a condition needing this surgery, rather than rely on the earlier rejection of the meniscal tear claim?
Mr. Simmons, so I understand the particular case also related to a much earlier decision on an accepted condition where the terminology has changed, so that caused confusion and resulted initially in the incorrect decision, but then the correct decision was made on internal review once further medical advice was sought from our Chief Health Officer Division.
Well, what was the terminological confusion that led to this original decision later overturned?
So I understand that the term that was related to the initial decision was a term that was used many years ago, I can't remember the exact year, but sort of more than a decade ago.
We're talking decades ago.
Decades ago, that's correct. And the terminology has since changed. So the medical advice was confused by that initial condition based on the change in terminology.
I mean, injury left knee is not a very technical term. It's not that hard, is it?
I understand I'm not a health practitioner, Mr. Singleton, but there are a lot of complexities around our legislation. And certainly one of the things that's been brought to light is that and we're seeking to stretch this as much as possible within our current legislative ability to provide that sort of benefit to the veteran and taking that broader wellbeing perspective. But there are limitations in our legislation around connected and related injuries where we can't go beyond a certain boundary. So that's a limitation of our legislation. And there's a number of, obviously, things associated with the knee, which may or may not be caused by that initial condition.
Do you classify the original decision as a mistake caused by confusing terminology, or a valid decision, but one where someone legitimately took a different opinion later on?
Having looked at the example, Mr. Singleton,
yes, I think you know the one.
Again, I'm not a medical expert, but I would characterise it. It was an error made, and the system worked in terms of the internal review process, and it was corrected.
Well, did the system really work? This is a person who contacted the minister. Would this error have been corrected if the veteran had just been told, I'm sorry, the medical expert tells the delegate, and the delegate believes that you're not covered because it's just not the right condition? If that would have been the end of it for many veterans, wouldn't it?
I think there would be a whole spectrum of potential scenarios or hypotheticals. What I do know is what happened in that particular circumstance, but in other circumstances, for example, the client may contact DVA again instead of the minister, and that does occur, and then we would also review it through that internal review team.
You would accept, would you not, that the ultimately successful outcome for this veteran was in large measure the result of two factors in combination? One, he was a doctor himself and knew or believed there was a mistake. And secondly, he had the wherewithal to contact the minister, leading to two more doctors looking at it and a number of staff.
Mr. Singleton, I accept that was a factor, absolutely, but I would also say that it's not the only scenario. There are a number of other scenarios which I alluded to earlier where it would result in that review and the correction of the decision.
And a number of scenarios where the poor veteran just would have received a wrong decision and there would be no further review.
Yes, I accept that too, and that's certainly something we're looking to improve.
All right. If that's a convenient time, this is the scheduled break time.
Thank you, Mr. Singleton. We'll leave for lunch for an hour.
Thank you.
All rise. The Royal Commission into Defence and Veteran Suicide is now adjourned until 2 p.m. The Royal Commission into Defence and Veteran Suicide is now in session. Please be seated.
Thank you, Mr. Singleton.
Thank you, Commissioners. Panellists, one loose end from the morning session. Ms Cole, you told us that a lot of the claims received are not ready, they have evidence gaps and so on. It's a question to whomever wants to address it, but does this not indicate that there is some kind of a problem at the entry level? The system's not easy to use, or the information is not there. Something wrong is indicated, is it not?
I think it's actually a combination of factors. I think there are actually incentives in our legislation to actually apply before you have the medical evidence, because of the way the legislation allows us to pay for a medical report post a claim, but not prior to a claim, unless that claim is actually subsequently accepted. So that is one problem. I think that particularly for many people, it's a very complex system, and while we try to give as much information up front as possible and have put a lot of prompts on our website and in my service, they still don't quite understand the importance of a clear diagnosis in the claims process, as opposed to them identifying that they have an injury or an illness. So we see a lot of claims where a general injury or illness is identified, but not a specific diagnosis, which is what we actually need for the purposes of determining the claim. So those factors do make it quite difficult for a veteran, and that in part is the reason why we put a lot of resources into that assistance stage, that claim support officer, in recognition of that, rather than putting the onus back on the veteran.
Mr Carrolley, have you or your team done a study to try and work out what are the major problems leading to this issue?
So we are doing a number of pieces of work at the moment to try and make sure that the medical information that we receive is most fulsome. We have a medical forms review project underway that is looking to simplify the medical forms that are provided along with the reports. We're also undertaking a number of other assistance measures to look at how to best streamline the medical forms that are provided, provide them in a different format. Overall, over time, we would like to see these move from paper-based forms into something that links more comprehensively back with our IT systems, so they can all be automatically provided. But we do see that as being quite a fundamental factor in the delay.
You've mentioned some solutions that are underway, but has there been a study that attempts to analyse the whole picture? And I'll just give you an example just to illustrate the question. It may not be a good example, but go and talk to all the delegates and try and find the patterns where the gaps are, and then compare it with the way my service works, draw a conclusion that an amendment to my service is required here. But it's something that gives you the proportions.
Yeah, that's certainly something that we're working on at the moment. In October last year, we made some significant changes to my service, which allows us to better understand whether where the claim is sitting in the system. So is it sitting with DBA? Is it sitting with an external medical provider, or is it sitting with Defence? Now, the data is still very, very early, so we've only got 1 or 2 months worth of data, but what we can say from that data is around a considerable amount of time is spent waiting for medical evidence.
Yes, but that comes after the claim is lodged. We've just at the moment focused on the difficulty in getting the claim lodged with all relevant evidence. Has that issue been analysed in a holistic way to find out what the big causes of inadequate claim lodging are?
Not holistically, but as mentioned, as part of some of the reform works that we're undertaking, we identified that the medical forms that needed to be filled in by medical providers were far too complex. We're undertaking a review at the moment. We've stripped around 70 forms out of about 200 forms that are available, moved them into from 70 to 30 forms, so it makes it easy for the medical providers to actually provide those forms. One of the key things I think we found is that the medical providers who are providing this information, it's quite complex and time-consuming for them to produce these forms, making it simpler for them to write in and have that information available. We think is a major step forward.
Is there an incentive program for GPs and other practitioners to get training, to learn the forms, to do them right?
I'm not aware there is. Maybe one of my colleagues might have some more information, or we can certainly get that for you.
I can add to that. I do believe there is information available on our website and other webinars and so forth that the Chief Health Officer Division makes available to GPs that provide them assistance around some of these things.
Training courses, can a GP say, I'd like training in filling out DVA forms and I want to know about the SOPs and so on? Ms Nolan, you might have an answer because you're
might
not
be able to assist there. So we do run workshops for GPs. We're in the process of organising an online training program. This is through the Chief Health Officer Division. We also have veteran pathways through the PHNs to give information to GPs about how they can actually support veterans, their veteran patients in accessing health services, what entitlements are available through DVA and so forth.
And are there incentives to encourage medical practitioners to actually participate in the training, or is it really they're volunteering their time?
They're volunteering their time at this point.
Come back to you, Ms Cole. How often do delegates rely on the results of a separation medical exam conducted by the ADF of a transitioning member?
So I could not give you a number or a percentage, but delegates are always encouraged to look as closely as possible at the defence record as a whole to see whether there are diagnoses there first.
Would it be useful from a DVA perspective if the separation medical examination was, I'll speak a bit crudely, but beefed up, done by medical and other staff who have a bit of training in the SOPs and other DVA processes, and among other purposes, the SME would lead to a report designed for your purposes, and you'd get it and you'd have all the injuries, all of the impairments that come from those injuries and so on. Would that be a helpful thing to receive?
It would be, and the other thing we have discussed with the Department of Defence is whether in their new system they're able to put a flag in the record as the record is developed, if you see what I mean. So if a individual, had an injury at some point and it would likely be DVA compensable in the future, that is flagged just to simplify some of the processes.
And when you say their new system, are you referring to a particular IT system?
At the moment, the defence, as I understand it, and please don't. Yes.
We'll check, but
it,
give us
yes.
your best understanding.
As I understand it, they are currently coming close to finishing their new health record system for defence members as a whole.
Have you been consulted on the design of that system?
Not me personally, but my area has been involved on and off in the design process around elements which may be relevant to DVA.
Do you anticipate that the new system will, among other objectives, have the objective of capturing, storing and organising data in a way that will be very useful when you get it?
I really couldn't say at the moment, not being close enough to the process.
It would, from your point of view, be quite desirable if defence medical records and other service records and so on were organised in a way or coded in a way that was readily analysable by DVA systems.
Or by people, DVA people, yes.
People using people and systems together.
Yeah.
Has the DVA urged defence to factor
I
that into
believe
their
so,
design?
but I could not confirm exactly what the interactions have been, not being personally involved in them.
But the people doing it are in your area, is that right?
Some of them are, yes, but also our IT team and similar other personnel.
All right. Ms Nolan, could I turn to you? Could you briefly introduce us to the outreach program counselling?
Thank you, Mr. Singleton. In Open Arms, we have both in-centre counsellors and our outreach program counsellors who comprise approximately 80% of our capacity. So approximately 80% of the work that we do is actually delivered by our outreach program counsellors, who are people who are largely in private practice to whom we refer.
How long has the program been going?
I think for over 20 years. I can't give you an exact date, but Open Arms has always substantiated its in-centre capacity with a referral process to people in private practice.
It's the case, is it not, that OPC providers have until now been engaged pursuant to a statutory registration process?
Correct.
Is that a process also authorised by a statute?
No.
Is there a statute involved?
No.
Do you know why it's called a statutory registration process?
I think it was used metaphorically to describe a process of engagement which was attempting to mirror the process by which practitioners are engaged through the Better Outcomes strategy through Medicare, but it was a truncated version of that.
And the process was one that was endorsed by the Repatriation Commission and the Minister at the time about 10 years ago, or 12 years ago?
I'm not aware of that.
All right. Approximately how many OPC providers are there at the moment?
1,200.
And approximately how many veterans receive counselling through that arrangement?
Last year we had 40,000 clients. 80% of those would have received support through our OPCs, roughly speaking.
It's correct, isn't it, that a decision has now been taken to change the procurement process such that in future OPC providers will be engaged only if they tender for the role and are accepted onto a new panel?
Correct.
And that was decided in brief because the department understood that this old process did not comply with Commonwealth procurement rules?
Yes.
I'll just ask the operator to bring up a document. It's DVA quadruple 9 0135 0001. I think this will be a departmental response to one of our notices requiring information. And you can see the first page there. I'll ask the operator to go to page 0003 and expand 5.1, which has some dot points in it. We'll get to it in a moment. They were quicker than I thought. In your view, in the present context, is the paramount consideration from your perspective continuity of care for your clients?
That is a consideration, yes.
Do you consider it the paramount care consideration?
Continuity of care and quality of care, yes.
Do you accept that there are risks associated with the change in procurement arrangement?
Yes.
One of them is that current clients might be impacted if a current provider is not appointed to the new panel.
That is correct.
And indeed, some providers may not even tender.
Correct.
Among other things, the tender process will require a lot of paperwork to be filled out by providers. Do you agree?
May I provide some context?
Yes.
We have attempted to make it as streamlined as possible. We've run several industry briefing sessions both during the day and after hours, including a session specifically devoted to assisting potential tenderers to understand what information is required and how to fill in the forms.
Right, so that's a yes, and you've done something about
Correct, to mitigate that risk.
Much of the information that these forms seek is very similar to the information that had to be given through the so-called statutory registration process, correct?
With some significant additions.
Many of the counsellors would have no experience of Commonwealth tendering processes, correct?
That is true.
If we just look at the screen as a reminder, if need be, let me just ask this question. one way to make it easier, and you've mentioned a number of methods to at least facilitate meeting the burden, would be that there be a separate form or set of forms for existing providers, so that they, question one, are you already a provider? Do you let us use the information previously given? And then you just ask for the information you don't have. Is that one of the methods you've used?
No, it's not. We've been subject to quite strict advice in terms of compliance with the Commonwealth procurement rules, and we've abided by those.
All right. Well, if we look at the screen now, you can see that among the procurement rules that the department concluded it was not meeting are these three. We don't know what other ones are, but presumably these are among the more significant rules.
Yes.
Would that be a fair comment? Thank you. Rule 4.16, that's the second one here for convenience. It says this: when a contract does not specify an end date, it must allow for periodic review and subsequent termination of the contract by the relevant entity, that's the department, if the relevant entity determines that it does not continue to represent value for money. Now, presumably the department viewed the statutory registration arrangements as contracts without an end date and which also could not be terminated. Otherwise this rule wouldn't apply at all. Is that correct?
Under the previous arrangement, statutory registration, technically there was no contract.
So if there's no contract at all, Rule 4.6 doesn't apply at all, does it?
It depends upon how, and this is a legal matter and I'm not trained to really respond to that, but I can say that from a referral process, when we refer a client to somebody, to one of our OPCs, that could be deemed a contract, but in terms of the broader contractual engagement, it wasn't deemed to, the statutory registration process was not deemed to be sufficient.
Well, I appreciate you're not a lawyer and I will keep that respected. But as the officer with carriage of this significant development, you would have made a conscientious effort to understand the issue, including the legal issues, correct?
Yes.
But the rule applies only where there's a contract that has no termination date and can't be terminated. Your understanding is there wasn't a contract, but even if there's a technical reason why it should be considered a contract, the department did terminate the arrangement, didn't it? It's terminated all of them effective from June 30.
The reason I'm hesitating is because ostensibly the statutory registration process was initiated by the OPC and the department would then accept that on the basis of providing referrals to the OPC on individual clients.
Just what I'm suggesting to you is you weren't in breach of Rule 416 and invocation of that rule was no reason to change the system.
I'm sorry, and I'd have to take advice on that.
Is that the analysis I've given, no contract, it was terminatable because you did terminate it and therefore the rule doesn't apply. Is that an analysis to which you've turned your mind before today?
Yes, in that we were advised that what we had in place under statutory registration was not in fact a contract. So even though Rule 4.16 stipulates that there should be an end date to the contract, under the previous statutory registration process, one view is that there was no contract, so that we did not have a contractual mechanism in place, but the other view is that even if it was a contract, there were no end dates.
So, but you terminated it anyway. And you have terminated them effective from 30th of June.
Yeah, I think it depends
understand
upon...
the point being made here is that the rule was not in breach, either because it's not a contract or because it was the arrangement could be terminated. I appreciate you say you have advice that the arrangement didn't comply with the rules, but do you, specific to this rule, have you previously turned your mind to the possibility that this rule did not apply at all?
I'm thinking about that now. We have looked at other ways of engaging with our OPCs in order to be compliant with the Commonwealth procurement rules, and the advice that we've received is the one that we've acted on.
All right. The next rule mentioned is 7.18 or 18, and the rule is relevant entities must report contracts and amendments on AusTender within 42 days of entering into or amending a contract if they are valued at or above the reporting threshold. I assume these were above the threshold. A solution to that non-compliance would be to report them to AusTender.
Witness, could you please speak up when you answer? It has to be recorded, and a mere nod can't be recorded. Thank you.
Thank you.
A solution to that problem with Rule 7.18 would be register them with AusTender as quickly as possible. Was that a solution that the department considered?
I understand that was something that was looked at, but again, in order to be fully compliant with the Commonwealth procurement rules, we took advice on how we would achieve that, and we then enacted that process.
Did you make the decision not to attempt the solution of registering with AusTender, albeit out of time?
I took advice on that from people who are more experienced in that matter and accepted that advice.
All right. Is that a yes? You took the decision?
Yes, I took that advice.
And did you specifically turn your mind to the possibility of lodging or reporting these contracts or arrangements to AusTender?
My understanding is that that still would not have been sufficient to make us compliant with the Commonwealth
not an
procurement
answer
rules.
to the question. I understand the basic position you have, and you can correct me now if I'm wrong, but you say, I was told the arrangement did not comply with the rules and there had to be changes. I'm now going to the specifics.
Yes.
Your answer might well be, I never turned my mind to each of these individual points. I just acted on the advice holus bolus. Is that your position? Or did you turn your mind to the specifics?
If I may provide some context, we did look at what other ways may be available to us to avoid going through the process of establishing a panel, and the advice that we received was that the approach that we took was the safest approach, and so I did not consider specifically each of the 3 points that you've raised, but I did consider the advice as a whole and undertook and supported that process.
Now, the safest approach to which you've just referred is the legally safest approach, correct?
Yes.
It's not the safest approach for the clients of the DVA.
There are risks associated with that, yes.
Yes. Noting that the DVA, look, the last rule here, the first top point, procurement connected policies, I won't read the whole rule, but the thrust of it is this, that the department had to, quote, comply with a procurement connected policy where the policy indicates that it is applicable to the procurement process. See the list on the Department of Finance website. In other words, this is a catch-all rule that picks up all of the Department of Finance's policies. Was consideration given to going to the Department of Finance, explaining the risk to veterans and asking them to change the policy, that whichever one it was, or getting an exemption from it?
There have been approaches made to the Department of Finance and we have acted on advice received.
Well, did the department approach the Department of Finance with a request for all necessary exemptions to enable the outgoing scheme to continue?
Not specifically, no, not to my awareness.
Noting that the DVA has given an assurance that the breach of the rules did not involve fraud and did not compromise the quality of the program, I withdraw that because I've just asked the rest of the question already. I'll ask the operator to bring up another document. It's DVA 5072 0001 0314. While that's coming up, there was no consultation process with the OPC sector, with councillors or representatives of councillors before the new system was announced, was there?
We were operating on advice from our procurement specialists.
Could I ask you to approach it this way?
So no, there wasn't.
Yes, if I could ask you to answer the question first and then give the explanation. And so what happened, this is the first page on screen of a letter that you sent to all providers dated the 27th of November last year, correct?
Yes.
For most, if not all of them, this is the first they would have heard that their current registrations were to be cancelled and they would have to tender.
Correct.
This letter, I'm sorry, the arrangement, the decision that's been taken means that the current registrations will end on 30th of June this year, correct?
Correct.
But the new panel pursuant to the tender process will be established from April this year.
Correct.
And all clients will be hopefully for many clients, they'll have the same person and there'll be continuity of care. And the only problem was the poor old counsellor had to go through some bureaucracy. No, for our purposes, no big deal. That's true, isn't it?
Correct.
But for some, they're going to have to be moved to another counsellor.
Yes, that's correct.
Is it the case that there's going to be some assessment made of whether it's a high-risk situation requiring added care or relatively low risk with a straight handover?
Correct.
And if there's a high-risk client, then there'll be a transition service arrangement that will allow the existing provider to continue until June 30.
Correct.
But if that's not assessed to be the situation, it'll be a transfer in April as soon as the new panel is set up.
That's right.
And before there can be the extended handover over 2 or 3 months, it'll have to be approved in writing.
The handover?
If a current counsellor is to continue until June,
yes,
rather than until April, that has to be approved in writing by the department, correct?
I'm sorry, could you say the question again? I didn't quite understand.
Most people are going to be if they have to have a new counsellor, most of them will get their new counsellor in April, correct?
If that's possible, yes.
And they will only stay with their current counsellor where there is a client risk associated with transition to a new clinician, correct?
I'm sorry, I'm still not quite understanding. May I?
Well, no, it's my fault if you're not understanding.
Yeah.
There's a procurement plan, a document which we can, excuse me, Commissioner, we can show you if need be, but it's quite a lengthy document, but it makes the point that people must be transferred to the new counsellor in April, with one exception, and it's this. And if the exception applies, then they can stay with their current counsellor for a bit longer. That's correct.
If the counsellor has not been successful or has elected not to participate in the tender process, then we are working through that evaluation process to establish the panel. And if there are clients whose counsellor is no longer going to be able to provide services under contract to Open Arms, then we would seek to either have that episode of care completed before 30th of June, or if the client wishes to continue with their counselling, to make other arrangements, either through transfer to an in-centre clinician or to another OPC.
I'll just ask the operator to bring up a different document, if I may. DVA 5072 0001 0086. Are there going to be assessments of which clients may be at risk and need extra support?
Indeed.
Who's going to do that?
The in-centre clinicians. So we do that in conjunction with the OPC. So may I provide some
You can tell us what an in-centre clinician is, that would be handy.
People who are directly employed by Open Arms.
All right, so they're going to do this assessment. Is there a role for the existing clinician in that process?
Correct, that is in conjunction with the OPC, and may I provide some further information? The OPCs are required to give us information on a regular basis about the level of risk of the client that they're supporting, as well as any other factors that we might need to consider in relation to referrals to other services as well, given that we're not a specialist service in other areas such as family and domestic violence. So we do have regular interactions with our OPCs around risk factors, levels of risk, and other sources of support that might be available for the client as part of an integrated care model.
Now, the fact that there will be an assessment of who's at risk and who's not, there's a handover, and that existing clinicians will either end their, thank you, operator, will end their arrangement in April, but can continue until June if the client is at risk. That's a significant detail, is it not?
Yes, but that it's dependent upon whether the client wishes to do that or wishes to transfer sooner, and whether the OPC is prepared to continue seeing the client until the 30th of June.
So the fact that the client has a choice in the matter is also a significant matter?
Yes.
Aren't those matters that should have been included in your letter that was on the screen a moment ago?
That information has been provided in some of the industry briefing sessions in terms of what the handover process would look like. It wasn't included in the first letter that you showed, but it had been conveyed in subsequent briefings to my awareness.
And are these briefings like seminars or webinars or?
Webinars.
And do all OPC counsellors attend them?
It's not compulsory. We ran them at, 2 of them were in the evening, and I think one was during the day, and we also recorded them.
Do you have any record of how many of them have attended?
We do. I can't tell you off the top of my head, but we can certainly provide that information.
Have you written to all of them to give them the information in writing? This important information about the transition arrangements for at-risk people.
To my awareness, that had been covered off, but I'd have to take that on notice.
All right. I might just come to adverse events analysis. I think, Mr. Pullen, you've got jurisdiction over that at the moment as the First Assistant Secretary responsible, is that right?
That's right in the terms of the departmental-wide adverse events analysis. Separately, there is a process that Open Arms undertakes. So just to clarify and distinguish between the two.
So there are two processes with the same name and similar processes but for different divisions.
Ours is an enterprise-wide approach, and Open Arms has a specific approach, which sometimes is referred to as adverse events. So just to avoid any confusion.
All right. Are they Ms. Nolan, two different things with very similar names?
The process within Open Arms is called a clinical incident review, because it's very much about the clinical intervention and whether or not there were any risks associated that we could have rectified. So it's a clinical incident review rather than adverse events analysis.
All right. So if we concentrate on that distinction and then on adverse events analysis. Firstly, Ms. Nolan, you used to oversee the AEA stuff.
Yes, I did a couple of years ago.
And now Mr. Pullen oversees it. Was the precursor of this work, maybe it's a prototype, I don't know what language you've been using, but called deep dives?
Yes, that it could be considered that the deep dives were a precursor to the development of an adverse events analysis capability.
And were two deep dives undertaken in 2019 as a proof of concept?
Yes, that's correct. May I add, there were also other deep dives conducted in 2018, which also informed what an adverse events analysis process might look like.
Right. Were the 2019 ones completed in 2019 or did they take longer?
They were very much in draft form because we were, may I provide some context? Basing this on a root cause analysis methodology that's used in the health sector and aviation sectors. And part of the proof of concept was to identify whether or not we could actually discern a root cause in relation to veteran suicide by the variables which are under the aegis of control for the Department of Veterans Affairs.
Was funding to establish an adverse events analysis program obtained during the budget process for the budget of 2021 to 22?
That's correct.
When we touched on this issue in March 2022, one of the unresolved issues was DVA's ability to get access to relevant information held by Defence. What's the status of that issue today, Mr. Pullen?
So in terms of adverse event analysis, the activity that we undertake is undertaken based on information held within the department. There are privacy-related issues in terms of consulting external to the department, including with Defence on particular case matters. But I don't think that inhibits the purpose of the AEA. The purpose of the AEA is to look at continuous improvement of processes within the department. The purpose of the AEA is not to establish any causation around the death, which is undertaken through separate processes, particularly coronial processes at the state and territory level.
If you are attempting to learn lessons for the department's processes from a tragic incident, surely understanding the nature and contributing factors for the incident is relevant.
It is certainly relevant to have access to the broader context, and I anticipate going forward as part of undertaking more comprehensive AEAs, because there are several layers of AEAs depending on the complexity associated with the event and the department's interaction, when we're undertaking those more detailed reviews, I imagine we would turn our mind to other information available outside the department, which may include coronial and other processes, which would take that sort of broader approach in terms of information we'd have access to. But your point around information from Defence, at the moment we did seek legal advice, and I understand there are privacy limitations around the information that we can access.
The problem remains and the problem hasn't been solved. That's correct, isn't it?
I would say that there are some limitations, but I would say that in terms of the adverse event analysis, it is not a major problem in terms of undertaking adverse event analysis to inform improvement to departmental processes, because the purpose of the AEA is to look at what DVA has done and how DVA can learn and improve our systems.
So 2 years ago, another issue was and attempts were being made to address the issue, was settling arrangements with the IGADF to align the work of that agency with your agency. Have such arrangements yet been settled?
Not specifically with IGADF.
That'll do. We've got a lot to get through, but that's what we needed. Has the DVA settled a policy on the circumstances that will or may lead to an AEA being conducted at all?
So we have completed several AEAs already. The department has completed.
I asked about the policy on when they'll be done, not whether they've been done. Have you finished a policy on when and when not they will be done?
So recently, the department has agreed to establish a suicide prevention committee and a suicide expert advisory group.
I've asked you a yes or no question. Have you settled the policy on when they will be done?
No, we haven't settled a policy on how quickly they need to be completed.
We may get to last Thursday's developments in a moment, but is there a particular team or unit within the department that is charged with doing the AEAs?
Yes.
What's the name of the team?
So the team sits within, I can't recall the exact name of the team, but the team sits within our mental health branch.
How many staff members assigned to the team that does the AEAs?
The team is currently a team of 4 people.
Is it, does that include the leader of the team?
Yes.
And are there any pertinent qualifications or experience that these people have for this work?
So yes, these people do have a background in undertaking analytical work. The team leader, I understand, also has a clinical and sort of other background in having worked in the mental health space previously. But essentially, because the real benefit of the AEA is looking and understanding how the department can improve its processes and interactions with veterans. The really important skill are sort of those broader analytical skills.
Does the team exclusively do AEA work? I know there are different levels, but exclusively that, or does it have other responsibilities as well?
The team undertakes a range of work around both the AEA governance arrangements as well as undertaking AEAs themselves.
But nothing else. There are no other.
There might be a couple other small functions, but that's the predominant part of its work.
It's just an attempt, an overview of the work. They do preliminary assessments.
Yes.
Would that be, you referred to different levels, is that one of the levels?
Yes, that's the most basic level of review.
Is that essentially a desktop review?
That is a desktop review.
How does the team get the matters to be reviewed? Are they allocated to them by a branch manager or yourself, or do they try and keep themselves abreast of developments and proactively go and find matters to analyse?
Well, the assessments are undertaken when there's been an adverse event, so where a suicide has occurred, and then they would undertake that first stage, which is a preliminary assessment, where the department has been advised of a suicide or suspected suicide, because, as you'd probably be aware, there is a lag between an event occurring and it actually being confirmed as a suicide by the Institute of Health and Welfare and other coronial processes.
To be blunt about it, an adverse event is, in the present context, is a suicide.
Yes.
Is a purpose of doing a preliminary assessment to decide whether or not to do a deeper analysis?
Yes and no. So that first stage still can provide learnings, but they're not at the enterprise level. They would be more localised learnings relevant to particular divisions or improvements. If the preliminary analysis identifies some broader systemic issues or likely systemic issues, that's when it would then get referred to then undertake recommend undertake a comprehensive assessment, which would look at those much broader issues and more deeply and sort of more complex matters.
Is comprehensive analysis the next level up?
That's right. That's the second level.
As of a recent notice that we served, it was NTG DVA 135. The department told us that 13 preliminary assessments have been done so far. Have any more been done in recent times?
13 preliminary assessments have been completed. There's approximately 24 that are currently underway, so more than 20 underway at the moment.
Now, one could say that's 13 since 2021 or 2022, but more realistically, when did the work of doing preliminary assessments begin?
So it's not since 21-22 because, as Mr. Nolan was referring to, the department was still working through what the appropriate process would be, and we were undertaking what was called deep dives at that stage. Now that we've learnt from doing and established those foundations of our process, these preliminary assessments have largely been undertaken since August of last year.
So the fairer way to express it is 13 in the last 6 or 7 months, since August.
Yes.
Now, turning to the comprehensive analyses, what sources of information beyond DVA records do the staff have access to?
It is largely DVA records, as I understand it, but they may also look at publicly available information as well. But the purpose is not to specifically reach outside the organisation other than publicly available material because of the privacy-related matters that I referred to.
At this level, are staff members interviewed?
I'm not sure. Possibly. It would also need to be conducted carefully, but it would be more than just a comprehensive analysis, would be more than just a desktop review.
If no one was being interviewed, it's just a matter of reading records, including public sources. It would be close to a desktop review, wouldn't it?
Close to desktop review, but a much more intensive desktop review because it would involve considerably more time, senior resources looking at it, signing off on the comprehensive assessment.
As of the statutory notice response I mentioned a moment ago, I'll say it one more time for those who are interested, NTG DVA 135. 28 matters had been identified for comprehensive analysis. Have any more been identified in recent times?
Not that I'm aware of.
In respect of how many of those matters has the analysis begun?
So two comprehensive assessments have been completed and another 3 are underway at this stage.
Is the standard approach as follows, that once the comprehensive analysis has been done, the next level up is a review?
That's correct.
Does that happen only if the report of the analysis recommends it, or does it always happen?
That's the third stage, so it would happen if the comprehensive analysis recommends it. That's right. Though I would say, and we haven't had this position yet, I would say that, and we have recently employed a very experienced person to help us in setting up the governance arrangements. So the review component is still being settled in consultation with them because we haven't undertaken any reviews yet. But there is a possibility if there was a very serious, not that any suicide is not serious, but if it came to our attention very early on that something needed a review, I don't think we would wait to sort of do a preliminary assessment, go through a comprehensive assessment, do a review. I think there might be some circumstances where we would reach the conclusion that we should go straight to the review process, but those final governance arrangements have not been settled.
Just to summarise some of the points made, although funding was given in the 21-22 budget, first preliminary work, the desktop reviews didn't start till August last year. We've only got 2 comprehensive analyses done so far. None have made it to review. And the policies and procedures are not fully in place yet. What have been the barriers to getting this system fully established and running?
I think I would describe it more, so obviously there were legislative sort of privacy related aspects that are referred to that we need to understand what we could and couldn't do. But I would also describe it as a learning by doing process where we needed to work through what was the appropriate framework to use, which is, as Ms Nolan mentioned, we moved away from a root cause approach to a restorative just culture approach because that was determined to be more useful and effective in terms of identifying the things that DVA could improve to assist, and that has taken a period of time. I mean, the alternative could have been that we raced off and did 100 preliminary assessments using a framework that was maybe much less effective and that didn't then lead to supporting better processes and outcomes. I do acknowledge it's taken longer than most people would like, but I think it's also important to get the foundations and the framework right before then we scale up our approach.
My question was, what were the barriers? It did take a long time. I appreciate people want to get it right. This took a long time. I mean, work didn't begin till August last year. What were the barriers to getting it done more quickly?
I think the privacy related and understanding the legislative requirements.
Have they been resolved? Has the legislation been amended?
The legislation's not been amended, but we now have an better understanding what our constraints are to work out how we would then undertake.
You're up and running now, would you agree, to some degree?
Yes.
You weren't up and running a year ago. You weren't up and running last July, in practical terms, were you?
We were undertaking, as I understand it, I wasn't in the role at that time, we were undertaking some deep dives. So we were undertaking some work, but it was still very much learning from experience. We have now settled the foundations and are up and running.
Privacy legislation may well provide a limit on the information to which you have access, but it was not an impediment to setting up the team, setting up the policies and so on. And I'd suggest to you that it's just not a real explanation of why it's taken so long to be functional. Do you agree?
Well, I think I just refer back to my earlier response in terms of why it's taken a period of time to to learn how to set that up.
Ms Nolden, do you want to add anything to the discussion? You had some insights from earlier years, perhaps?
I can certainly comment on what we do in Open Arms, if that is of any assistance.
Only for time, it probably would be, but I'll just confine myself to the AEAs for the time being, and I thank you for the offer. Mr Pullen, do you consider that the team of 4 has the resources that it needs?
So we are currently resourcing the team. We think it could be a larger team, and we're building and recruiting for that. Though before we've scaled it, we've wanted to make sure we've got the foundations right in terms of the approach. Now that we've settled the approach, we are scaling through recruiting. The program was funded. Funding ceased 30 June last year, but we continue to support the function because it's an important function.
Is it the case that last Thursday DVA approved a significant part of the governance arrangements for the AEA program?
That's correct.
Why couldn't even this basic administrative achievement not have been achieved earlier than last week?
I think it reflects that we are undertaking a number of reforms and changes across the department. AEA is important, but there are also a number of important improvements that we're making that directly impact veterans, including the work in the claims area. So I would like this work to have progressed faster, along with a number of areas to have progressed faster, but that's where we landed.
Was a factor in the timing the fact that this Royal Commission was resuming hearings this week?
It was on the agenda already for Executive Management Board, and we were settling some of the governance arrangements as part of that.
I take it that's a yes, because we were on the agenda for a long time as well. The fact that we were resuming this week was a factor in getting it over the line last week, correct?
I think there were a number of factors.
Among other factors, but this was one of them.
The Royal Commission obviously has an important role, absolutely. So in turning our minds to our commitments and to the Royal Commission, obviously, that I'm sure that assisted.
Is consideration now being given to expanding the program to cover attempted suicides?
I think it's something that we would continue to consider, but at this stage, our adverse event analysis is focused on suicide only to prioritise that effort.
All right, thank you for that. I'm now going to turn to the major topic of engagements. Thank you for your patience, in particular, Ms McLaren. I'll ask the operator just to bring up the org chart again, which is DVS 0012 0001 0635. The DVA appears to engage with veterans in many different ways, in many different contexts. Just moving from left to right on this chart, just as a prompt, we can see on the left the client benefits group, which has teams that engage with veterans in respect of claims for entitlements, among other things. That's one form of engagement. Does the client benefits group engage with veterans in other contexts outside claims benefits? Does anyone know?
That's a bit outside my remit. I think their primary focus with veterans would be within that claims process space.
Ms Cole, do your teams deal with veterans on non-claims processing issues?
Where a veteran has a query around, say, a health approval issue or something like that, they may go to their delegate at the time and ask those questions, and usually there's a referral process in that scenario.
And that would often be a query about an issue within Mr Pullen's area.
That's correct.
They already know the delegate.
Yep.
Ms McLaren, when was your group, the Veteran Family and Stakeholder Experience Group, established?
So it was established at the end of July last year.
Some of the staff in the group were presumably transferred from other existing teams in the DVA. Did the group include any new positions?
It did include some new positions. And so when the Secretary started in her role last January, she identified that the communications and engagement functions across the department were very spread, and engagement in particular was done on a very ad hoc basis. There wasn't a lot of consistency in the approach, and engagement is obviously a critical part of what we do. So she focused on bringing those functions together into a single group of the veteran, family and stakeholder experience. So at the moment, it's still focused very much on that client benefits, but you can see on the org structure that in particular, the ministerial engagement and
I'll just get the operator to bring up the next part of the chart, which is the second. That's it?
Yes, sorry.
This is your group that's coming up.
Yes, this is my group. The Ministerial Engagement and Communications Branch and the Deputy Commissioners in particular have a very strong focus on engagement. So the Engagement and Co-Design Branch, which we affectionately know as TED, that their role is about engagement and co-design in relation to program and policy development, so that rather than the individual veteran, and obviously the engagements that our different teams have with individual veterans are incredibly important, this is more about the whole-scale engagement and ensuring that it's done in a way that we're engaging with the right people at the right time in the right way. So we have our first ever veteran, family and stakeholder engagement strategy, which we have developed with members of the veteran and family community, and that will help guide. It's a primarily internal document, but it'll be made available publicly, and that is to guide our engagement and ensure that it is done in a way that maximises the benefit for the veteran community.
Well, I just want to get an idea of what these branches do. Branch divisions are you're at the top in the dark blue. That's a group, as I understand it. You've got in the less dark blue divisions.
Yes.
And then the whites are called branches.
Yes.
And there are teams within the branches that don't actually appear individually here.
Yes, that's correct.
I'll start with commemorations. I suspect that many of us in the public have a basic idea of what that is about. Is there something about commemorations, which is an important engagement, that you would say we might not know about that should get a mention?
So I think that one of the things that's really important to understand about commemorations is that commemorative events, though important for recognising Anzac Day, Remembrance Day, or things such as Vietnam 50, they're really important. It's an important lever for the department in terms of engaging with veterans that we may not otherwise have access to. So, for example, last year we had Vietnam 50. As part of that commemoration and that series of commemorations, we had access to Vietnam veterans, and that gave us the opportunity to provide information about DVA and the services that we provide. So I would say it's likely that as a result of that, some of those veterans who may not have been engaging with us started to access some of our services. So it is a really important engagement lever.
In practical terms, does it take the Vietnam Veteran 50 example, are DVA staff just dispatched to public occasions with a pile of brochures and they just walk up and introduce themselves, or is there something more sophisticated?
So for Vietnam 50, we ran a commemorative program. So that meant, we had certificates that every Vietnam veteran or a family member could apply if the Vietnam veteran has passed. And commemorative medallions to recognise their service. That was particularly important for the Vietnam veteran community who felt that they hadn't been recognised upon their return. Then we had the major event on the 18th of August last year, which is Vietnam Veterans Day. We had over 3,000 Vietnam veterans attend on Anzac Parade in Canberra, where we put on classic Canberra weather. And that did give the opportunity, so it was focused on Vietnam and the commemoration service, but our staff were there. And as part of that, we open arms and all of those services, we make it known they're available.
How's it done? Is it a series of stalls on the side, people walking around with pamphlets?
It wasn't stalls. There was information in we had a commemorative program, but it was also that the event itself drew people to the DVA website. And that also gives them information and access to our other services. And I think that drawing them to that, and we also ran a series, Sir Peter Cosgrove did a number of videos for us, which we put up on DVA TV, which is our YouTube channel. And we know that younger veterans in particular, that's how they engage. They engage through social media. They don't engage through your mainstream papers.
All right. I won't get the operator to expand it further than it is, but there is the Royal Commission Implementation Branch. We have a sense of what that might be doing, but does it in its daily work actually engage with veterans?
No, that's more of an internal...
Yes. I'll skip to the big one, perhaps for present purposes, ministerial engagement and communication. Unless the minister's a veteran, that's not a veteran engagement activity, but just look at these other ones. Are there branches here that have a particular role in actually dealing with veterans, or is it more a matter of designing engagement that David's and other teams will execute?
So the grants and
Mr. Pullen.
Grants and client engagement branch, that they have a lot of dealings directly with veterans, that the client engagement component is the Veteran Access Network. So that's if you call 1-800-VETERAN, one of the call centres that you may be directed to, depending on what you say, is the Veteran Access Network. That's also, we have 19 Veteran Access Network officers. So they are very much that client-facing role. Grants, that team works very closely with ex-service organisations, and so obviously the grants program supports those organisations. And our engagement and co-design branch, they facilitate a lot of our really critical engagements. Next week they will be facilitating the Families Forum, which we will have family members, and for the first time next week we will also have male family members joining us as part of that engagement. But they run a very comprehensive engagement program throughout the year. They do facilitate workshops for Mr. Pullen's team and my colleague Andrew Kefford's group in general. They've run a number of post-vention workshops, and that this year we are implementing a program of consultative forums. Each of those, there'll be 6 consultative forums, and they are open to anyone in the veteran community to attend. And each of those will be hosted by Andrew Kefford's hosting the first of those ones on aged care. 4 of the forums are going to be specifically related to a topic. First one being aged care. 2 of those forums will be very general forums where we will invite members of the veteran community to submit topics of interest, and we'll ensure that the relevant senior staff members are present so that they can answer those questions. They'll be via webinar. That's the most practical way for us to do that with a veteran community that's scattered across the country.
Thank you, Mr. Pullen. Can I turn back to you? You oversee 4 branches. What's the role of the Coordinated Client Support Branch?
The Coordinated Client Support Branch provides case management support predominantly amongst a number of teams.
And are a lot of the clients of the branch people who are engaging with Ms. Cole's division?
That's right, as well as within my division on health and other services, or other services across the system.
It's not confined to claims processing.
That's correct.
And the Mental and Social Health Programs branch, could you give us an overview of what kind of programs they're delivering, if that's an accurate question?
Sure. So they're responsible for rehabilitation programs, so that's connected with incapacity to get someone back to work or back to general medical wellbeing, as opposed to what you might think of rehab as after a surgery or a rehabilitation appliance, just to make that really clear. The branch is also responsible for our adverse events analysis work, a number of other mental health programs, social health programs.
Is there an interface or relationship with Open Arms?
There is.
What's the nature of it? Are you working together, fighting over turf, avoiding one another, or doing something else?
So there's distinct roles. The mental health branch is responsible for program delivery, whereas Open Arms obviously has long-standing role around counsellor and sort of other services directly to veterans.
Do the programs deliver services to individuals, or are they more systemic programs?
There's a mixture. So, for example, we have programs like Veterans Health Week. We have Heart Health Check, which are distinct programs, and then we have broader work that's being undertaken, such as on our adverse events analysis work. We're doing work around thinking about postvention, lived experience, and so forth. So there's a mix.
All right. Ms. Nolan, do you want to write a reply?
Yes, I was just going to say that I think it's fair to say that in the mental and social health programs branch, they have more of a macro approach in overseeing the delivery of programs that then may be feeder programs into referrals, into open arms, where we actually do direct service delivery. So we actually engage with clients ourselves as opposed to funding the engagement of clients through a broader macro approach with programs such as Kookaburra Kids and so forth.
Ms. McLaren, is there a principle that underlines what engagement work is being done by your group and what engagement work is being done in Mr. Kefford's group and perhaps particularly Mr. Pullen's division?
So that my group is we're the engagement professionals in the same way that we wouldn't have an accountant asking me questions today. It wouldn't be a
It might do a better job.
effective conversation. That there's a specific skill set that comes with facilitating and designing an engagement. That what Mr. Pullen does in his team is they're the subject matter experts. So they bring the subject matter into the engagement and then we work with them to deliver that engagement. And that's because engagement needs to be trauma-informed. It needs to be done in a way that is sensitive. It needs to be facilitated in a manner that will deliver the best outcome for the veteran community. And that's a very specific skill set. So, look, we haven't always got it right. We're still learning along the way. And so what you asked earlier, what was one of the new positions? The Assistant Secretary Engagement is one of those new positions because that was a recognition that was previously a non-executive role, a smaller team, that to deliver those engagements in a way that is meaningful and effective and can be built so that our programs and policies are developed and implemented using lived experience and responding to that feedback. You needed people who were skilled in doing that. So that Mr. Pullen might come to me or one of my team and say, hey, that we want to run a program on this, can you help us design an engagement? And we're currently having a few conversations around a few different areas where we can assist. Also at the moment, both my communications and engagement branch are working with Leanne Cameron on the Aged Care Task Force on how that can be designed and how we can support her to deliver a program that is informed by lived experience.
Mr. Pullen, do you want to write a reply? Or are you happy with that delineation?
I thought that was a good summary. I've a couple of examples that I've reflected on when I was running the Claims Process Improvement Division. I worked very closely with Ms. McLaren's area on our commitment to you approach, because that obviously had a significant communications approach to make sure that was joined up. We've also worked very closely with the TED team, as McLaren referred to run some bereavement sessions associated with the work we're doing on postvention. And then through the more formal ongoing mechanisms, such as the ex-services organisation consultative group that Ms. Claren's responsible for running, we regularly turn up and present updates and engage on the particular program areas that we're working on in the division. For example, some of the work we've been doing in the hearing space.
A reason, Mr. Pullen, why the transition issues and in particular veterans hubs are not in your area? They look like they might be programs you deliver. Happy for either of you to address it.
Well, I think we could both. So we work very, very closely with the transition branch and the hubs branch. And I think a really good example of that is around the veteran employment campaign. Obviously, that's a campaign. That's a commitment, election commitment from the government. So the communications elements of that, my team's very, very heavily involved in, but obviously employment's a key part of transition. Equally with hubs, we work very closely with that team. And one of the elements that we're very interested in with them is that they are doing work because, as you know, hubs are run by ex-service organisations, and they're engaging in some work on why people access hubs and why they don't, and what we need to do to make sure those who need to do.
Sure, but what I actually asked is why on the org chart are they over on the far right? That doesn't matter, but they happen to be under Ms Pope. That's not the detail I'm interested in, but they're not under either of your groups. They do seem to be out by themselves for some reason. Maybe it's just Ms Pope's got some expertise, but is there some other more fundamental reason?
I think the Secretary provided a pretty good summary of that in her address in July last year, where she explained she wanted to give a focus to transition, so she created that dedicated focus to do that because it's just so important. That doesn't mean that we don't work very closely with the transition branch and the hubs, which we do. For example, normally today I would be attending a transition meeting, but I'm obviously here for the Royal Commission, but there's that kind of joined up transition meeting that I am a member of to make sure it is all joined up.
There has been a big focus across the department in making sure that none of us work in silos, and that we are, I mean, on an org chart it looks like we are, but I can assure you that absolutely we are not.
I accept there have to be arrangements and divisions on paper at least, but thank you for addressing that. Mr Pullen, are any of the programs that you oversee programs that have been introduced in the last year or two? As fundamentally new ones, not merely relabelled or anything?
I believe there are several pilots that have recently been funded. I only commenced in the role at the beginning of November, late October. There's been no new programs since I commenced, but I am aware there are some recent pilots that have been established.
Right, thank you. Ms McLaren, are any of the programs that you oversee ones that have been introduced, not just as pilots, but actual indefinite programs, new?
So I don't think there's new programs, but there's certainly been expansion of programs, one of those being the Understanding the Veterans Experience, which is a program where previously we ran it exclusively on base, so that we would take some DVA staff to a Navy base or an Army base, and a facilitated conversation with serving personnel would be held, and they would answer questions from the facilitator about why they joined, their experiences, and DVA staff would witness, and then we'd have some kind of on-base experience. That we've now expanded that to include some off-base experiences. There was an event on Monday this week, which the Secretary attended at Currumbin RSL with female veterans, which focused very much on their experiences. And one of the things that we are building on, so it's not new, but enhancing, is our engagement with female veterans. Currently, the Female Veterans Forum happens once a year for 2 days. We're going to continue that as our flagship event, but we're going to expand that to have at least 2 online sessions a year, plus potential regional events where we can. And I'm very excited that today we have put out a call out for the first time. We're recruiting women, just generally female veterans, who would like to express an interest in participating rather than choosing people.
Thank you.
Mr Singleton, sorry, if I could just add to my previous answer, I do recall two additional programs that are fairly recent. One is the Psychiatric Assistance Dogs program. Another recent program that has been funded is specific work on evaluation of program management. So that's a really important program because that's...
Let's repeat that second one. There was a noise I didn't...
the evaluation program on program management. So it's funding for the department to undertake better evaluation of its programs, which is really important on supporting continuous improvement.
Kind of quality assurance mechanism, is it?
I'd say it's more than quality assurance. I'd say it's both assuring the quality but also embedding lessons so then we can even improve our programs further.
How was the what was the full name of the dogs program?
I struggle to pronounce it too, Mr Singleton. It's the Psychiatric Assistance Dogs
It was.
program.
I thought so, and then I lost my confidence. How was funding for that program sourced?
I don't recall, but I imagine it was in the budget. I'm pretty confident it was a budget decision.
To what extent did that involve engaging with veterans with whom the department hadn't previously been engaging?
I wasn't in the role at that time, Mr. Singleton, but I imagine it would have been informed by a previous trial. I understand there was a previous smaller program that was then expanded, so it was most likely informed from that and the engagement with veterans on that program.
I'll ask it as a broader question, and I'll give you the opportunity to answer as you wish, Ms McLaren, but I'll ask everybody, but Ms McLaren gets first dibs. Are there any programs introduced, say in the last 12 months, not just pilots, because that's a special case, but ongoing programs which involve engaging with a cohort with whom the department hadn't previously been engaging? Ms McLaren.
So I think that there's some very solid examples of where our engagements have informed our policy and program development. So the domestic and family violence strategy had been heavily informed by the Families Forum and the Female Veteran Forum, as well as the ESORT, and that I can give you, not a program, but an example. What last year the Families Forum raised with us some concerns around the hold music. So when you call 1-800-VETERAN the hold music, they described it to us as being like a death march, and they felt that it was triggering for a number of people. So we went and had a look, found out from Services Australia that there was some other options we can use. Next week at the Families Forum, they'll be voting on the new hold music for the department.
Is the Families Forum something that's been introduced in the last year or so?
It's been running for several years, but we've been continually changing how we do it.
And that's an example of input. Vet families, in this case, heard and acted upon. I'm asking whether there are any new programs in the last year or so where a new cohort is being engaged with, people you hadn't engaged with before.
So I think one that we're about to engage with is that we're doing our work.
I'll ask you about it. Let's just nail down the last question first.
Yeah.
The answer is no, there are no new programs of significance.
I would say yes for our acute support package which is an existing program, but it's a fairly new program, and we recently ran some bereavement workshops to support the development of our post-vention strategy, but it identified a number of opportunities to improve the way we're implementing our acute support package, which we are now adapting and implementing response to that consultation, and that was with a new group of people that we hadn't engaged in that way before.
All right. Now, Ms McLaren, you want to tell us about the next thing?
So one of the programs that we're working on at the moment is the commemorations for Interfet 25, and as I said previously, commemorations is a really important lever for us. So given that this commemoration will be acknowledging the service of people that's fairly recent, I mean, certainly compared to Vietnam 50 or Korea 75, that it's an opportunity for us to engage with peacekeepers and peacemakers who have served in Interfet and served in other parts of the world in that late 1990s, early 2000s, who I believe are not a group that we've heavily engaged with. Certainly I've heard in my time in this role that younger veterans and contemporary veterans are an area that we need to focus more, and that's certainly one of the areas that I'm very committed to working on. And in the development of the Veteran Family and Stakeholder Engagement Strategy, I actually sought out some people who were not on our usual engagement forums to comment on the development of that strategy, and a couple of them were younger veterans, because they are the people who don't necessarily have access to the department through our established mechanisms.
In previous testimony from another colleague not here, we've been told that the DVA is not engaging with about half of the ex-serving Defence Force members in Australia. Ms McLaren, just from your perspective, what role, if any, should the DVA be playing or attempting to play to engage with veterans who are not initiating contact?
So I think it's really important to acknowledge that those veterans who we don't have a relationship with at the moment probably fall into one of three categories. The first category are those who don't require the services of DVA, and that's because they may still be serving, or they've transitioned and they're living their best life and they don't feel that they need to interact with the department. The next group may be a group that would benefit from interacting with DVA, but for whatever reason that they don't like the department, they've heard negative things about the department, or they don't want to interact with us, they're not accessing the services which they should be. And so I think it's really important for us there to work in partnership with ESOs who may be able to build that trust so that we can then build the trust with that veteran cohort so that they do access those services. The third group, I think, is a group that may need us, but they don't know how to access us. So that's where it's really important that we do have those multiple mechanisms to engage people, that we do have a social media presence to engage younger people, that we do know that people, particularly 18 to 35, that's primarily where they do get their news source from, is from social media, that our older cohort, that we still do have access through Vet Affairs or other mechanisms, and again, with partnership with the ESOs who may be able to reach those people. But I think it's really important that there are people who might be in that first group I mentioned who don't need us now but may need us in the future, that they know how to access us and that they know what we can actually do. So the same that you or I don't access a public hospital unless we need it, we want people to access us when they need it.
I'm not suggesting that you should foist yourself on those who are living a good life or those who just don't trust you, to put it bluntly, but do you think it is the proper role of the Department of Veterans Affairs to proactively get out there and at least make themselves known and let people know how to access?
Absolutely, I do. And that's why we are currently doing a project to refresh our website to make it more user-friendly, and that we have recently started an Instagram account, again recognising that that might reach an audience that we weren't reaching previously, that DVA TV, our YouTube channel, that we're increasing our products through that. So our most watched videos on DVA TV are how do I link my service with MyGov? And then followed by things like how do I submit a claim? How do I do a transport booking? So they're all very practical things, and some of those videos have over 10,000 views. So acknowledging that people might not want to read details on how to do it, but they might put their phone and go, oh, okay, there's the YouTube video, I'm going to do my claim this way. So I think it's really important that we are getting out there, and I think it's also important that we do tell some of those really positive stories as well so that we can build the trust with people who may not have that with us.
I don't suggest that the three categories you identified are wrong. They sound quite logical. But has the DVA undertaken or commissioned any study to try and confirm why so many veterans don't engage and what the proportions are between those three and perhaps an unknown fourth reason might be?
We don't have that information and we haven't done that work yet, but we are very much looking at the work that's happening in the hub space that I mentioned earlier, which is why people don't engage with the hubs, and trying to understand that is that because they don't need them or they feel they don't need them, or is it because the service offering doesn't meet their needs, in which case does the service offering need to be adjusted to meet their needs? So I think that there could be some lessons that we learn from that, and we should take those learnings to better understand our cohort. But I think it's really important that we're accessible so that if people do need us, they do know how to find us.
Is any, I'll withdraw that, suicide in the cohort we're talking about with whom you're not engaging is an issue, it is occurring. Has the DVA undertaken any study or commissioned a study specifically into suicide in the cohort that is not engaging with the department?
I'm not aware of any studies. I don't know if any of my colleagues are aware of any.
I am aware of some work that's been undertaken by our data and insights part of the department, where they've looked at different cohorts over a long period of time. So it takes a whole of population approach. That's sort of at its early stage. I can't go into further detail just because it's not within my area, but I am aware of that work.
Sorry, anyone else know about that project? All right.
I think that sits in the Chief Operating Officer's group.
Mr. Carrolley mentioned the word data, so I looked at him, but may not be fair. I'm going to ask does the department currently have projects that are specifically designed to find new cohorts to engage with? I know you've mentioned improving the website and that kind of thing, but
Yes, so that the work that the TED branch, the engagement branch, is undertaking is about ensuring that we do get a diversity of views and that we do find ways to encourage people who are not usually people who come forward, that our ESORT members, I absolutely admire their dedication and commitment, and they provide us with a great amount of advice. But that they have that access to us. So we want to make sure that we get the voices of people who don't have that regular forum. So, like I said, the first time today we have gone out and we have asked female veterans to nominate to participate in our engagement on that. And with those 6 sessions that I mentioned before, we will be going very far and wide to make sure that people, so that first one with aged care, where we'll be heavily targeting people, veterans who may be about to become or who are clients of the aged care system, their family members, aged care providers. In the future, some of the future sessions, one I'm hosting in May is around engagement and how we can better engage with the veteran community. And so that one we will be very much looking and asking the community as well, veterans and families, how can we engage with you in a way that is meaningful for you? And I think a key part of that is closing the loop. So when ideas come from the veteran community or from families or from stakeholders and we implement them, we need to tell them that we've implemented them and the role that they've had. And I think that's something that we're getting better at as a department. I'm certainly bringing some of my learnings from, I was a New South Wales public servant for 20 years, and that those learnings from those big projects in New South Wales about having to provide that feedback constantly, I'm hoping that's something that DVA can get better at doing too.
I'll ask the operator to bring up DVS 0012 0001 1852. While that's coming up, I'm going to postulate that some veterans who want to find out what services are available or how to get in touch with them might go to the DVA contact page, and what, if I've read out the right number, we'll see a reproduction of that page.
Yeah, I'd suggest it's not our finest work.
Well, let's, if one looks at it, it appears that if a veteran wants to find a service or just find out what services are available, the avenue that the department offers is to fill out an internet form. Is that right?
So that's one of the ways that veterans can contact us.
That's the first one mentioned here. In fact, if you look at the headings, it's ask a question, provide feedback, connect with us.
Yeah, I think that we
The first one is a click on the general inquiries form. That's at least the first and most prominent way. What we'll do is bring up the next document is what happens if you do click on that, and that's DVS 0012 0001 1857. I'm not suggesting there aren't other ways of getting in touch, but I'm trying to look at it from the point of view of the veteran, and who says, yes, I have a question, and clicks on General Inquiries form as the only available link under that heading. And what we have, it doesn't appear like this initially. You get the first half with 1, what's your query about? And if you click on the right circle, access to DVA then comes up. So it's a little bit interactive. And if one goes to the next page or scrolls down, having clicked on other support, so it's a general inquiry, you get this. And then as one goes down the screen, there's an inquiry form, and you can see that the veteran is asked to type in a first name, a second name, I think comes up as we go along, and there are the different boxes. Now, it doesn't show here, but when one actually goes to the real website, there's a red asterisk next to surname, date of birth, email, phone number, and what your inquiry is about. There's no, apparently the veteran card number is not compulsory. There's no actual explanation, but you would take it, would you not, that the red asterisk means these are compulsory fields?
And I suspect very much that they are. That certainly that is one way of contacting us, that the vast majority of people do contact us through 1-800-VETERAN, and I think that the evidence of that is that we received 1.6 million calls, about 2,600 a day last financial year, and I believe that in the first half of this financial year, that we were already tracking towards 1 million calls. So that number is well and truly out there because people are using it. I agree that we can definitely put that as more prominence on our website so that people do know that phoning is very much an option for them.
So if we were on the previous screen, I won't trouble the operator, but if one had scrolled all the way to the bottom, there would be the veteran 1-800 veteran number with no explanation other than if you want to call us, that's the number. Maybe that's a good explanation, but it's not the most prominent option. I'll truncate this little section. It really isn't encouraging a veteran to just make general inquiries, to say the way to inquire is to give us your first name, your second name, your date of birth. That's a pretty chilling and discouraging approach, isn't it?
Yes, I think that certainly people should be able to access information. If it's not in relation to their own personal data, then they shouldn't necessarily have to provide who they are. If they're just seeking standard information about our services and how to access them, certainly I think that we can look at making that number more prominent on our website. And like I said, we are undertaking a project at the moment to make it more user-friendly. So hopefully you wouldn't need to go to a general inquiry. You just click on a box and up would come the information that you're looking for.
And of course, someone might want to ask a question that's not covered. Why couldn't they just be given the option, give us your name if you want, give us we need an email address or we can't answer you, but it can be any email, Hotmail, go and get a Hotmail for this purpose only. I mean, that would be a bit better, wouldn't it?
Yeah, and I'll certainly look into that. I'm not a technical person, so I can't tell you why these things are set up in that form, but certainly that access to information is really important.
Do you mind if I add?
Please.
Yes. And we also have the chat, Pat. This is the chat bot that
Ask Pat.
Ask Pat. Now it's not. I'm only new to the department. It's not. Doesn't have a significant level of functionality to it, and it could be improved. But that's also another entry point, and quite a modern entry point.
And one can go to an office if one's nearby.
Yes.
So I'm not denying the availability of other ones. But we won't have time to go into all of the others. That's an example that we've just dealt with. Ms. Nolan, your division operates under a distinct name and branding, even has its own colour. Open Arms, does that have advantages, having that distinct branding?
Yes, I think it does. I think you referenced earlier that some veterans may feel a sense of distrust in relation to DVA, and we are keen to encourage all veterans and families to access their entitlements under Open Arms. Having distinct branding can sometimes assist with that.
Ms. McLaren, is that a good analysis from your colleague?
Absolutely. I think that Open Arms' branding has worked very much in favour of serving the veteran.
Do you think it reasonable to at least consider setting up a new agency, might be a division, but with its own branding and its own name, to pursue proactive engagement with veterans and perhaps to do things like being a single point of reference, referral, query?
No, I think that work can be done very much from within DVA, and I think that we do still need to do some work to build trust with those who don't trust us. But like with commemorations and using those positives as an engagement tool, I think having that function within DVA will serve to better support people like Ms. Cole and Mr. Caroli and Mr. Pullen in actually delivering their outcomes.
I appreciate, in effect, you've said, well, it can be done in the department, but you also agree with Ms. Nolan that there are advantages in the separate branding approach, particularly given that there are some trust issues. What is it about other forms of engagement that distinguishes the rest of the department, or some of it, from open arms that makes it inappropriate to follow the open arms model?
May I make a comment? I think Open Arms was established by Vietnam veterans over 40 years ago, and part of the separate branding has been to acknowledge that legacy as different to the rest of DVA as a Commonwealth Government agency. Open Arms was established by veterans for veterans, and I think that that separate branding has been in part to acknowledge that legacy, as well as to encourage people to access a mental health service as opposed to their entitlements through DVA. So I think we have a different service offering, which lends itself well to being branded separately.
And I appreciate the historical thing, but one, of course, can learn from the success of what was an ESO and learn from the historical success. Ms. Nolan's original answer, which is perfectly consistent with her second answer, but it was there are advantages in the separate branding. And I just want to know, Ms. McLaren, why those advantages would not be relevant to other forms of engagement.
Well, I think that we also shouldn't shy away from the fact that we are the Department of Veterans Affairs, and that we need veterans and their families to come to us as well. So I think that we need to be building up the why you should come to us, that we do need to engage really broadly, but sitting aside would probably take away all the benefits of having the program delivery and the service delivery, which is why veterans should be engaging with us.
And I'll give a final thought for your consideration before I yield to the commissioners. It's a similar question, without the emphasis on separate branding and trying to look completely different. But what about a branding approach which acknowledged we're DVA, but emphasised this is the way to contact us. Whatever your issue is, you can come to us. We'll refer you as appropriate. If you want to make a claim, we'll get you over to Ms. Cole. What about that? The example of Service New South Wales has been suggested to us. Everyone knows it's the government. So it's not hiding, but it's a recognisable point of contact that perhaps the department doesn't presently have.
I think that we do have that through 1-800 Veteran, but we can do a lot more to make it clear that there's that entry path. So 1-800 Veteran is actually 15 call centres through one entry point, and that that's been a much better way to do things than having to find this is the number for transport, this is the number for claims, this is the number for your general inquiries. So I think that there is definitely merit in this is how you contact us, here's your single entry point. And we're one DVA.
Thank you, panellists, commissioners. Over to you.
Thank you, Mr. Singleton. Commissioner Brown.
Thank you very much. So I might start with you, Ms. McLaren, just on that issue of trust. You said that you recognise that there's still a way to go to build trust, and you talked about engaging through ESOs to access to veterans, talked about the website, Instagram, YouTube, but do you have a kind of broad sense of what you actually require to build trust with the veteran community?
I think it's a big part of it is making it clear what we're doing, and so communicating, and then that particularly where people ask us to do something, to loop back and close the loop. So, and I think that in particular with the great work that has been done to reduce the claims backlog, to demonstrate that work has been done, and now what we're moving on to is the next phase. And I think it's really important that we're always honest and upfront with people as to what we're doing, what we can do, what we can't do. And in particular, where people give us feedback and say, we need you to do this, if we can't do it, we need to explain why we can't do it, because people feel that they've wasted their time if they've engaged with us and got no outcome. So that for me, closing the loop, coming back making it really clear what we can and can't do, making it clear what our services are, what we can help with, what programs and policies we're doing, and also where, and this is really important on the spectrum of engagement, being very clear when we are talking to people, are we informing you? Is this a decision of government that has been made and we're just telling you this is what's happening? Or is this something where we're actually seeking your view and that your view can influence the direction that this policy or program takes? Or are we actually empowering you to really make the decision? For example, and I know it's only a small thing, but choose our hold music. Are we actually giving that authority to you to make that decision for us? And being clear on what it is we're doing and why we're doing it, I think, is an important part of trust, because when you don't do that, people just walk away.
Thank you. So the other thing that continues to puzzle me, as I understand it, for several years now, DVA has been notified by Defence of all service members who are transitioning, and yet you don't maintain, as I understand it anyway, maintain contact with those serving members if they don't have a claim with DVA. It would seem to be an obvious place to start.
So the transition branch sits outside my area of responsibility, so I'm not quite sure on what does and doesn't happen there, but that's a valid point.
I have to say I'm surprised that you're not aware, given your engagements, and that seems an obvious place to start, but I accept what you're saying, you're not aware. I'll move on. Can I ask Ms Nolan, in relation to the change in the procurement arrangements, DVA obviously promotes a veteran-centric approach. Is it fair for me to assume, and perhaps you can't answer this, but it doesn't appear that the approach that the Department of Finance has put out is in any way veteran-centric?
I'm not sure what to say in response to that, but
okay,
we have...
we'll take it as a comment, perhaps. Would you, however, under the previous arrangements, have terminated the services of an OPC contractor if you had concerns about the quality of care?
Under the statutory engagement process, what would tend to happen is that they simply would cease to get referrals. We would provide feedback, if necessary, make notification to APRA if that was appropriate, but they would cease to get referrals from us rather than a termination of a contract, because ostensibly there was no contract. There was a letter saying that we may refer to them, and then we would refer to them on an ad hoc basis. It lacked programmatic settings in a way that you could then evaluate and control for quality.
I accept it lacked the programmatic, but the outcome would be the same.
Correct.
So it's kind of bureaucracy for bureaucracy's sake. Sorry, that's another comment from me. Could I ask Mr. Pullen, you said that the funding for the AEA ceased with the last financial year. Did I hear that correctly?
You did hear that correctly, Commissioner. That ceased at 30 June 2023, though the department has continued to resource that function because it's an important function. And now that we've established the foundational requirements, I've given approval to expand the number of people within the team.
So can you just clarify for me why it ceased? Was it
Object.
like
That might not be a question that witness can answer without...
Sorry, could you just move closer to the mic?
I apologise.
I'm happy for the witness to tell me they can't tell me, but I'm just curious to understand why it may have ceased, if there is an explanation.
I wasn't in the role at the time, Commissioner, so I'm not aware of the reason for the decision.
Thank you. Can I just ask Ms. Cole, there was discussion about the separation between initial liability and permanent impairment and the teams that deal with the claims. I'm aware that going back many years, they were done together, then they were separated. Now there's been the combined benefits approach for some claims, and in the future potentially we'll go back to having them together once we're under the single legislation. But just for my own knowledge, what was the problem in the first place that with having it together that led to them being separated into separate teams?
I'm sorry, Commissioner, I don't actually know because I was not here at a point in time when that arrangement was in place. Okay. So the division I came into had a structure, clear structure of IL teams, PI teams and NCAP teams.
You also said that there may still be a requirement that some veterans may still have continuing VA or DERCA entitlements even after we move to the new legislation. Can you just explain that?
Yes, I can. I'm not an expert in the proposal, but I do understand the basics of it. So if, for example, a person were on a VA disability pension, that is a fortnightly payment, and that payment would continue throughout their life, essentially. Now, if they had under the arrangements as I understand it in the draft, exposure draft, if they subsequently had a new condition which they wish to claim for, they will do that under the MERCA, but that standing entitlement to their disability pension will continue throughout their life.
Okay, thank you very much.
Thank you. Commissioner Douglas? I'm just conscious of the time. I just have a couple of quick questions. Ms McLaren, you'd be familiar, obviously, and I think Mr Singleton discussed with you those veterans who are not engaging with DVA, and you'd be familiar with the outcomes of the last census, where for the first time we actually worked out how many there are and where they are and so on. I mean, it's obviously a very good method for DVA to work out where the constituency is, and then you might make plans from there. We've been told that that may not automatically continue, the questions in the census. Would the DVA, are you in a position to comment whether the DVA would have a view in terms of supporting or otherwise the continuity of questions about veterans in the census, the national census?
From my perspective, it's a very useful question because, as you pointed out, Commissioner, that data of where people are is very useful for us in targeting service delivery, and also from an engagement perspective that it shows us where we should be targeting our communications.
It should be a no-brainer, shouldn't it?
Yes.
So we'll put down DVA supports census questions, will we? Okay. The other issue is slightly digressing, and I'm curious through your engagement with the broad range of people in the veteran community, whether this has come up or not. But we have heard from a lot of people about problems that have been experienced where there's been unfair denial of recognition, and medallic and otherwise, of people who have been in zones that have not been declared to be conflict zones. And probably one of the worst examples I've seen is the Lebanese Civil War, where Australia had peacekeepers and then someone in Canberra decided it wasn't really a war. And there's been toing and froing. I think some groups in one area got it, but then other groups across the river didn't get it. Is that an issue that's come up at all on your radar?
I've had it raised with me by one person in the last 12 months.
Okay. Are you in a position to comment on the process at the moment, as I understand it? And you may say this is outside your scope, but it seems to us that the process at the moment is that the Minister for Defence is the only person who can decree whether a zone was a conflict zone or not, based on the advice of the ADF. Does the DVA have a view about that at all, or whether the recognition and commemorations area may want to get involved in that discussion?
That one is, I think, outside my scope, that we certainly have conversations in relation to commemorating events and recognising peacekeepers and peacemakers generally. but that I've not been privy to any conversations about what defence or the minister recognises.
Thank you. Okay. Just one more question for Ms Noland. Your organisation has obviously gone through a lot of changes, starting out as Vietnam Veterans Counselling Service, and then now here we are with Open Arms and the various elements of it and so on. In a perfect world, do you think it's fit for purpose at the moment, or do you think you'd like to see some major change in the perfect world? If you were God, what would you want Open Arms to be and do? And I know it's a big question, but I'm sure you're up to it.
Might help to put my speaker on. Thank you, Commissioner, for the question. Open Arms is in a unique position in that we are relatively well funded as a mental health organisation. I think one of the challenges for us is ensuring that we remain relevant to the veteran community in its changing iteration with younger veterans, enhancing our model of care for families. I think in an ideal world, I would have everything that I would like to have in place in terms of clinical governance, in terms of quality assurance, in terms of updating and upgrading our group programs in place tomorrow, but that is a work in progress. I do feel confident that we are on the right track. I think being established as a division has given me much more decision-making latitude and autonomy to put in place the things that we need as a mental health service, but also as part of the Department of Veterans Affairs as a Commonwealth Government agency. And I think in a perfect world, I'd probably get something close to what I have got to work with. I would just like to be able to get things done more quickly.
More resources, obviously, which is what everyone needs, I guess.
Although I do have to say we are well funded. We are the only well-funded mental health service I think I've ever worked in, and I've worked in New Zealand and in the UK and across Australia.
Thank you. Mr Dean, any questions?
No questions, thank you.
Thank you. Mr Singleton, any matters arising?
I'll just ask the question.
That's better.
The Commonwealth Procurement Rules at Clause 2.6 provide that the rules don't apply where appropriate officials determine that measures are necessary for human health or to protect human health. Did the department consider whether it could come under that clause before it made the major reforms to the OPC?
I would have to take that on notice.
That's sufficient from me, I'm sure, this afternoon.
So, Commissioner Douglas has one.
That I am reminded of something I intended to ask before. With this change in the contractual situation, will it be open for the department to fund medical professionals at higher rates than they have been? We do hear quite a few complaints that the funding for the medical professionals isn't nearly enough.
That is an ongoing issue, certainly in terms of being competitive in the market with a scarce supply of mental health professionals. It's something which myself and my colleagues across the states and territories and in the private sector are always combating, and we do try to ensure that we are paying a reasonable amount, bearing in mind that we can also provide other supports to attract employees, including things like clinical supervision, learning and development and so forth. But I think that that is an ongoing issue for us.
Thank you.
Thank you. Are the witnesses to be excused from their summons?
Yes, thank you, Commissioner.
Okay. Thank you for your evidence today. We know it's been a long day, but it was necessary, obviously. You're excused from your summons to appear today. If there's no other issues, we'll adjourn briefly. Okay.
All rise. The Royal Commission into Defence and Veteran Suicide is now adjourned until 4:15 p.m. The Royal Commission into Defence and Veteran Suicide is now in session. Please be seated.
Good afternoon, Ms Longbottom.
Good afternoon, Commissioner Caldas. I recall Vice Admiral David Johnston to give evidence. May he please be administered an oath or affirmation.
Do you swear by Almighty God that the evidence you shall give will be the truth, the whole truth, and nothing but the truth?
I do.
Thank you.
Commissioners, there are 2 tender bundles for the evidence this afternoon. I ask that the operator please display the first tender bundle. Commissioners, I seek to tender the documents in... Oh no, this is a supplementary tender bundle, but I can attend to that first. I seek to tender the documents in the supplementary tender bundle in the manner in which they are described.
Thank you. They'll be accepted on that basis, Ms Longbottom, and allocated the next lot of numbers. Thank you.
Thank you. And then I also seek to tender the documents identified in the principal tender bundle in the manner in which they are described.
Okay, that's 3 pages.
That's so.
They're accepted as well, and they'll be allocated the next lot of numbers. Thank you.
Thank you. Commissioner Caldas, before I commence the examination of Vice Admiral Johnston, there is an issue that my friend for the Commonwealth needs to raise in relation to the document that is tender bundle document number E, and it's reference DEF.999.0165.0001.
Commissioners, in the course of Vice Admiral Johnston preparing to give the further evidence today, it's been ascertained that a view was taken as to what constituted a sexual offence for the purpose of the Defence Force Discipline Act 1982 in responding to notice NTG DEF 213 capital C1, which may be broader than was strictly appropriate when you look at the offences under that Act. What we're proposing to do is to have some further information provided to give context to the numbers in that table. Just at a very general level, the numbers in the table will include not only sexual offences, but offences such as prejudicial conduct under the DFDA, which may have a sexual element to the offence. So it is a broad categorisation, if you like, and we thought it may be useful to provide some further information to clarify or provide further explanation for the numbers in those tables. We haven't...
Does that mean the document will be substituted, or...?
No, we weren't proposing to substitute it. We'll give some thought to whether it should be done by way of a statement by somebody or whether it can be done in correspondence.
Yeah, thank you. When will that be, do you think, Ms Mott?
The issue's only just been identified. I think we'll be able to attend to it fairly quickly, but I don't want to give an undertaking without having instructions. I can get those instructions and
thank you.
Provide that time.
Ms Longmont, are you content with that?
We are, thank you, Commissioner.
Okay, thank you. Thanks for raising that.
Vice Admiral, I want to take you back to some of the evidence you gave when you appeared before the Commissioners on Monday. If you recall, during the course of evidence, we took you to what's called the Handover Takeover Pack to the Chief of Personnel, dated October 2023. Do you recall that document?
Yes, Council.
In that document, at paragraph 12A, I can take you to it if necessary, you identify a number of concerns regarding systemic weaknesses in the military justice system. Do you recall that?
Yes, Council.
one of those systemic weaknesses you identify is the assurance system for both discipline and administrative aspects of military justice, particularly level 2 assurance. Do you recall that?
Yes.
Now, Admiral, during the course of evidence on Monday, I asked you some questions about which committee you would brief concerns about systemic issues with assurance systems for military justice. Do you recall that evidence?
Yes.
And as I understand it, the effect of your evidence was, well, one, those matters would be identified in annual reports, but putting aside annual reports, they would be matters that you would brief up to the Chiefs of Services Committee. Do you recall that?
Yes, in addition to the annual reports.
In addition to the annual reports. And at our request, you undertook to provide the Commission with specific minutes of COSC, the Chiefs of Services Committee meetings, where those issues were raised. Do you recall that?
I do.
Now, we have been provided with copies of minutes where military justice is discussed during the course of COSC meetings. And thank you for doing that for us. We have only had those documents for a couple of hours, but there are some propositions that I wanted to put to you in relation to them. Now, am I correct that COSC meets approximately once a month?
That's correct.
And we have been provided copies of minutes in which military justice is discussed across the course of 5 years. That's correct?
Yes.
And so across the course of 5 years, on my maths, there would have been approximately 60 meetings held by COSC. Is that correct?
Thereabouts, maybe, except for December, yes.
Okay. Now, of those approximately 60 meetings, there are 12 documents that have 12 meetings where minutes have been produced. So there are only 12 meetings of COSC across the course of the past 5 years where military justice is discussed. You would accept that?
Yes.
Now, the documents we have been provided indicate that on an annual basis, around November each year, the work plan that is produced by the Military Justice Steering Group is provided to COSC for its approval. That is consistent with your understanding of the minutes?
In the last quarter of the years, yes.
So effectively, and this was canvassed in your evidence on Monday, each year the Military Justice Steering Group produces a working plan. It goes up to COSC for its approval, and then once it's approved, it's then addressed during the course of the year, and the Military Justice Steering Group report against progress each year. That's a fair assessment?
It is.
Okay, so putting to one side those work plans, on our reading of the minutes, there is only one occasion on which concerns about systemic weaknesses with the assurance system for defence, for military justice is mentioned. I might just take you to that particular document if I could. Could the operator please display DJO.1002.0001.0075? So if you can see there, Admiral, that is a minute of the meeting on the 7th of August 2019. About how long had you been accountable officer by the time that meeting was held, for military justice, I mean?
Nearly 12 months, just over.
If the operator can then please turn to .0080 and expand paragraph 34, subparagraph E. Now, on our review of the minutes, that is the only occasion on which there is any discussion of substantive concerns about systemic weaknesses in the assurance system. Is that assessment, to your view, incorrect, Admiral?
In my view, yes, it's incorrect.
Okay, well then can you please take me to the other minutes where there is identified concerns with systemic weaknesses with the assurance system for military justice?
Council, the material that you have are the minutes of COSC meetings, which record what would be decisions taken, agreed or noted. What it doesn't include, so at every Chief of Service Committee, there are papers for each of the items that are much longer in the detail and canvass a broader range of issues. That minutes record decisions taken, as I'd said, or are an abbreviation of the discussion that occurred. So the minutes of themselves are not necessarily a full record of the material that was presented to the committee.
Now, I will give you an opportunity to take me to papers or briefing papers where systemic weaknesses with the military justice assurance system are noted. But as I said at the outset, on our reading of the minutes at least, there may be an update provided to COSC. That update may speak to progress alongside particular work items, including with respect to assurance. But even in those briefing papers, there is not specific reference to concerns about systemic weaknesses with the assurance process for military justice. So could you please take me then to any briefing papers where that matter is raised?
So, Council, I can't do that off the top of my head. I'm conscious and aware that that material exists, but I'm not in a position here to be able to take you to explicit papers where that is the case.
Well, let me suggest to you that that issue is not raised with the exception of what I've just taken to you to now. Nowhere in these documents is there raised a concern about systemic weaknesses with the assurance system for the military justice system. Do you accept that proposition?
In the context of just the COSC minutes, yes.
Yes. You do accept that proposition?
In the minutes, yes.
No, I mean both in the minutes and in the briefing papers.
No, I do not accept that proposition.
If I am right about that and you are wrong, do you accept that that is an illustration of the failure of the governance system in that there has been a failure to report up to the relevant committee a systemic weakness with the military justice system?
Council, you're asking me a hypothetical.
I am, yes.
And I'm not agreeing the proposition.
No, you don't have to agree with the proposition. I am saying to you, if that hypothetical is correct, do you agree that that would be an illustration of a failure of the governance system within Defence?
No.
Why not?
Because I'm confident that the material has been presented and an awareness of those limitations exist, Council.
That is not the question I have asked you, Admiral. The question I have asked you is, if there is an absence of mention in the briefing papers or the minutes before COSC of systemic weaknesses with the assurance system, is that a failure in the governance system?
Council, the purpose of those meetings is to make sure key decision makers are aware of the key issues, and I am confident that is the case.
You're confident that's the case because you just know it, or you're confident that's the case because it is documented in those minutes?
I am confident because the material that was presented to the committee encompasses it.
And I have put to you the proposition that it doesn't. And if that proposition is correct, do you accept that that would be an illustration of a failure in the governance system?
Council, I think I've answered saying no, because it's my view it's the discussion that occurs and the level of knowledge of the people who need to have that understanding is a reflection of whether the assurance system is working.
Okay, now I'm going to shift topics now, Admiral, to evidence that was given yesterday by the Associate Secretary, Mr. Yiannopoulos. But I might start in that respect to taking you to a extract from a meeting of the Enterprise Business Committee on the 24th of November 2021. Operator, can you please display tender bundle document M? It is DEF.1161.0001.0116. And can you please expand paragraph 15 of that document? Admiral, you there note difficulties with articulating our business model. Is that there a reference to One Defence?
In the broad council, yes, I think it's a reference to the responsibilities of the accountable officers across the department.
And consistent with the evidence you've just given, you go on to say that may be a reason why we have issues with defining accountabilities. Can you please give commissioners an overview of the concerns you held at that time with respect to the definition of accountabilities within Defence?
Commissioners, my comment at the committee meeting was that the Defence and the expression that's used is a matrix organisation. By that, it means that we draw, for example, I draw on finance support, human resource management support from other parts of Defence. They are not from elements that work directly for me. We use people who are the specialists in it, but they may reside in a different group for it. So the accountability model, it can be difficult to describe because of the interdependencies of an accountable officer's role with the enabling support that is key for them to be able to perform their function. So that was the expression I was trying to make at this meeting. There are interdependencies between functions in Defence that make that accountability a more difficult description.
Now, Admiral, the Commission heard evidence on Tuesday from Associate Secretary Yiannopoulos. Have you had an opportunity, did you have an opportunity to watch or to consider that evidence?
No, regrettably, I had some full commitments all day yesterday.
Well then, Admiral, I might, to assist you, take you to some particular aspects of that evidence. I might ask, Operator, can you please turn up the transcript from day 86, commencing at 87-8556. My apologies, it's day 87. And thank you. Can I ask you to please expand from line 25, and I'll give you an opportunity to read that, Admiral, right to the end of the page, please, Operator.
Yes, Council.
And then if you could then please expand, operator, the next page through to line 35.
Yes, Council.
Now, Admiral, the first matter I want to put to you emerging out of that evidence is this. Do you accept that a challenge for defence leadership is a lack of leadership accountability mechanisms?
I think it's a key part of leadership is to have accountability mechanisms, but I'm uncertain to which particular part you're referring to where that lack would exist.
Well, in your view, do sufficient leadership accountability mechanisms exist?
I think the leaders, including me, are clear on what we are accountable for.
Are those accountabilities documented?
Yes, Council.
Are the documented accountabilities sufficient, in your view, to clearly identify what you are accountable for and how that accountability is measured?
It's clear on what I'm accountable for and what the outputs are that I'm required to deliver.
And where are those accountabilities documented?
You find them in part in the administrative instructions that we went to on Monday. You also get an expression of what we are accountable for by looking at the Defence Corporate Plan, which describes the defence outputs and the accountable officers who contribute or lead on those outputs.
Let's start with the corporate plan, for example. In what way, can I ask, do you have a performance agreement or some specific mechanism by which your performance against particular outcomes is measured?
A performance agreement in the context of performance reporting?
Yes, key performance indicators, a mechanism by which your performance for delivering particular outcomes is assessed.
I have a charter letter which describes what those performance outcome requirements are.
I've seen the charter letter. My question is, do you have specific outcome-based measures to assess your performance against your particular areas of responsibility?
I have them for most areas reflected in the corporate plan or in other documents. Wouldn't suggest I have it in all areas, Council.
Okay, let's start with a corporate plan. Is there, so obviously, as you've said, the corporate plan identifies particular outcomes that defence is to achieve in a given year, and it identifies who is accountable for those outcomes. Is there a separate document that identifies your specific outcome-based measures against the corporate plan?
Some of them are built into the corporate plan, so they include measures that are specific and measurable. So the plan itself does have elements of that to it.
Putting to one side the corporate plan, what other documents specify your particular outcome-based performance measures against your accountabilities?
The corporate plan is the primary one that would express those in a number of areas.
Now, the Associate Secretary gave evidence that around 2021, so this is around the time that of the EBC meeting to which I just took you, he created the Strategic Accountabilities Table. The purpose of that table was to clarify and make clear for everyone where accountabilities exist in the system. In your view, has the strategic accountabilities table been effective in achieving that outcome?
I think it's very useful for the purpose of clarity, both for the accountable officers and for others who, in a number of ways, are responsible for supporting them or have key roles as part of those delivery of outcomes.
Now, I might ask the operator to please go to the transcript at 87-8594 and expand from about line 14 to the end of line 30.
Yes, Councillor.
You will see there the Associate Secretary puts forward his assessment that the accountabilities in the strategic accountabilities table is clear, but identifies that there are parts of the organisation that don't like them, and when they don't like them, refer to them as unclear. Are you one of those within the organisation that do not like the strategic accountabilities table and considers them to be unclear?
I'm not.
Okay. I now want to take you to the strategic accountabilities table. Operator, can you please display tender bundle document number J? It's DEF.1335.0001.006. And can you turn, please, to .0008 and expand item 2. And if you could then please also put up alongside it the balance of that row which appears on the following page. You are familiar with that aspect of the document, Admiral?
I am.
Can you explain to Commissioners what it is intended to do from your perspective?
Commissioners, there are, like many of the senior executives in Defence, there are many parts of the role that I perform. This document principally outlines those responsibilities that I have. I think in it you can see I have a core role around the capability for Defence, the preparedness levels that we set for the force, for the strategic circumstances that we find ourselves in. So it's a description of the functions that I perform at a very senior level, and at the lower part of that, it gives a description of the relationships of those who I both support or who also support me.
And you recall, Admiral, just before I asked you some questions about the strategic accountabilities table, that is this document we have in front of us, and the effect of your evidence, as I understand it, is that you consider that this document is clear in terms of defining accountabilities. Have I correctly understood your evidence?
You have.
Including your specific accountabilities.
Yes.
Now, what I want to explore with you, Admiral, is the extent to which there is, first of all, specific outcome-based measures that are linked to the accountabilities that are identified in this document that would allow senior leadership, including yourself, to have their performance measured. Can I suggest to you, Admiral, in terms of identifying what your accountabilities are, this is properly characterised as a high-level document?
Yes.
Would you accept that this table does not appear to include any outcome-based measures to measure your performance against each of those accountabilities?
In this table, that's a reasonable description, yes.
Okay, well, we spoke earlier about the measures by which your performance is assessed. You've made specific reference to the corporate plan. Are there any other documents containing outcome-based measures to measure your performance against the accountabilities in this table?
I think you'll find there are descriptions in the Defence Portfolio budget submission, documents that we provide to Government Council, which provide an indication of the outputs under those roles.
Admiral, my question is not directed to specific broader outcomes for which Defence is accountable. My question is directed to illuminating for the Commissioners where there are specific documented outcome-based measures by which the performance of each individual senior leader can be assessed. Is there such a document in relation to the accountabilities you hold as identified in this table?
If I could give an example which might be helpful, Councillor. So my key role in a capability sense is making sure future capability is delivered for the Australian Defence Force under the decisions that the government takes. In our annual report, we have to report against the progress in presenting government with those decisions on the future force, including the delivery of it. It's measured by whether we're obtaining on time, whether we're within the scope of the advice that we've given, whether the cost is consistent. So there are measures that exist that describe the outputs that we're achieving and are measurable against our achievement of them.
Would you accept, Admiral, that while there might be, in a broad sense, measures that exist, there is no single point of clarity as to how a senior leader would be held accountable for a failure to deliver on an outcome with respect to one of their accountabilities as identified in this table?
So, my view, and particularly me as a senior leader, I am accountable for the output. So a failure in any part of it impacts my accountability or achievement, Council.
And in terms of how that accountability is measured, what form does that take? So, for example, is there an annual review where you sit down with the CDF and the CDF specifically considers your delivery of specific measurable outcomes as against the corporate plan, as against each of your ongoing responsibilities as identified in this table?
Council, I meet with the CDF nearly every day where we are dealing with the issues of delivery of my responsibilities, either constraints or limitations as part of that. So I have regular conversations with the CDF about the delivery of the roles for which I am accountable.
It might be helpful, Admiral, if we canvass this issue in the context of a specific example that's given in this table. As you'll see on the far right-hand corner of item 2, one of your key non-ongoing responsibilities is in relation to this commission, inter-service work stream. Can you clarify for commissioners what that responsibility pertains to?
Sorry, Council, could you just draw to which part of this document that's referring to?
So the final column under the heading Key Non-Ongoing Responsibilities. I might just ask if the operator could expand that.
Council, that's a reference to not within the services, but providing a supporting function to make sure Defence is providing all of the support that we can to the Royal Commission and meeting the requirements for the Commission in order to enable your work to occur.
And in respect to that responsibility, are there any documented outcome measures by which your performance of that responsibility are or can be assessed?
Not that I'm aware of, no.
Okay. I just want to step through with you, if I can, Admiral, how this particular table sits alongside the Defence Administrative Policy. Admiral, I'm going to take you to a document that was in the tender bundle for Monday. It's not in the tender bundle for today, but I think it's a document you will be familiar with. It is your prior particular accountability document or administrative instruction. It's DEF.1384.0002.0002. Are you familiar with this document, Admiral?
From our discussion on Monday, I recall it, yes.
And I might ask if the operator could please display that document, particularly at dot 0021. And if you could display it against the document that was previously up, DEF.1335.001.006 at .008. And across to the following page as well, just those two parts of the table that were displayed previously, please. While that's coming up, Admiral, can I ask you to please explain for the commissioners the intersection in your understanding between the strategic accountability table and the Defence Instruction Administrative Policy in terms of defining your specific accountabilities?
Council, yes, that's a rather complicated question, Commissioners, if I might. The two of them have a relationship with them, but the administrative policy, or the document that is referred to you on the right, is an expression of some particular elements of accountabilities as the military enabling domain lead is described in there, which effectively is just an administrative umbrella for a whole range of military functions that are performed. In this case, one is called out in particular, which is exercised by the Chief of Navy, and that is the seaworthiness or technical authority function that is operated by Navy. Because I am the overall umbrella authority for military enabling administration, in this case it sits under that particular title.
So am I right to understand, Admiral, the effect of the evidence you've just given is that the strategic accountability table on the left will identify, in the first place, policy areas that are within your particular accountability?
Outcome areas, yes.
Outcome areas within your accountability, and I think you've accepted it does that at a high level.
I agree.
And the document on the right is to be read as giving some more specific description of accountabilities with respect to particular issues within your broader domain responsibilities.
Yes.
Now, just in terms of the accountability structure within defence and the hierarchy of how one defence is organised, am I correct to understand that, let's use here the example of the Chief of Navy. The Chief of Navy is accountable to you as the Vice Chief of the Defence Force, and you in turn are accountable to the Chief of the Defence Force.
The Chief of Navy is accountable for his responsibilities to the CDF, as are the other Chiefs Council. So they do not report through me.
Okay, well, just let's have a look at the document here on the right. So at the top, you are identified as being the accountable officer for the military enabling domain provisions. That's correct?
Yes.
This particular aspect of the administrative instruction pertains to seaworthiness or seaworthiness management system.
Right. Yes.
Just in terms of the document on the left, the strategic accountability table, could I ask the operator to please display the next page? You will see there under supports, there is reference to capability managers to deliver joint maritime, land, air, cyber, space and intelligence capability. Now, I will be grateful for your clarification, but on our reading of this document, you are identified here as having some sphere of responsibility with respect to matters pertaining to the Navy and seaworthiness. That's correct?
Not entirely, Council. So if I could explain, I'm responsible for the administration of military policy. What the document on the right does is provide a delegation to the Chief of Navy directly, consistent in this case with the Chief of Navy's responsibilities for seaworthiness, that he is able to directly prescribe or put in place policies associated with seaworthiness. So one is an administrative policy function, which I am delegating to him because I express the umbrella holder of military policy, but that is more an administrative process of ensuring that the Chief of Navy is able, under his authorities then, to develop and to be able to outline seaworthiness policies and requirements.
And so the document on the right, the cancelled administration policy, as you've just said, delegates particular responsibility to the Chief of Navy for that?
It delegates him the authority to write those policies because I am the overall policy authority of who might be able to then develop their own sub-policies within that.
So it delegates the Chief of Navy authority to write those policies. But at the top of the page, you are still identified there as being the accountable officer. So what, if any, responsibilities does the Chief of Navy have to you as the accountable officer in relation to those policies and their effective discharge?
He does not have any link to I am the accountable officer for the military enabling administrative domain. I think, Council, that's the important distinction that I'm trying to make. But for purposes of, and I think in the Chief of Navy's accountability statement, you'd see set professional standards. There are a series of roles or responsibilities that I have in part enabled because he can write policy on those matters, but that is an administrative function. It is not a delegation of authorities from me.
Would you accept, Admiral, as my tortured examination as I've taken you through these two tables perhaps illustrates, it is indicative of some difficulty from an outside perspective in terms of understanding where specific accountabilities lie?
Except Defence is a very complex organisation, and yes, it can be difficult to see how those linkages are made.
Now, can I, operator, you can please remove the document on the right, but could you please keep up the document on the left? You'll see there, could you please expand that part of the table under supported by? You'll see there, Admiral, there is reference to, in the context of yourself, and the Associate Secretary as the two senior integrators for the Defence Enterprise. Could you please give the Commissioners an overview of what that expression, senior integrators for the Defence Enterprise, relates to and what your specific responsibilities are in that respect?
Council, yes. Defence, as you know, comprises two components, the Australian Defence Force and the Department of Defence. The Associate Secretary, under the Secretary's authority, has distinct accountabilities in the department. I, through the CDF's authority for the ADF, in a one defence model where we have a highly integrated organisation, integration of effort between those two components of defence are critical to our outputs. Associate Secretary and I, as described in this document, have a role to ensure that those elements come together well, both the military component and the Australian Public Service component in the Defence Department, in order to achieve our outputs.
And you've just used the expression there, integration of effort. Have I correctly characterised that responsibility?
Yes.
Are there measurable, documented outcomes against which your discharge of that responsibility are measured?
They're measured largely by the outputs of the department on whether we have sufficiently achieved that integration. It is a key supporting element to the outputs of the department itself, Council. We could not achieve the described outputs for defence without that integration occurring.
Accepting that, what I'm trying to understand is whether or not there is a documented benchmark by which that responsibility of integration of effort can be externally measured.
There is not a set of key performance integrators, if that is another expression, that would explicitly describe that integration function that the Associate Secretary and I perform. But as I mentioned, the outputs wouldn't be achieved if it was not being managed.
Now, would you accept, though, Admiral, that an output is not an outcome?
I think that's I'm not sure of the utility of that distinction in the language of it. If the outcome is the defence of Australia, that's a fairly clear statement of our objectives.
Can I just come back to the evidence you've given about the description of what the senior integrator role relates to? On Monday, you identified your relationship with the Associate Secretary in this way. You said, it is a critical relationship between the two roles. We have a particular responsibility in bringing the threads of the various elements of the department together, and we work very closely to do so. Do you recall that evidence?
I do.
Is the description you gave on Monday, is that a description of your role as senior integrator as identified in the strategic accountability table?
It's true as senior integrator, but it's also a reflection of my roles in a number of those other components that are showed in that accountability statement.
Can you clarify that? So am I right to understand you to be saying there is an overarching responsibility to ensure that the civilian and military side of defence, if I can put it in that way, are integrated as part of one defence? Is that a correct characterisation?
Broadly so, Council.
Broadly.
Yeah.
But
and I only say that as, of course, the civilian and the uniform parts all work through various elements of it. So it's not a distinction in its purity.
no, but there is a responsibility with respect to the enterprise of one defence as a whole to ensure on your part, working together with the Associate Secretary, that there is, as you've said, an integration of effort.
Yes.
So that's one aspect of it. But then in terms of the other aspects of it, could I use, for example, say, workplace health and safety? are you there referring to, if we could use that as a particular example, you have specific responsibilities for workplace health and safety, and I'll come to those in a moment. The Associate Secretary also has those responsibilities. Is that another illustration of those two threads where you come together to ensure that the system is integrated properly? Have I correctly understood that?
It's perhaps not the best example.
Can you give a better example to commissioners then, please?
An example I might use is a responsibility I have for delivering the future capability of defence. That requires contributions from the services, from the head of intelligence, all informing requirements. On the Associate Secretary side, it also needs our delivery agencies, our sustainment agencies working together. So through the parts of the department where he has a key role, and that element which I do, the integration of our two efforts is what makes future capability possible. Why I said Workplace Health and Safety Council is, of course, I have individual responsibilities as a group head, as does the Associate Secretary, but others lead that work in the department.
And that might be a convenient juncture, Admiral, to shift to that as a topic. I'd like to work through your responsibilities with respect to the health and well-being of the members of Defence. On our examination of the documents, those responsibilities appear to exist at 3 levels, and I just want to take you through those just to make sure I have properly understood that. And in each respect, we are interested in understanding how those responsibilities are documented. In the case of, not just in a general sense, you have a responsibility for that particular issue, but specific measures by which your responsibility can be assessed. Now, you made reference before, I think, to your charter letter. Could you just give commissioners just a brief overview of the role the charter letter plays in terms of defining your responsibilities?
The charter letter, commissioners, outlines those key functional outputs which I am responsible for. I think in some of my evidence today I've used examples, future capability of defence, the setting of the preparedness, and that means the readiness of our force to respond to different requirements of government, so that the demand signal, if I could, to the services about what type of scenarios they need to be ready for, the readiness level for them. You see I'm described as a joint force authority. That means in part both determining that future force and the way the force operates together, so making sure that integration does occur through it. So there are a number of those key outputs which are relevant to the Australian Defence Force's capability as described in my charter responsibilities.
And I might just bring that document up now. Operator, can you please display DJO.1001. Thank you. And can you please expand paragraph 12? Sorry, paragraph 2 rather. Now, you are there identified, Admiral, as having, in your role as Vice Chief of the Defence Force and Head VCDFG, can you please give the commissioners an overview of what precisely VCDFG is and the capability it comprises, particularly with respect to people?
Commissioners, and I did say Defence was a complex entity. The way we are structurally organised is, and you would be familiar with the services, Navy, Army and Air Force. The other entity that groups us together is called a group. So I am the head of the Vice Chief of Defence Force group. I have a number of divisions within that. They perform military strategic commitments as one who work with our interagency partners on the requirements for defence outputs. The force design is a division. So the grouping is an organisational construct that brings together a number of divisional efforts under a single banner. You'll hear us referred to as group heads or service chiefs.
And just in a broad sense, can you give the commissioners an understanding of about how many people are within that group?
I think in my evidence on Monday I referred to there was 19, either, of course, the 3 service chiefs, as you're aware, and then a combination of other military 3-star appointments and civilian band 3 appointments.
So it's there identified that you have responsibility to develop and steward the people and capabilities for which you're responsible, including fostering their well-being. Can you please give commissioners an overview, first of all, of what that specific responsibility entails and any documented measurable outcomes by which your performance against that responsibility can be measured?
The statement is a description of my specific role to the people who work more directly for me. So separate to my function as the Deputy of the CDF, which has a whole of Defence Force remit to it, in the manner which I described, there's a group that I am the group head for. Paragraph 2 is an expression of the statement of my role to be a good steward of our people, to be able to demonstrate the values and ethics that we expect of our people through my own conduct. So I have a direct responsibility for those people who report more directly to me in the performance of their duties.
And are there any documented specific measurable outcomes you have with respect to that particular aspect of your responsibility?
Council, there are a number of ways in which that is described. I think on Monday we talked in part through my leadership responsibilities for the health, welfare, safety of our people is described in our leadership doctrine. So there are expressions of that role and responsibility that I have as a leader that appear through the leadership doctrine, which describes the responsibilities of all defence leaders.
Now, I might just take you now then, Admiral, to DEF.9.0132.0068. And if you could please turn to .0152. You might recall we spent some time on this document on Monday, Admiral, and you can see there on the table that's been displayed, there is a description given of your carriage or ownership of particular topics. I just want to particularly focus on the welfare and well-being and mental health aspects of that table. Take a moment to read it.
Yes, Council.
Does that describe a different responsibility to that which is articulated in your charter letter, or is it a more specific enumeration of that responsibility?
It's a more specific description of it.
Okay. I then want to move on to specific responsibilities you hold under the Workplace Health and Safety Act. Operator, can you please display DEF.1288.0002.0392? And expand the first paragraph there. Now, you are there identified, Admiral, as being one of the designated officers of the person conducting a business or undertaking.
That's right, Council.
That is a specifically defined provision under the Workplace Health and Safety Act. For convenience, I might refer to that as you being a WHS officer. Are you content to use that term interchangeably with person conducting a business or undertaking?
I am.
Thank you. That should hopefully make things a bit simpler. The first question I have is, in terms of your responsibility as a WHS officer, does that pertain to One Defence as a whole, or particular subsets within it? And if so, what subsets?
As an officer, it particularly pertains to the group of people I lead, the VCDF group that I was just describing.
And where is that subset responsibility articulated in a document?
In this particular document, Council?
In any document. The question I have is this. So we can see here that there are a number of individuals within senior leadership in Defence who have responsibilities as a WHS officer. My question is directed to understanding how we as a Royal Commission can see on the face of the documents whether or not your responsibility pertains to everyone in One Defence, or if it is, as you say, a specific responsibility to the VCDF group, where that is identified document so that accountabilities are clear.
Council, my understanding is the Workplace Health and Safety Act makes that particular definition clear around the function that the individual must have, or the influence that they can exercise, is a reflection of the responsibility that they have. So why the group head or service chief articulation is important there is I can influence heavily and determine the priorities within my group. That's consistent with the authorities and responsibilities that I have, and then consistent with the way the officer definition of the Workplace Health and Safety Act is, that's where my particular responsibilities lie. So I must have a significant influence on the output of a certain set of activities for the Act to be in its application.
Might be convenient then, Admiral, if I just take you through the provisions of the Workplace Health and Safety Act, just so that I can have an understanding, and the Commissioners can particularly, of how you see the intersection between your responsibilities as identified in this document and how it appears in the Act. You can just bear with me for a moment. So the policy states that your responsibility as a workplace health and safety officer is to exercise due diligence to ensure that your workers comply with the Act. And those specific duties are enumerated in Division 3. I might just ask if the operator can please display Section 27 of the Workplace Health and Safety Act Commonwealth. If not, I can just read out to you the particular sections. It might just be convenient if I read out to you the particular sections, Admiral. So Section 27 of the Workplace Health and Safety Act says that if a person conducting a business or an undertaking, so that's the role we've just described, the WHS officer, has a duty or obligation under this Act, an officer of the person conducting the business or undertaking must exercise due diligence to ensure that the person conducting the business or undertaking complies with that duty or obligation. Now, those due diligence requirements include taking reasonable steps to acquire and keep up to date knowledge of workplace health and safety matters. You're familiar with those provisions in terms of articulating what your specific responsibilities as a workplace health and safety officer are?
Yes, and if I could be helpful, Council, the document that was just up, I think the second paragraph of that is the one I was referring to, which provides a useful description of in what manner do those responsibilities apply.
Well, I might then just ask if the operator could please redisplay that document. Are you talking there at about what appeared at Annex A?
I'm not
Might bring it
sure
up and
what
you can
page
take
it
us
was.
to the particular provisions.
No, that wasn't the one that was previously being displayed. Now it's the second paragraph, Council, is the one I'm referring to. By that I mean the person who participates in decision making, in effect, the whole with a substantial part of a business or undertaking. That's the alignment I'm suggesting with my group responsibilities where that definition applies.
And what I'm trying to get an understanding of is, from the outside looking in, how can someone identify where your specific responsibilities as a workplace health and safety officer sit as compared to, say, the associate secretaries?
Because of that description in that second paragraph, which says where my decisions, and this is relevant to the workforce that I work alongside, has that impact of wholly or substantially determining the roles that they perform. So as a group head, that is true for my workforce. That's not true for my authorities in a different group or in Navy, Army and Air Force. In the Associate Secretary's case, it would be similar for the group that is responsible directly to him.
So your understandings of your responsibilities are, your responsibilities as a workplace health and safety officer pertain solely to the workforce that is that you are responsible for, that is under your command. Is that correct?
So principally for that group, yes.
Okay, so principally for that group, what exceptions exist then?
So with my responsibilities more broadly as a senior leader, we're understanding risks that might be involved in the operational deployment of the Australian Defence Force. So other areas where, as a senior leader, I have a broader function to perform, but principally under the Act, this is the appropriate description of how the Act applies to the workforce that I work with.
Okay, so as I understood it, you've just said you principally have responsibilities to that workforce under your direct command.
Yes.
You separately have responsibilities where you exercise a specific function or power that may affect another component of the broader defence workforce. Is that a correct understanding?
Yes.
But save in those two respects, you consider you do not have any other specific obligations as a workplace health and safety officer. Have I understood that correctly?
That's my understanding.
And then in terms of your specific responsibilities as a workplace health and safety officer, do you accept that those extend to managing risks to health and safety?
Yes.
And as part of managing those risks, identifying reasonably foreseeable hazards that could arise to give rise to risks to health and safety?
Yes.
And your responsibilities extend beyond just identifying those risks, but they extend to eliminating those risks so far as practicable.
That's right.
And if it's not reasonably practicable to eliminate those risks in their entirety, then you are obliged by the legislation to take steps to minimise those risks so far as it is reasonably practicable.
I agree.
And specifically, those obligations pertain to a number of categories of risks, but they include psychosocial hazards.
Yes.
And a psychosocial hazard is, in broad terms, defined by the legislation, and particularly the workplace health and safety regulations, as being a hazard that would emerge in the workplace that may cause psychological harm.
Yes.
Okay. Now, I want to get an understanding then of the mechanisms by which you discharge your specific accountabilities as a workplace health and safety officer. Could you please give the commissioners an overview of how you do that?
Commissioners, certainly, and it is one of the most serious responsibilities that I have. I discharge them through a number of means, but one of the mechanisms that is very important to me is I run, and I think in the tender documents you would see it, what's called the Vice Chief of Defence Force Safety Board. That board has its purpose of looking at the functioning of the workplace safety management system that I have in place. Through that, I meet quarterly with all of my division heads. We have a risk register that we review to determine what the mitigated and unmitigated risk levels in our workforce are, what trends have been emerging, what actions we need to take. So the board is an important function of making sure I understand the data and the steps that we are taking to look after our people. But that's supplemented by a whole series of other means for me for gathering data. I'm clear on particular parts of my workforce that carry more psychosocial risk than others. I think you have previously, and in hearing block 11 in particular, heard from elements like the Defence Response Unit, which has a function around the Defence Reparation Scheme. We recognise as an example with that group that vicarious trauma was a significant issue for the matters that they were dealing with. We put in place additional measures for the screening of people who take up their roles, identifying self-help plans on how they can look after their care. So for those risks that exist in different manners across my group, and they do perform a very wide range of functions, we identify the risks that are particular to certain workplaces, put in place mitigation measures for them, and then keep a close eye on the performance of those measures to manage the risks. And when incidents occur, they are reported through me as part of the incident reporting framework that we have.
Now, if I could take you, please, Admiral, to the 199 response. It's DEF.quadruple9.0132.0068. And if the operator could please display .0076 of that document. You'll see there's reference in the second last row to the Vice Chief of Defence Force Safety Board. Is that the organisation that you've just been referring to?
It is, Council, yes.
You'll see there, and you'll recall from Monday, the N and Y in the row designate the viewed events as put forward as about the topics for which that board has ownership. You will see there is a no by reference to welfare and well-being, and a no by reference to suicide, suicidality and self-harm. Do you agree with that characterisation?
Not as it's presented on that page, no, the Council.
Okay. Do you see there being any differentiation as appears in that table between responsibilities for mental health specifically and otherwise welfare and well-being and suicide, suicidality and self-harm?
Sorry, I'm unclear on the question, Council.
Do you see there being any reason why your board would be responsible for mental health but not responsible for suicide, suicidality and self-harm on the one part?
We are responsible for both.
And for welfare and well-being
Yes.
as well?
Yes.
Okay. Now, I want to have an understanding of the I might just take you actually for completeness to .0137 of that same document. And expand table 1.36. That is the description that has been put forward by defence as to the sphere of responsibility and purpose of that group. Can you read it and tell me whether or not you agree with that description and or if there is anything that you would add to it?
The sub-point A is not clear to me, and I would not have expressed it in that manner.
How would you have expressed it?
I don't think the point is appropriate at all in terms of my workplace health and safety responsibilities.
Why not?
Because as the description that we have had, Council, it applies as an officer to those elements where I exercise substantial influence on the workplace. So that's I think it is an imprecise way of trying to describe that function.
So would it be fair to say that your view is that subparagraph A defines your WHS due diligence obligations as extending to a broader cohort of people than you understand it to pertain to?
That's right.
Now, I might just then take you to some documents. Just before I leave that, you can see at the bottom of the table, you're identified as the chair. I think in answer to questions from my learned friend on Monday, you clarified that insofar as it pertains to tiered committees such as this, as chair, you are the decision maker in relation to the matters that are canvassed by that particular board.
Yes.
Okay. Now, I just want to take you to some documents that further enumerate the work that board performs. Operator, can you please display DJO.1001.0001.0262? And can you please turn to .0273? And expand paragraph 28. Now, just take a moment to read that, Admiral.
Yes, Council.
Now, accepting what you've just said about the capability scope of your WHS due diligence obligations, would it be correct to say that paragraph 28 defines the means by which you discharge those obligations?
The means isn't probably the word I'd choose to use, Council, but it's a description of the elements that are part of me exercising that responsibility.
Well, paragraph 28 says you demonstrate due diligence by A, B, and C, by the three things that are identified there. Is there anything else by which you demonstrate due diligence?
No, I accept that statement.
And in respect of each of the items that are identified in this table, are there any documented measurable outcomes by which your performance of those due diligence obligations are assessed?
Yes.
Where are they?
You would find them in the Workplace Health and Safety Manual that's referred to the WHS-MS. You find it in the reporting that I receive quarterly or we discuss at the safety board, which reflects the trends that we have seen, the risk levels that we are dealing with, the incidents that have occurred. So there are clear objectives and performance measuring occurring as part of that system.
Now, Admiral, subparagraph A describes one of the steps you take to demonstrate due diligence as the issuing of a statement which demonstrates commitment to 3 things. I might just ask the operator to just to put alongside this a document, just to make sure I've understood correctly what that statement is. Operator, can you please display DJO.1001.0001.0318? And can you please display the next page, .0319? Is this the workplace health and safety statement to which paragraph 28 refers?
Yes.
Now, the statement is identified as demonstrating a commitment to take particular steps. Could you please explain to commissioners whether or not each of those steps about which you demonstrate a commitment are taken, and if they are taken, where they are documented or where we could find those?
Can you draw me particularly to which element you're referring to, Council?
We can take them first one by one. So the first is establishing objectives and targets for the WHSMS. What does that acronym stand for?
The Workplace Health and Safety Management System.
Okay, so by this statement, you've demonstrated a commitment to establishing objectives and targets for that system. Where are those? Have those objectives and targets in fact been established?
They're established in the document, which is the management system, yes.
Okay, so there's a specific document called a management system where we will find those.
Yes.
Okay, the next item is measuring and improving safety performance. Is there an established mechanism by which safety performance can be measured and through measuring improvements be identified?
Yes.
Where will we find that?
You will find that in the quarterly reporting that I receive at the Safety Board, which demonstrates incidents and trends. You would find it through, we perform what is called, we have been supported by Air Force who do safety assessments called a snapshot survey that surveys our workforce with a well-being component to it. So I see it in the workforce reporting that gives explicit data about the state of the workforce. So we have a number of measures that contribute to that outcome, Council.
And then if I could ask you to give the same if I could ask you to answer the same question in relation to the third of those commitments that are demonstrated by the policy statement.
So I have a small cell that is a workplace health and safety cell. We provide specific support to the particular workforce that and the risks associated with it. We have very much in the last few years focused on psychosocial measures and I think in my earlier description to the commissioners I was talking about, we've helped them with self-care plans for individuals. We've provided specific training around vicarious trauma that they may be experiencing. So depending on the functions of a particular workforce and the risks that are relevant to that functions, we have provided training and support to them that are relevant to their roles.
Now, Admiral, I want to take you to a couple of minutes emerging out of the safety board. Again, the purpose of this exercise is to illuminate for the commissioners the specific risks that are managed within that board and then I will separately ask you some questions directed to clarifying the intersection between the obligations of your board and that of the Workplace Health and Safety Enterprise Board. Just before I do, I should just correct a mistake I made. I think I identified the Safety Board as being a tiered committee, but I understand it's not a tiered
It's not, no, that's correct.
Before you move on, Ms Longbottom, can I just clarify one
course.
thing? You were asked about the work or the WHS management system, and I thought I heard you describe it as a manual earlier on.
It's a management system, Commissioner, my apologies, but it is a documented system.
Okay, so if there was somebody below you looking for guidance on something, they would go to this particular manual, would they?
Yes, they would.
Thank you.
Operator, can you please display DEF.1327.0002.0131? And if you could please turn to .0132 and expand paragraphs 12 and 13. Just take a moment to read that.
Yes, Councillor.
Now, Admiral, on our reading of that document, it identifies that psychosocial risks make up the majority of the risks within the remit of the board. Is that a correct understanding, or should we read that as identifying those risks as pertaining particularly to issues associated with unacceptable behaviour?
No, not quite either of them, Council. What that paragraph is highlighting that because of the nature of work that is performed within my group and the assessments we have done of the risk, we believe psychosocial risks are the most substantive risks within our workforce.
And would it be fair to say, at least on our reading of the minutes emerging out of your board, that psychosocial risks continue to be a significant risk across the course of the work of your board from 2021 through to even sort of today? Is that a fair assessment?
It is.
Now, I just want to pause there and focus specifically on the reference to unacceptable behaviour. On Tuesday, and this is, I'm diverging slightly from workplace health and safety here to a military justice issue. On Tuesday, the Associate Secretary was asked a question about whether or not he agreed that issues relating to the appropriateness of ADF members who are convicted of a sexual offence against other ADF members remaining part of the Defence Force is a matter that falls within his responsibility. His answer to that question was no. I might just ask if the transcript can be brought up so you can have an opportunity to see the evidence he gave. It's a transcript day 87, 87-8588. Have you had an opportunity to read that, Admiral?
Was there a particular paragraph that, or is it all of it, Council? My apologies.
Yeah, there are a number of propositions emerging out of that I want to put to you. First of all, do you agree that the appropriateness of retaining ADF members who are convicted of a sexual offence is not a matter that falls within the responsibilities of the Associate Secretary?
I do.
Who is responsible for those matters?
Or the retention of people, it would rely or resides with the service chiefs.
So
That chiefs of Navy, Army and Air Force, if I may.
So, and I want you to particularly focus upon your time as accountable officer for military justice. During that tenure, did you have any responsibility with respect to issues relating to the appropriateness of retaining ADF members who are convicted of a sexual offence?
Council, would it be helpful if I could describe how those determinations are made? The short answer is no, but I can help perhaps illuminate how those judgments are made.
That would be helpful. Thank you, Admiral.
And if I'm right, Council, I think in particular the commissioners were interested, if I recall, it was 31 cases over a number of years of people who had been convicted of sexual offences or a form of them. I think all of which I might just identify, I think those were cases where they were found guilty. You would be aware that for Defence Force magistrates or court martials, the sentence of dismissal is available to the presiding authority, but in those cases, given the particulars of them, the deciding authority clearly did not elect dismissal as a punishment, but all of them were punished in the manner that the sentencing principle found. So all of the individuals were punished. There are alternate means then available to us under the administrative system of whether those individuals would continue to meet the criteria of serving in Defence's interest. And that's the second part that can be performed. So the discipline system, court-martial or Defence Force magistrate will consider an offence and award a punishment associated with that offence. The service then can consider whether that individual's ongoing service is warranted, but that has to be done in a manner mindful that an individual cannot be punished twice for the same offence. So it may look at the broader circumstances of that individual. It could be an understanding of their mental welfare at the time, their behaviour over certain periods of time, or the patterns of performance that they may have demonstrated. So the service, in considering that outcome, could not seek to punish an individual for the same circumstances that were considered through a discipline system, but would consider other conditions that would be relevant to that judgment.
Now, I just want to particularly focus, though, on who is responsible for making the decision with respect to administrative termination, and I think that's really what you're specifically talking about there. The Associate Secretary refers to it as a command decision. Is that command decision something with respect to which you have any authority or oversight?
No.
Okay. Who has authority or oversight at a senior leadership level with respect to those command decisions?
It's a delegation that is drawn from the Chief of the Defence Force and explicitly described into the three services and functions that are performed within those services. Others, I have a delegation which I've not used in my tenure because it hasn't been associated with people working for me or the circumstance where it might be referred to me. But it is a delegation drawn from the Chief that is in writing described at various levels of authority, and it does change depending on the service. So the three services have slightly different delegations that they have sought.
But it is, would you not accept, an area with respect to which, in a broader enterprise sense, there ought to be policy about how that particular power is exercised in those circumstances?
But there needs to, I'm just being careful because we can't, the manner of terminating, particularly through administration, councillors, cannot be prescriptive. The decision maker
Except
needs
that it has to be assessed on each case.
That's correct.
Yes.
So there can be guidelines for consideration about what is in the interest of the service, but then yes, left to the decision maker for the applicability in that particular circumstance.
But in terms of the fact of guidelines, is that a matter that falls within the remit of the accountable officer for military justice?
No.
Why not?
I think my evidence on Monday gave an example of that, of work that is now, being councillor, yes, but if I could explain, it would be a better answer. My apologies to you. On Monday, I described work that is being done in civil convictions, or what might be guidelines that are applicable to, or decision makers could consider. That work is being done by the now accountable officer.
Okay, so and can I just, in that respect, am I right in understanding that a challenge with respect to civilian convictions is defence being able to identify where a member has been convicted of a sexual offence in the civilian sphere?
A defence person is required to inform their workplace when they have been charged, but that requires the individual to make that declaration. There is at the moment no mechanism for the states and territories civilian courts to automatically inform defence that an individual has been charged.
So then, but coming back to policy, I think you have just accepted that, at least in the case of civilian convictions, developing policy or guidelines that pertain to the exercise of that discretion to administratively terminate a member is a matter that falls within the remit of the accountable officer for military justice?
Yes, to provide advice to the CDF.
So if it falls within the ambit of the accountable officer for military justice in the context of civilian convictions, why doesn't it fall within their ambit in the context of convictions under the DFDA?
I do think that is a further body of work that could be done following the work that is underway around civilian convictions.
But was it a body of work that you undertook during the course of your tenure as accountable officer?
During my tenure, the inconsistency or the variability became obvious to me. It was with the Chief of Defence Force and I looking at similar data, we formed that conclusion, and that work had started, but it is not complete.
And would it be correct to say, you correct me if I'm wrong about this, so far as we can identify, there is only one arm of service that has a policy, that is the Navy, and it is I can take you to it if necessary, but I don't think it is for present purposes. There is a direction from Navy dated the 30th of November 2022, but so far as we can identify, there is no similar policy for Army or the Royal Australian Air Force, and there is no singular policy for the ADF as a whole. Is that correct?
I'm uncertain, Council. I don't know.
Now, just shifting back to workplace health and safety, I just want to have an understanding of the relationship between the role of the VCDF Safety Board and the role of the Enterprise Workplace Health and Safety Committee. Operator, can you please display a DEF.quadruple9.0174.0001? And if you can please turn to .0011 and expand paragraphs 7 through to across the next page, paragraph 14. Have you seen this document before, Admiral?
Council, I'd have to read it to be clear on whether that's the case. I'm not sure.
I'd encourage you to take a moment to read it, because this is obviously a statement put forward by Defence about the operation of your particular board that you chair, it would be helpful if we could understand whether or not you had any input in giving that account.
Personally, no, but I would expect that the workplace health and safety element that works within my group would have contributed to it.
Now, what we are trying to get an understanding of is how these two boards, that at least on our reading, similarly have a crossover in terms of the work they perform and the responsibilities they have intersect, and how the fact of these two boards works efficiently in the context of the enterprise committee system.
Council, absolutely. So the Defence Workplace Health and Safety Board is the enterprise board. So it has members commissioner from each of the services and groups. It is the one that looks at broad enterprise risks, the performance of the department from a workplace health and safety at the enterprise level. Council, as I've been describing, the VCDF Safety Board is about my responsibilities as an officer in the business to my people. The relationship between them, so I have a person who is a member of the Workplace Health and Safety Board. They're also a member of the VCDF Safety Board. That enables me to understand what the enterprise issues are and the relevance of those issues to my workplace and the roles and functions that people in my group. And similarly, issues of risk that we are identifying within the workforce in the group, we can take to the board to make sure they are understood or incorporated as part of the enterprise board. I would say each of the officers, so the group heads and service chiefs, will have their own mechanisms. So you've asked me specifically about my board. There are different forms of that would exist in each of the services and groups.
So you're referring there to the service-specific workplace health and safety boards?
And the other group ones, yes.
Okay, let's just start with the service-specific ones. To your knowledge, do they report up to your safety group or do they report up to the Enterprise WHS board?
So no, they do not report to me. Their relationship would be with the enterprise workplace. So I am one of the 19 groups that all report in. I do not have a reporting linkage to any of the other group or service boards.
And you're there described in paragraph 13, or your board is described as having performing an advisory function to the Defence WHS board. That reference to advisory, can you explain to commissioners what your view is of what that function is?
It was what I was just describing, Councillor. And I've said psychosocial risks are one of the most substantive because of the nature of work that my group perform. My advisory function to the enterprise board is to raise that as this is a known risk in our group, to give insights into how we are managing those risks, to understand at the enterprise level what requirements or initiatives might be available, but it's advice on the workplace health and safety issues that I am seeing for the workforce that works with me, and making sure those key issues or risks can be represented at the enterprise level.
Okay, so, and I think you've just said, like, if I can give just a particular example of a group where there may be a crossover between your board and the Defence WHS board, let's use what you've described as the VCDF group. Would that be a correct characterisation of a cohort within Defence in respect of which the WHS board may have some carriage, albeit in its enterprise capacity, and you separately in your VCDF safety board may have some carriage with respect to?
Yes.
Okay, can we then please go to paragraph 10 of that document on .0011? And expand paragraph 10. What I want to have an understanding of is, in a practical sense, you make, am I right to understand that you would make decisions with respect to governance of WHS issues pertaining to the cohort to which your board pertains?
Yes.
How do you ensure that there are no siloed approaches being taken with respect to your board and that of the WHS board?
Through that mechanism, Council, I was describing, I have a person from my board that sits on the enterprise board. And I invite to my board at every meeting a senior responsible officer in the department's workplace health and safety function. So we very deliberately make sure I am represented at the enterprise level, and we draw the enterprise expertise into my board so that we have a very good flow of information and understanding both of my group issues or those issues that are appearing or are being managed at the enterprise level.
I'm going to shift topics now, Admiral. I want to ask you some questions pertaining to some evidence that the Commission heard this morning from Mr. John Armfield. Did you have an opportunity to hear that evidence?
I heard the evidence this morning, yes.
Before you heard the evidence this morning, were you aware of the matters about which Mr. Armfield gave evidence to the Commission?
Not the particularities as he described it, no.
In any sense?
No.
Does that cause you concern, given that those events occurred during the course of your tenure as Accountable Officer for Military Justice?
I think that Mr. Armfield was very courageous in bringing the evidence that he did to the commissioners and with a very compelling description of what he had experienced. The function of managing him was within his workplaces and the service in which he worked. So I am always, and particularly as the accountable officer at the time, seek to understand when the process of military justice is not working, but the management of the particular circumstance in which Mr. Armfield found was managed within his workplace and his service.
Okay, I just want to take you then in that respect to some of the evidence that you gave on Monday. Can the operator please display transcript for day 86, particularly at 868504? Commissioners, while that's coming up, I am conscious of the time. There are about another 5 or 10 minutes, though, that I think it's important that I canvass with the Admiral. Is that acceptable from your perspective?
Yes, but we also have questions, and I'm aware of the 2-hour time limit for our transcription staff. I'm sorry to do this, but we may have to have a short break and then come back.
I apologise for having taken that time.
That's fine.
Now, Admiral, you identify there, this is the part of your evidence where you spoke particularly about assurance issues connected with how administrative inquiries were conducted. Do you recall the evidence you gave on Monday?
We did have a long discussion on it at Council, yes.
Let me refresh your memory. One of the matters that was within your responsibility as Accountable Officer for Military Justice was administrative inquiries.
Yes.
That includes something that is called fact finds.
Yes.
And you recall that I asked you questions about whether or not you held concerns about systemic issues with respect to the way in which fact finds are conducted. Do you recall that?
Not explicitly, but I did indicate that I had in my evidence indicated that the level 2 assurance over the administrative element of the justice system was one of those areas that I had identified had vulnerabilities.
Let me just take you to the specific answers you gave. You see at line 11, I say to you, given the frequency with which that tool is used, and I'm talking there about the administrative inquiry function, I asked you, do you hold concerns the absence of a centralised capability function is a systemic weakness in the conduct of administrative inquiries? You then go on to give evidence pertaining to, amongst other matters, the training, experience, mentoring and currency within the individual arms of service pertaining, and as I understood the effect of your evidence is that is one mechanism by which you have assurance. I then put to you a question, I said, do you have any concerns about the standardisation of those matters within individual arms of service? And you said, I think it's strong in that context. It is not strong enough in the joint context.
That's right.
And am I right to understand the joint context to particularly pertain to joint operations conducted by Defence, which would include, for example, a fact find conducted by a Defence Force recruitment organisation that sits within Defence? Am I right to understand your evidence as pertaining to those types of things?
No, that wasn't the context that I offered. I think in the paragraphs that you've shown, I used joint operational in the context of the offshore or the military functions we perform. That particular issue around joint inquiries came as a result of operational incidents and the deficiencies that were identified in the investigation of those incidents.
Okay. Do you have any concerns, or did you before, sorry, let me rephrase that. Having regard to the evidence that you heard today from Mr. Armfield, do you hold concerns about systemic weaknesses with respect to how administrative inquiries are conducted within organisations that are joint operations, such as Defence Force recruitment officers?
So from the evidence that I heard this morning, I'd have concerns in the way those inquiries were managed based on what Mr. Armfield represented to the commissioners, but that's different from a systemic view of the weaknesses where my evidence as I provided on Monday is unchanged.
And you heard the evidence Mr. Armfield gave this morning about how he did not raise his concerns just with his immediate chain of command. He went right up to the Deputy Chief of Navy, and that's not a matter that you had any awareness of before you heard him give evidence today?
No.
Does that give you cause for concern?
The council, that is consistent with individuals being managed within their areas of employment in the command chain.
Doesn't that go to show the systemic weakness that we were talking about on Monday? That is, that if it's left to individual chains of command, Defence as an enterprise has no oversight on any means of assuring itself that that particular frequently used tool is being deployed appropriately.
Council, as our discussion on Monday indicated, I have said there are vulnerabilities in the level 2 assurance, and I remain of that view, and that the assurance mechanisms, particularly around the administrative inquiry process, is largely based on the ability of individuals to submit complaints when they believe that inquiry process has not been well managed.
Now, I just want to take you to another part of the evidence you gave. Can the operator please go to 86.8-8524? Just take an opportunity to refresh your memory about that evidence. It pertains specifically to whether or not there was a mechanism of assurance that commanders were engaging with people involved in the military justice system in a trauma-informed way. Do you recall that evidence?
Yes, Council.
And as I understood, the effect of your evidence was, well, training is how we obtain that assurance? Is that a fair assessment of your evidence?
Not in its entirety, no. I indicated training and selection of individuals is one of the components of that assurance system.
And you said the other component is military justice audits that would give you an idea about if something else was happening?
And amongst other measures, yes.
Okay, what are those other measures?
But I think we did discuss them through the course of the evidence on Monday. that we can gain insights into the performance of units by looking at the number of incidents that occur, at the number of people who are seeking to leave that unit or transfer to different roles and responsibilities, the justice audits as you described. So there are workplace health indicators that do provide an insight into the general management and leadership that's occurring within a unit.
But it would be fair to say that the effect of your evidence was that the delivery of engaging with members in a trauma-informed way is principally the responsibility of those commanding a particular unit to have oversight of. Is that a fair assessment?
Yes.
Now, we spoke on Monday about your responsibilities with respect to ADF HQ. And as I understood it, the effect of your evidence was, well, there are some respects in which I am responsible for ADF HQ, but there are other respects in which the CDF is responsible. Is that a fair assessment of your evidence?
It is.
Who is responsible for oversight of ADF HQ insofar as it engages with people like Mr. Armfield, particularly with respect to the provision of, in his case, an inquiry report?
That because the authority to release a report is resident within the CDF, that a relationship between the release of a report is to the Chief of the Defence Force.
Okay. Because, and you may tell me if you did not, I'll put this to you, the effect of the evidence that Mr. Armfield gave was that in August of 2021, so that is during your tenure as Accountable Officer for Military Justice, he was provided a copy of the inquiry report into his brother's death. You recall that evidence?
I do.
That inquiry report was posted to him at the Helensvale, Australia Post Office. Do you recall that evidence?
I recall him saying so, yes.
There was no support given to him on receipt of that report. Do you recall that being his evidence?
Was his evidence, yes.
And that action occurred within ADF HQ. It was someone from ADF HQ who caused a copy of that report to be provided to Mr. Armfield in that way.
Yes.
And am I right to understand the effect of your evidence to be that the person who ought to be responsible for that, particularly insofar as it pertains to whether or not that is a trauma-informed approach, is the CDF?
No, I wouldn't put it. That function was exercised from within the headquarters in consultation with, as it would be with the service to which the person belongs. I expect the CDF would not have had awareness of the manner in which that was done.
And this is precisely the issue that I was engaging with you about, Admiral, on Monday. That is, this is a clear instance of a gap in the system where, despite us being told by Defence it engages with individuals in a trauma-informed way, there is clear evidence that, at least on this occasion, it doesn't. And in fact of that evidence, there needs to be a systemic assurance system to ensure that, in point of fact, despite their training, despite the policies, that commanders are dealing with their members in a trauma-informed way. Would you accept that as a proposition?
Council, it depends on what you're describing as that assurance system.
Some mechanism by which there can be assurance by Defence as a whole that its command are in point of fact dealing with members in a trauma-informed way. Do you accept that assurance system ought to exist?
That is the assurance system that command should be and the leadership providing to the people who are exercising that role.
But what you've just told me now in the case of Mr. Armfield is, well, no, the CDF isn't probably responsible, maybe ADF HQ is. This is a clear example of someone who was exceptionally traumatised by the way in which they were dealt with by Defence, but there is no systemic approach to ensuring things like that don't happen in the future.
I'm aware in that particular type of example, letters are not provided in that fashion any further.
I'm conscious of the time, Commissioners.
I understand our recording people are happy to break for 5-10 minutes and then we'll come back. And regrettably, Vice Admiral, we just need to have a break because they have to have a break every 2 hours. And then we'll need to continue a bit longer.
Thank you.
We'll adjourn for 10 minutes.
All rise. The Royal Commission into Defence and Veteran Suicide is now adjourned to 6:30. The Royal Commission into Defence and Veteran Suicide is now in session. Please be seated.
Thank you, Ms Longbottom.
Thank you, Commissioner Cardis. I have no further questions of the Admiral.
Okay. Vice Admiral, can I ask, why do you think this Royal Commission was established?
To improve and reduce to zero the rate of suicides in current serving and our veterans so that we better look after the welfare of our people, Commissioner.
You're familiar with the DART reports, 1 and 2?
The DART reports?
Yes.
Yes.
And we've just discussed the case of Mr Armfield.
Yes, Commissioner.
And are you familiar with the case of Dr Nikki Coleman?
Only in the very broad, not in any detail, Commissioner.
You're aware she gave evidence in September last year in some detail about the failings of the complaint system. Are you aware of that? Or
in the broad, Commissioner, yes.
Okay. From what you know, would you agree that it's an egregious case?
Commissioner, I apologise. I don't have sufficient detail to be able to make that judgment.
Well, frankly, it happened on your watch. It's not ancient history. It all happened. She gave evidence in September, and by then she had been actually forced to resign from the ADF. Having taken all that into account, and I hope I'm not putting words in your mouth, but I can't recall the exact words, and perhaps we can pull them up shortly from the transcript of the other day when you were here. But did you make a statement along the lines of the fact that you do not accept that there are systemic failures in the complaint system?
I expect I did not make that statement, Commissioner.
Okay, no, that's fine. I don't want to put words in your mouth, but certainly would you accept that out of the hundreds, if not thousands of people who have come forward, both to the DART team and then now to us at the Royal Commission, a sizable portion have complained about the complaint system, the disciplinary system, and the fact that they feel have been treated unfairly. You accept that's the case?
I do.
Okay, we're on the same page. With all of that in mind, I guess we turn our mind to what happens next. And what are your thoughts about how things can be improved? I mean, you would agree with me that the first step to solving a problem, and I think we've agreed there is a problem.
Yes.
Would you agree that the first step to solving that problem is acceptance that it exists, not denying it, and then dealing with it after that?
I do.
What would you see as a solution to fix these problems? And I appreciate you've handed off the responsibility now, but you had control of it for some years, and certainly your broad experience across the system would give you some thoughts.
Commissioner, I think we need to build the confidence of our people in that system. We would do that by making sure, and we have talked about it through my evidence on Monday, of improving a trauma-informed approach in the way the inquiry and complaint system is managed, of making sure that as part of that is the lived experience of people going through it. That will require clear policies, and we're improving them, clear education and training of the people who are participating, particularly as the managers within that complaint system, giving better visibility to our people of the means available to them, both those internal to defence and external, so they can choose whichever of the mechanisms best suits their circumstances. But we have work to do to improve the functioning of the system, but better work to do to make sure our people know how to access it and use that parts of it that suit them.
Thank you. There's one other aspect I'd elected to ask you at the beginning. Do you feel that the establishment of the Royal Commission was justified?
Absolutely.
Thank you. That's it from me, I think. Commissioner Brown?
Thank you. Admiral, Council was asking you about the accountabilities and you were endeavouring to respond to her questions, but in responding you said Defence is a very complex organisation. I'd like, first of all, to ask you, what do you think that means in terms of trying to effect change within Defence?
Commissioner, if I could offer you it's complex because it's large, it's dispersed, it works within Australia and overseas. As you have heard in evidence through the Commission, we have 5,000 to 6,000 people leave every year, and the same, so our turnover rate, we are constantly regenerating. That is the nature of our workforce. So complex in that context for me is the broad nature of it, the dispersed nature, the fact that the workforce is always evolving and flowing in and out of it. And we perform many functions from running health services to the delivery of combat effects. So the breadth of roles that we perform in delivering the security for our nature make it in aggregate a complex organisation.
I accept that, but if, as you have just described, you accept there's a problem in relation to suicide, you accept that what we've been discussing today in relation to the military justice system, discipline, complaints, etc., there are gaps, particularly in the trust. You need to build the confidence. As a complex organisation that needs to change, I guess my question is, do you have confidence that Defence can actually implement the changes that are required in a timely fashion?
And partly to Commissioner Kauros's question of, we absolutely believe in the Royal Commission and the work that you are doing, that we are committed to the outcomes. And yes, I do have confidence that we will, with all our best endeavours and the priority that it needs, work to the changes to continue to improve our system.
And just following, I mean, that's good to hear, thank you, but just following the line of the complexity, I guess we started out this afternoon, Council was examining you in relation to accountabilities. But then when we came to the example of Mr. Armfield, who I agree was very courageous to speak and quite compelling in his evidence, trying to understand who's accountable, what sits with the military justice system accountabilities, and what sits with ADF headquarters, and whether it's you or whether it's CDF, what sits with the services. And it just seemed to be a little circular kind of pathway that didn't particularly lead anywhere. And I appreciate what you were describing, I'm sure, is absolutely accurate. But it goes back to that issue about how clear are the accountabilities, because as I sit here now, it seems like no one is accountable for Mr. Armfield, and yet he's lost his career, he's lost his identity. I think he had something else that he said today that described his current situation. But where's the accountability? What's going to happen after today to address the issues that Mr. Armfield's case very clearly set out? Can you answer that for me?
I don't think sufficiently, Commissioner. In part, and I think I saw it in the media this morning, I'm aware the Inspector General of the ADF has reinitiated an inquiry into has an inquiry underway into Mr. Armfield's circumstances. I think in part there are, yes, many of us accountable for making this system work. That is because of that complexity organisation I described. It was very difficult to ascribe a single accountability to an individual, because to make it work effectively, all of those components that are relevant to looking after the health and welfare of our people need to work effectively, from the medical system, the welfare support, to the workplace that treats them respectfully and enables them to perform in the manner. We need each of those components. My plea, or I think as you consider your recommendations, it is important that the complexity of our system is a factor to you, and where it can be simplified, that is powerful. But in many areas, it is complex because that is the nature of the work that we perform, and we have to find a way of accommodating that.
And I do appreciate that and the challenges of the complexity, but equally, I mean, we have done over, I think, 750 odd private sessions now, and many of those, I think, certainly the ones that I have done, I think there are echoes of the same kinds of issues coming up. The lack, you know, what people have experienced and the lack of accountability, the lack of avenues, and I guess the lack of trust that you described, but the lack of any confidence that the system can change, because it seems, and I suggest this to you when you appeared, I think that what people have a sense of is what Mr. Armfield described today, is it felt like there was closing of the ranks, there was a cover-up, I think he used that word.
Yes.
And it looks like defence is defending defence and keeping the institution, you know, intact, but the individuals are the ones who suffer. That's a comment, not necessarily asking you a question. I'm sorry for going on, but it's just such a stark kind of representation of accounts that we have heard many times over. I'll leave my questions there, thank you. No, sorry, actually I won't. I just did want to ask you, when we visited Canada and we spoke with Madame Justice Arbour, who did a review into the issue of sexual misconduct in the Canadian Armed Forces. Now, hers wasn't the first review, but she came in and did a review of what actions had actually occurred after the first review. And she was very strong on the point about needing to let the sunshine in, to have external input at every possible point. I'm just keen to understand whether you think there is more scope within the military justice system in particular, but within defence more broadly, for those external eyes to assist defence to affect the changes that are required.
Commissioner, yes, we need to find to achieve that what you describe, which is all parts of our system, and I accept that. And in part, the discussion that we had at the end of Monday night was finding a way to do that works in all the circumstances in which we find it. In my time as a ship, we would spend 90 days at sea. You need a system that is available in each of the environments in which we find ourselves, whether that's a combat environment or safely at home, training in our barracks here. To make that effective, it needs to be plausible across the type of operating paradigm in which we find ourselves.
Yes, I mean, I don't think we're necessarily suggesting that you need to have it on the battlefield, but yeah, kind of in the broader system. Thank you. I'll leave it there. Thank you.
I just have a couple of very quick follow-up questions out of that. So the case of Dr. Nikki Coleman, as we said, was on your watch. September last year, she gave evidence. It was front page news. Are you aware of anyone under your watch saying we'd better have a look at this case and see what it was all about?
Commissioner, yes, and I think that was partly through some of the evidence that you may have heard when her circumstances were raised at Senate estimates, where her service chief reflected a number of those views.
Are you aware of anyone taking any action against anyone out of that case, out of what came out in the Royal Commission hearing?
I'm not aware, but that doesn't mean it's not happening, Commissioner.
It was on your watch, though. At that stage, you still had.
As the military justice officer, but not within the group of people who I was directly responsible for.
It didn't cause you to be curious when this was front page news?
Yes, Commissioner.
Okay. And up until, I think, a recent announcement by the IG, are you aware of anyone having taken action to rectify what happened to Mr. Armfield?
I'm aware that the relevant service chief, Mr. Armfield, apart from the recent IG, and I think as Mr. Armfield's evidence described, his engagement with his service and the Chief of Navy, I'm aware of that level of engagement from his evidence to you, but I don't have any specific insight into actions that have taken.
I think we'll be asking others who are now in charge that question. But one final issue. You mentioned earlier that there is a requirement on serving men and women to report to the ADF if they're convicted in a civilian court in a state or territory. Where is that requirement?
I would have to, I'm confident that it's written. I would have to take.
Grateful if you can take it on notice. Yeah. Yes. Okay. Commissioner Douglas?
No questions, thanks, but I think that your evidence was that they're required to inform their commanders if they're charged.
That's right, Commissioner.
Does that extend to conviction as well?
I think they have 24 hours when they return to duty to inform them of the charge. Of course, they have to get leave to attend, to be a part of civil court proceedings. So yes, we would normally have a ADF person there at the point where they are convicted to make sure we are aware of it.
Thank you.
Thank you. Ms. Mort?
Thank you, Commissioners. There's just one matter I would wish to clarify. Vice Admiral, you were asked on Monday to take on notice a number of matters. One of them was a request for production of minutes of the Chiefs of Services Committee, where briefings regarding issues with the assurance system for the military justice system have been raised. The documents that have been produced in response to that request are entitled Chiefs of Service Committee Outcomes. So they're not described as minutes, but in effect, is that what those documents are?
They are, Counsel, yes.
And are there other documents that exist that record briefings about issues in relation to military justice system being raised before COSC for its consideration?
They would be the papers that are submitted for cost consideration. Is that what you're referring to, Counsel?
Yes.
So there are papers, like most committee, there is a paper presented which is the body of material that the committee discusses. So the minutes or the outcomes are the reflection of the decisions taken, but that isn't the papers that are considered in session in the committee.
And are you aware whether the papers or briefings have been produced?
I'm not aware, no. I think some of them may be, but for example, the annual reports from the Military Justice Steering Group, but not necessarily all of them.
That was all, Commissioners. Thank you.
Thank you. Ms. Longbottom, any matters arising?
Just one matter out of my learned friend's questions. Admiral, there were, I think, at least 2 papers produced, but if there are any additional, can I ask you to cause them to be produced to the Royal Commission?
Could I just be clear on what you're asking, Counsel?
Of course, Admiral. So I understood Ms. Maud asked you whether or not the documents that were produced to this commission in response to the request on Monday encompassed, in effect, all the briefings that were put before COSC in relation to issues to do with military justice and its assurance system.
Yes.
The material we have received includes at least 2 such briefings, but if there is anything additional, can you please make arrangements for that to be produced to the Commission?
Yes, Counsel.
Thank you.
Thank you, Ms. Longbottom. Is the Vice Admiral to be relieved from his summons?
Yes, if you could please be relieved from his summons.
Okay. Thank you for the evidence today and the other day. We appreciate it was a long period. We hope and pray we're getting somewhere, but you're excused from your summons to appear. If there's one other issue.
One further matter in relation to the timing for the further information in relation to notice NTG DEF 213C. I'm told that Defence will use its best endeavours to get that response to our friends by tomorrow morning. If that's possible, we'll certainly try by then.
Thank you very much. Thank you. If there's no other matters, we'll adjourn till 9 o'clock tomorrow morning.
All rise. The Royal Commission into Defence and Veteran Suicide is adjourned to 9 a.m. Thursday, 7 March 2024.